Justice and Attorney General, Republic of Rwanda, the Inspector General of Rwanda National Police, the Governor, Northern Province, the Prosecutor General, National Public Prosecution Authority, the Secretary General, Rwanda Investigations Bureau, the Commissioner General, Rwanda Corrections Service, the Chief Executive Officer, Rwanda Governance Board, the Deputy Inspector General of Police in charge of administration and personnel, the Deputy SG NISS, the Reserve Force Commander, Rwanda Defense Force in charge of Northern Province, representing the RDF, representatives of academic institutions, including the University of Rwanda, the Institute of Legal Practice and Development, the African Leadership University, and other academic institutions present, invited guests from all over the continent and beyond, Rwanda National Police Commissioners, senior officers present, students of Senior Command and Staff Course in ITEC 11, students of the Institutes of Law Practice and Development, students of African Leadership University present today. Ladies and gentlemen, good morning and welcome to the 10th Symposium on Peace, Security and Justice, organized for the Police Senior Command and Staff Course in ITEC 11 under the theme, Enhancing Justice for Sustainable Peace and Security in Africa. I am Chief Superintendent of Police, Africa, Sendahangarwa Aporo, the Master of Ceremony for today. Honorable Minister and guest of honor, allow me to take you through the program for today. But shortly, let me emphasize that this symposium is deliberately organized close to the end of the course, Senior Command and Staff Course, for senior police officers and officers from other security and law enforcement institutions, in order for students to leave the college with a wide and deep understanding about the theme and topics that are discussed in this symposium. Guest of honor, Minister of Justice and Attorney General of the Republic of Rwanda. This morning, before we give you the floor to give us your opening remarks, we invite the commandant of the college to invite everybody to this college, and then he will invite you, Honorable Minister, for your opening remarks. Commandant, sir, the floor is yours.
Honorable Minister of Justice and Attorney General, our guest of honor, the Inspector General of Rwanda National Police, sir, Governor, Northern Region, the Prosecutor General of the Republic of Rwanda, the Secretary General, Rwanda Investigation Bureau, the Commissioner General, RCS, the Chief Executive Officer, Rwanda Governance Board, the Deputy Inspector General of Police in charge of administration, the Deputy Secretary General, NISS, Reserve Force Commander, Northern Province, representing the RDF, the Vice Chancellor, University of Rwanda, the Vice Chancellor, African Leadership University, Director of the Institute of Legal Practice and Development, representatives of academic institutions here present, commissioners of police, generals from RDF, distinguished guests, dear speakers, discussants to today's symposium on peace, security, and justice, Police Senior Command and Staff course participants, ladies and gentlemen, good morning and welcome to Rwanda National Police College. The guest of honor, sir, on behalf of the National Police College, and indeed on my own behalf, I wish to welcome you all to this 10th edition of the Symposium on Peace, Security, and Justice. It has been, and it has become a norm that towards the end of each intake of the Police Senior Command and Staff course, we organize a symposium on peace, security, and justice with a focus on Africa. This has allowed course participants to get out of the academic routine lectures and give them an opportunity of exchanging with professionals and other subject matter experts beyond the usual and formal academic setup. The conduct of this regular annual event has agreeably provided a platform for students to reconnect with the real world. It has allowed them to meet and interact with well-versed scholars and other highly considered personalities in matters related to their field of study, and hence expanding their analytical capacities required at their levels. It is worth mentioning that the ongoing 11th cohort of Police Senior Command and Staff course brought together senior officers from 9 African countries, which include Kenya, Ethiopia, Lesotho, Malawi, Namibia, Nigeria, Somalia, South Sudan, and Tanzania, and Rwanda, the host. The guest of honor, sir, in our last symposium of 2022, which was themed Fostering Good Governance for Peace and Security in Africa, speakers and participants to the symposium explored broadly the relationship between governance gaps, insecurity, and absence of peace with real examples from Africa. On the basis of literature and real-life cases, participants found that the quality and characteristics of governance have influenced countries' level of peace and stability and the prospects for socio-economic development. It was also clearly demonstrated that most of recurrent conflicts in Africa are closely associated with poor governance, characterized by, in a good number of cases, unequal distribution of resources, social exclusion, divisive politics, marginalization, to name but a few. Such situations have engendered insurgencies, violent extremism, terrorism, and generalized unrest in some parts of the world and in Africa. On the other hand, discussants in the symposium affirmed that strong governance systems in Africa and in the world have proved to be guarantees of safety and security of their communities. Therefore, it is a responsibility of the state to build a system that inspires confidence to its subjects and prevent any unrest. The guest of honor, sir, distinguished guests, building on those discussion, this year's symposium on peace, security, and justice is held under the theme Enhancing Justice for Sustainable Peace and Security in Africa. Peace cannot exist where justice is not served. So everybody needs justice. the poor and the rich, the weak as well as the strong. Today, the National Police College is pleased to open again this platform for debate and is looking forward to rich discussions which will benefit not only the Police Senior Command and Staff students, but also participants to this very important event. I wish to express my gratitude to Rwanda National Police leadership for the support and guidance to making this annual event happen. I thank the University of Rwanda, more especially the Center for Conflict Management, for their highly valued contribution in the organization and the conduct of this symposium. I thank also all of you who have responded to the Inspector General's invitation to this symposium. I once again welcome all the speakers, discussants, moderators, and participants to this symposium of the year 2023. And warm welcome to the partners, students from the Institute of Legal Practice and Development from Southern Province, Nyanza. We value your partnership and sincerely appreciate your consistent participation to this event. Let me welcome also the students from the African Leadership University who have come to participate to this symposium for the first time. We hope that your participation will really benefit us. The guest of honor, sir, allow me to end by welcoming you once again in this college and kindly request you to deliver today's keynote address and officially open our symposium. Thank you, sir.
Allow me to associate myself with the protocols as have been expressed by the MC so that I don't go wrong anywhere. Distinguished guests, all protocols observed, it is a privilege to be invited to officiate the opening session of this symposium on peace, security, and justice, organized by the Rwanda National Police in collaboration with the University of Rwanda. The main purpose of this symposium, as is highlighted in the concept note, is largely knowledge sharing and deepening a shared understanding of the key aspects of enhancing justice for sustainable peace and security in Africa. This symposium is a clear evidence of the increasing interaction of the concepts of justice, peace, and security. I am delighted that the leadership of the Rwanda National Police and the University of Rwanda have made this commitment of bringing together participants with diverse and immense experiences to discuss such a critical theme valuable to the sustainable development of Africa. I do believe that diagrams do express words better than speeches. So I had a diagram here maybe that I wanted us to go through. Okay. I'm sure I've presented this before, but there's a reason as to why I enjoy this particular paragraph. First of all, Kate Roth is a dear friend, but what she managed to capture with this particular diagram is quite key to what we are discussing today. So according to Kate Roth, for any society that is serious in what they are doing in terms of governance, what you are trying to achieve is a safe and just space for humanity. That should be the quest of any government. But in order to achieve this, there are two forms of elements that one should carefully look into. And the first form of elements is what she refers to as a social foundation. That's water, income, education, resilience, the voice, jobs, energy, social equity, gender equality, health, as well as food. This is what would have constituted the only elements towards a safe and just space for humanity. And by portraying this, one assumes that the definition of justice is broader than access to courts. So justice is broader than that. Justice is achievement of these social foundation elements, if you want to look at justice in this manner. Any institution which is built should be built towards achieving a safe and just space for its humanity, its citizens. We are talking about the executive, the legislature, as well as the courts. When we talk about justice, most of the times people refer to courts as one of the bigger elements towards achieving justice, and I'm sure we are going to have an opportunity to look at this. But in very recent times, from the 1970s onwards, in order to achieve the safe and just space for humanity, you also have to look at what are referred to as environmental ceilings. We have climate change. There's the challenge of fresh water use. There's the nitrogen and phosphorus cycles. There's obviously, for those countries which are not landlocked like ours, ocean acidification, but of course it has an impact to humanity, including landlocked countries such as ours. Then there's the chemical pollution, atmospheric aerosol loading, and ozone depletion, biodiversity loss, and land change. Let me just dwell for a moment on climate change. Climate change has led to very devastating challenges for countries. Any of you followed what happened to this country a few weeks ago? You do remember that we had a catastrophic event caused by flooding, mostly in the western part of the country. And this seriously affected justice, peace, and security of the country as a whole, but specifically to citizens of that place. So what was justice for these people who had been affected by climate change, which they didn't, of course, participate in causing? And one could conclude that the justice then, if you want to look at justice in a broader sense, was to first have quick response and respond to the catastrophes that was taking place, which is what the government did, the government of Rwanda. And by government, I refer to institutions such as the security institutions and all that. And that was in order to ensure that there's security, peace, and justice in the broader sense of justice for those people who are suffering this catastrophe. And then after that, after the first response, the next approach in order to achieve justice for these particular people who are suffering from this catastrophe was to ensure that they are resettled, and this is what the government of Rwanda is doing. But this presupposes that we look at justice in a broader sense rather than access to justice or access to court as it is referred to. So this is why I like this diagram, because it expresses what justice in the broader sense is. And I do hope that this is how we are going to refer to justice when we have these panels today that are going to expound on different topics. But unfortunately, this is the ideal definition of what justice is. But what is the picture today? It appears that humanity has transgressed both sides of this donut. It's actually formed as a donut, as you can see, the diagram as it is. There are shortfalls which are below the social foundations, and I'm going to give us figures on how we have had shortfalls on social foundations that have actually led to the challenges towards justice, security, and peace. Then we also do have overshoots beyond the environmental ceilings, which have also caused challenges towards security, peace, and justice. Let's first look at the shortfalls that have led to challenges in achieving peace or even enhancing peace, security, and justice. Despite unprecedented progress since independence of many African countries, we are still very far behind this, achieving the social foundation elements. When you look at the statistics, they are quite stark. Generally speaking, 1 person in 9 does not have enough to eat. So how can you explain that there's justice, security, and peace if 1 person in 9 in Africa does not have enough to eat? A quarter of the people in Africa do live on less than $2 a day. A third still has no access to toilets. 1 in 11 people has no source of drinking water. Almost 40% of people live in countries where income is distributed unequally. And more than half of the world's population live in countries which have very severe lack of political voice. When you look at the overshoot now on the other side of environmental ceiling, the environmental life-giving systems are under unprecedented stress, and we have transgressed at least 4 planetary boundaries out of 9. I won't go into details of this, I'll just express the boundaries that we have transgressed. And the 4 boundaries that we have transgressed are those of climate change, land conversion here in Africa more especially, nitrogen and phosphorus loading when it comes to the soil that is required, as well as biodiversity loss, which is extremely catastrophic. If we just single in on the issue of climate change, the concentration of carbon dioxide in the atmosphere now exceeds 350 parts per million. It is over 400 parts per million and still rising, leading to hotter, drier, and more hostile climate. This is seriously impacting on justice, security, and peace, because there's no way that you can explain that you achieve that safe and just space for humanity if the world that we live in, and especially the continent that we live in, is getting hotter, drier, and more hostile. That's catastrophic. So when you're looking at justice in the broader sense, you also have to take into consideration the challenges that we are facing today. A few years ago, not too long ago, there was compartmentalization of what justice is. When you look at even the question of human rights were categorized in what were called the 3 generations. And then the argument then by legal jurists was that there are 3 different components of human rights which were referred to as separate generations. There was the civil and political rights, economic, social, and cultural rights, and collective or solidarity rights, which were referred to as the 3rd generation rights. But nowadays, this has been put to rest because it does appear that in order to achieve justice, all these generations of rights have been compounded into one, because in one set of what was referred to as an independent generation of human rights has a direct correlation with another set of human rights. I do remember when there was this argument in the UN Charter of Human Rights on having rights to environment, which were referred to as collective rights. Most of the people in the Western world did not believe that this should be our rights in any form or sense. But it's now customary that, or it's now worldwide believed that you cannot achieve the right to environment without looking at the right to life, because the right to environment is affected by, affects the right to life. If there's an environmental catastrophe, then the right to life is affected. So there's an interlinkage of these generations of rights in the broader sense of what justice is, peace and security. And the notion of the three generations of human rights as a basis for justice had endured for 40 years until it was proven not to be true. This idea of justice, peace, and security had no solid historical or analytical basis, and it obscured rather than clarified the relationship between rights in achievement of justice, peace, and security. While the impact of justice in shaping the country's peace and security environment, as well as the nexus between the concepts of justice, peace, and security, remain part of academic and political rhetoric, I do hope that this symposium will open a fruitful opportunity of bringing together distinguished scholars, policymakers, justice practitioners, political analysts, and other high considered professionals from the justice sector to share practical experiences and challenges, as well as the way forward in relation to this very important theme. Distinguished ladies and gentlemen, now coming back to Africa, in Africa as well as everywhere else, it is now established that justice, peace, and security are interrelated concepts, regardless of their different definitions, as justice always contributes to peace and security. When you're talking about this safe and just space for humanity anywhere, in essence what you're talking about is a three-legged stool. The first leg is justice, the second leg is security, and the third leg is peace. If you take away one of the legs, then the stool is incomplete and it's not stable and can't be used for the purpose that it's supposed to. That's why these three concepts are interrelated. When you look at many of the recurrent conflicts in Africa, they are associated with social injustices, resulting into structural violence, insurgents, violent extremism or terrorism, as well as divisive politics, unequal distribution of scarce resources, marginalization, discrimination, human insecurity, just to name but a few. And this has been a challenge to achieving this safe and just space for humanity. Indisputably, there is no magical way of preventing or addressing all these social injustices, if not through enhancing justice. And this can be certainly achieved by strengthening justice institutions with a view of making Africa a peaceful continent. I am therefore hopeful that the symposium is well grounded and will lay foundation on how to foster justice in our respective countries as a prerequisite for sustainable peace and security. And I am confident that this symposium will be an opportunity for participants to learn from practical examples of countries, including Rwanda, where justice has played a remarkable impact on peace and security in the aftermath of the 1994 genocide against the Tutsi. This symposium, which is an initiative of the RNP and the University of Rwanda, has provided a forum for cooperation, collaboration, as well as constructive debate and effective interchange on the interrelationship of the concepts of justice, peace, and security as key drivers to sustainable development in Africa. It is a noble endeavor that the RNP, in collaboration with the University of Rwanda, have undertaken. And on behalf of the government of Rwanda, we do commend these efforts. We do expect that the discussions in the course of the coming 2 days will provide very important insights, and I am confident that we, individually and collectively, will come away with very valuable lessons. And it is on this note that I do declare the Symposium on Enhancing Justice for Sustainable Peace and Security in Africa officially open, and wish all of us fruitful discussions and deliberations. Thank you very much.
Thank you very much, Honorable Minister, for opening the symposium, this 10th symposium at Rwanda National Police College for this intake 11 of Senior Police, Senior Command course and Staff course for intake 11. IGP sir, all distinguished guests, we shall now have a group photo that will take not more than 10 minutes. Everybody else will remain seated other than the front row that will go out. Yeah, I'm corrected. Yes, thank you, sir. Maybe 5 minutes because time is not on our advantage. Such that when we come back, we will immediately start with the first panel. So students of the Senior Command and Staff course and the front row will go out for a group photo. Protocol will lead us to where the group photo will be taken. Thank you very much, sir. a seat. Shall we please take our seats? As introduced by the Commandant, Rwanda Defense, the Commandant of this college, and also the Honorable Minister, this symposium is organized in collaboration with the University of Rwanda. And to introduce the symposium is the Vice Chancellor, University of Rwanda, Dr. Didas Kaihura. Please take the stage and give us the introductory remarks of the symposium. Thank you very much.
Honorable Minister of Justice and our guest of honor, and I will as well associate myself with the protocol as was put before. Distinguished participants, ladies and gentlemen, a very good morning. It is my distinct and great pleasure to be standing here before you, giving an introductory note this important symposium with the theme, Enhancing Justice for Sustainable Peace and Security in Africa. Actually, when the theme was being selected, I think there was a very serious debate on what comes first of the three major concepts. I will probably not dwell much on security and peace because I'm not sure whether I will be giving the right justice to those two concepts, but in regard to justice, even though it has been greatly elaborated by the Honourable Minister in his remarks, I'll take a few comments as we introduce this symposium. According to the rule of law in Armed Conflicts Online Portal, which is popularly known as RULAC of Geneva, Academy of International Humanitarian Law and Human Rights, that classifies all situations of armed violence that amount to an armed conflict under international humanitarian law. Out of 110 armed conflicts it is currently monitoring, more than 40% are on African continent. It is in Libya, Morocco, Western Sahara, Egypt, Burkina Faso, Cameroon, the Central African Republic, the Democratic Republic of the Congo, Ethiopia, Mali, Mozambique, Nigeria, Senegal, Somalia, South Sudan, Sudan, and I could go on, and I'm not sure whether this list would be exhaustive enough. And some of the above enumerated countries have several conflicts in addition to other forms of violence. Whereas most conflicts in Africa are intrastate, more also are increasingly becoming regionalized, involving states and non-state actors across borders. The increase of extremist ideologies such as the proliferation of genocide ideology in the Great Lakes region, increased terrorist activities in West African countries, in the Horn of Africa and the Sahel region, and several criminal networks that are involved in trafficking humans, drugs, weapons, and resources are all real challenges that need to be confronted if at all we have to, in Africa and the world at large, have to achieve the sustainable peace and security. Certainly, this situation makes the theme of our symposium very timely and important. However, justice, which is the theme, seems to presume to be the ingredient of sustainable peace and security, and it is greatly lacking. It was clearly put by the Honourable Minister that justice is no longer just the small thing that we had all along been thinking of accessing courts or getting justice from courts. but rather that broad to include all other things, including climate change, food security, and others. But again, keeping ourselves within the ordinary context of justice, the former context of justice, according to 2022 report for the World Justice Project, Africa is doing well either on the rule of law index, is not doing well either in the rule of law index. Out of 140 countries and jurisdictions that were evaluated around the world, African countries that came among the first 50 are only 3, and these are Rwanda at number 42, Mauritius at number 45, and Namibia at number 46. Similar studies also give the same picture. According to the 2021 report of the Secretary General of the United Nations on promotion of durable peace and sustainable development in Africa, conflicts in Africa are related to, among other things, as was put clearly by the Honourable Minister, non-inclusive governance systems. And I'm glad that the CEO is amongst us here, the CEO of governance in Rwanda. Those governance systems that exclude some sections of their populations. We also note the weak institutions that are not capable of delivering basic social services such as housing, and one would wonder how housing would be related to security, peace, or justice. Education, relating it to all the 3 concepts. Healthcare, water and sanitation, being unable to provide economic and employment opportunities, and justice. The ordinary justice is unable to deal with corruption and unfair distribution of these limited resources. This is true when there is lack of enough regional and global blueprints prescribing what needs to be done to achieve sustainable peace and security in Africa. If we can take just 2 documents, the United Nations Sustainable Development Goals and the African Union Agenda 2063, we can see that justice is central and is indeed supposed to be at the heart of achieving this sustainable peace and security. From the SDGs, Goal 16 of the SDG is on peace, justice, and strong institutions. However, this SDGs report of 2022 shows that about 40% of the African population does not feel safe walking alone at night in the areas in which they live. Walking alone. And this time it's not about you being a man or a woman, it's people are not just safe walking alone at night. The same report places ending armed conflicts, strengthening institutions, and enacting inclusive and equitable legislation that protects the human rights of all persons to be necessary preconditions for sustainable development. The African Union Agenda 2063 aspires that the Africa we want is a continent whose population would enjoy access to independent courts and the judiciary that dispense and deliver justice without fear or favor. A continent where by 2063 justice would be affordable and timely accessible to all, and where corruption and impunity will be a thing of the past. I will therefore take this opportunity to invite you, especially students, to use this symposium to broaden your understanding of these issues, these major concepts, so that when you leave this great college, you would indeed be able to strategically assess the different challenges related to your respective fields and be able to suggest some workable solutions. I agree with the broad definition of justice as cited in the concept note for this symposium, and not the fact that the interpretation of what constitutes deserving, because the concept, it is stated that the principle that people, trying to define justice as a principle that people should receive what they deserve. The same concept also notes that the fact that the interpretation of what constitutes deserving is sometimes problematic. However, I have no doubt that the panelists and moderators assembled for us here to discuss the 4 sub-themes in these 2 days are well placed with their knowledge and expertise to help us understand and draw some lessons and recommendations that can be useful for that change of the way things are being done in Africa today. Justice, peace, and security are indeed complex concepts that are intricately related and intertwined, as was put earlier, but I strongly believe that the knowledge you students gained during your course of study, including in this Masters of Arts in Peace Studies and Conflict Transformation at the University of Rwanda Center for Conflict Management, plus each individual student's past experiences, will all allow you to meaningfully participate and enrich these discussions we are going to be having for these 2 days. We are always proud of our partnership with the National Police College and the National Police at large. That has been on for quite some time now. As I come close to my conclusion, I want to submit that given the fact that Africa has been divided between states and within states for so long, a justice system that will contribute to sustainable peace and security in Africa is that kind of justice that is capable of producing cohesive and inclusive societies. Justice that is capable of administering equal distribution of resources, ensuring that state institutions and state officials are accountable to their citizens, where there is no corruption and discrimination. Therefore, it is understandable that this kind of justice is more than that usual classical justice system, as was clearly put by our guest of honor. It is not that merely of punishing offenders and correcting civil wrongs. It should be capable of tackling the deep-rooted multiple causes of instability in Africa. And what is that is impossible to uproot? For Africa and Africans to live peacefully. Justice is supposed to be the universal in nature because it applies to them, to the humans, to the human beings in the first place. And these human beings are ordinarily supposed to be equal, united by their human nature. Of course, as had been it was put far back in 1945 by George Orwell's, it is always taken to be that all men are equal, but of course there will be those that are more equal than others, and I don't know how this came about. Tous les hommes sont égaux, mais il y en a ceux qui sont plus égaux que les autres. But still, we have to have justice. Before I conclude my introductory note, I want to share with you a lesson that I learned just a few days ago, and I'm sure that you may have received the same through your social media, about a student that was unjustifiably chased out of a class, and none of his fellow classmates was concerned about the unfairness. They simply kept in a class. Nobody complained. They waited for the professor to carry on. And what was interesting in that story is that the professor wanted to now bring the true meaning of justice and law. Are we always concerned about what happens to our colleagues, our neighbors, our workmates, how they are unfairly treated, or we simply let it go because it is not about us and on us? We are not the ones in such a situation. When we see what is happening with our neighbors, and our neighbors can be broadened, not being the next house, but the next country, how are we concerned? How do we react? What is our role? So on that I want to thank you so much for your kind attention, and I wish you a great and honest deliberations throughout. Thank you so much.
Thank you very much, Vice Chancellor, University of Rwanda, for your introductory remarks and complimenting what was said by Honorable Minister to set a keynote for the discussions that will be made during this two-day symposium. It's now time for our first panel discussion on a topic titled Justice in Africa, Past and Current Status. I will introduce the panelists to you before I hand over to the moderator this morning. I will start with Dr. Alphonse Mulefu, the Acting Principal, College of Arts and Social Sciences, University of Rwanda. Dr. Mulefu, please welcome to the stage and take the seat on my right. Dr. Alphonse Mulefu is a senior lecturer and acting principal of the College of Arts and Social Sciences of the University of Rwanda from February 2019. He holds a PhD in law from Tilburg University, the Netherlands, a master's degree in international and European public law from the same university, and the bachelor's degree from the University of Rwanda, formerly called the National University of Rwanda. The next panelist is Dr. Businje Kabumba, senior lecturer from Makerere University. Dr. Kabumba, you're welcome to the stage. Dr. Businje Kabumba is a senior lecturer and director of the Human Rights and Peace Center at the School of Law, Makerere University, Uganda, who has taught public law for over 13 years. He has been recognized by the Supreme Court of Uganda as being widely researched and highly experienced with regard to constitutionalism, human rights, and good governance. He has litigated groundbreaking cases before the Constitutional Court of Uganda and has published work. His work has been cited by the High Court in a number of cases. His main current research inquiry is the relationship between power and vulnerability. Welcome, Dr. Kabumba. Our next panelist is Mr. Aimable Havugiyaremye, who is the Prosecutor General of the Republic of Rwanda. Prosecutor General, you're welcome, sir. Aimable Havugiyaremye, Prosecutor General of the Republic of Rwanda, has been in this position since November 2019. He has held other different positions in public service, such as Chairperson of Rwanda Law Reform Commission, Director of the Institute of Legal Practice and Development, Commissioner in charge of advising the Parliament reviewing the Constitution of Rwanda in 2015, Vice Chairperson of Rwanda Law Reform Commission, Principal State Attorney in the Ministry of Justice of the Republic of Rwanda, and many others. Welcome, Prosecutor General, sir. Finally, I will call upon the moderator this morning, Dr. Charity Wibabara. Dr. Charity Wibabara has a PhD that she acquired in 2014 from University of Western Cape in South Africa in collaboration with Humboldt University in Berlin, Germany. She is a national public prosecutor with the National Public Prosecution Authority of Rwanda, and previously she was a full-time lecturer at the University of Rwanda, Faculty of Law. Dr. Charity Wibabara, the panel is yours. Thank you very much. Shall we welcome our panelists with a round of applause, please?
Thank you very much, distinguished guests, ladies and gentlemen, good morning. As already introduced by the MC, my name is Charity Wibabara, and I will be the moderator for this selected panel of men of wisdom, experience, and influence in their different areas of services, which are complementary in nature. I'm certain and sure that this is going to be an interesting panel, which is going to explore the giant challenge that Africa is facing at the moment of increasing injustice in the region, which, as a matter of fact, is a growing security threat for the continent and affects the peace as well as the well-being of the whole world. Dear participants present here, join me in welcoming once again this panel that is going to share with us from their laboratory of knowledge the challenges strategies and solutions of what Africa needs and the international community as a whole to ignite justice in Africa for long-lasting peace and security. On this panel, we are blessed to have the Prosecutor General of Rwanda, Mr. Aimable Havugiyaremye. I hope there is no subsequent charge for not presenting him as my immediate boss. Welcome, sir. Yeah. It is also a privilege for us to have Dr. Businje Kabumba, all the way from Makerere University in Uganda. You're welcome. And as you can see, we have our seasoned expert, Dr. Murefu, who is also at the panel, and he's a lecturer at the University of Rwanda, but as you heard from the presentation, he's the acting principal of the College of Arts and Social Sciences. Welcome, Dr. Murefu. Yeah, so that said, let us commence with our first speaker, and that is going to be Dr. Murefu. He's going to explore the dynamic nature of justice in Africa, describing its evolution and nexus to peace and security. He's also going to explore in great detail the concept of justice from both legal and social science perspective. Doctor, you have 15 minutes to make your presentation, and the floor is yours. Feel free to stay seated or to join this. Thank you.
Thank you very much, moderator. I think I will use less than 10 minutes, and probably we will discuss more, also to allow students to have time to contribute. The question of whether there is a nexus between evolution of justice and peace and security, taking the broader meanings of the three concepts. In this case, justice as the principle that people ought to receive what they deserve. Peace as a situation where the human relationships does not involve physical violence in settling disputes or disagreements. And security as a state of being free from danger or threat of it. I would argue that indeed there is a strong connection between the evolution of justice and the existence of peace and security. This is true mainly in two ways that I would like to expand on. The first one is in the prevention of conflicts or disputes from occurring. And the second one is to contribute in peaceful resolution of conflicts or disputes or disagreements. We all agree that rational human beings are capable of anticipating consequences of their actions. They have the ability to know what is best for them and be able to choose between what is right and wrong, and are capable of a sense of justice, as thoughts and feelings about what is fair and unfair, and what people deserve from and all others. I would like to recommend the organizers for having thought about the evolution of justice to be part of this discussion and talk about justice broadly, because even if we all know what justice is or have a shared feeling of what is for fair or not fair, we rarely bother to ask the origin of this sense of justice in human beings, what it is for, and how it is designed, what activates it, and why it sometimes fails to give rise to fair judgment and good behaviors. Humans are capable of thinking in abstracts. Thus, they can predict consequences. Human beings are capable of detecting a wrong against them and that against others, and would understand that those who wrong others should be punished. In some circumstances, humans might acknowledge that the wrongdoers should be punished, but not agree on the level of punishment to be imposed, or simply not want to participate in the punishment. I remember, as someone who was working in the Gacaca courts in Rwanda, the traditional justice mechanism that was used to deal with the crime that were committed during the 1994 genocide against the Tutsi, we had some incidences, though not many, of where during the phase of correction of information, people denounced some individuals of their communities, giving information about the crimes they allegedly committed during the genocide against the Tutsi, but decided not to go forward during the trial to accuse them. I am sure my Rwandan colleagues know the term that was used as checheka. I will avoid discussions of whether human beings learn through social interactions or innately gain the sense of justice. As I have already said, it is uncontroversial that human beings are capable of knowing what is the right thing to do. The wisdom that human beings possess, their intellectual and linguistic abilities, though not always used, allows them in all societies to provide and engage in complex forms of justice across communities. The one most shared sense of justice among human beings is that of equality. The Honorable Minister alluded to that when he was talking about the fair distribution of resources. The one most shared sense of justice among human beings is, as I said, that of equality. This is where I want to start by arguing that justice contributes to peace and security through prevention of conflicts. People survive in cooperation, and this cannot be possible without certain agreed ways of how members of our communities knowing how to conduct themselves. We all know that we are never successful working alone. We need each other for mutual assistance and survival. People have different talents and skills, so we need to work together for division of labor, and most importantly, we need coordination and rules to be sure that we will realize the benefit of our association. This is best assured through a form of justice that all members of society must accept. The reason we humans have to a large extent succeeded is, as also believed, the fact that humans are capable of thinking of abstract scenarios and predict their conduct and the related consequences. As Krebs notes, a sense of justice induces members of group to distribute resources in fair ways, to honor the commitments they make to others, to punish cheaters, and to set different ways of resolving disputes. It is fair to argue that most conflicts in societies, at least in internal conflicts, which are the majority today, results from social injustices and patterns of structural violence such as discrimination and exclusion. Therefore, if distributive form of justice, where resources are fairly distributed among members of the society, can be observed, it is without a doubt capable of helping in the prevention of those kinds of conflicts. I don't want to be misunderstood. I'm not arguing that justice should result in people having the same things all the time. No. Even if an attempt was made to give the same things to all of us here today in this room, as a start, we would still end up having the same, end up having the same things in the near future, because people have different skills and knowledge, and God, nature, luck, or blessings, depending on what you believe, distributes fortunes and misfortunes differently, and at the end, we would not be having equal resources. I'm simply referring to that kind of justice where a society is arranged in a manner that accords equal opportunities and treatment to all its members and reaches back to assist their unlucky members, those in need. Then we can talk of a just society. Distributive justice is therefore critically important in contributing to peace and security. We can take some examples of transitional justice, even if the work of the South Africa's Truth and Reconciliation Commission is often cited as a success, the fact that many black people still live in segregated townships and are in poor conditions, sometimes similar to those they lived in during the apartheid period, they might still be feeling a sense of injustice, despite their current political civil rights that were gained since 1994. However, it is possible that we will not be able to live up to those standards of fair distribution of resources, and sometimes we will wrong others. As Krebs notes, there is a great deal of evidence that people are inclined to behave only as fairly as they need to maximize their benefits from social exchanges. That is why people are inclined to react more strongly to being treated unfairly by others than to treating others fairly, to hold others to higher standards of fairness than they hold themselves, and to reckon costs and benefits for themselves and others in different ways. Therefore, the moment we have a dispute or when we inflict a wrong on others, we need another kind of justice, the peaceful way of resolving a dispute. Justice is one of the ways disputes that happen during the interactions of people are resolved. The process of rectifying the wrongs that happen between people during the daily human interactions helps in producing fairness used to produce peace after a dispute or a wrong. When disputes are not settled, if, for example, criminal justice is not working, when criminals are not punished, or system that assures people that the agreements they engage in are going to be respected, that failure to do so, and if there is no process to hold those who go against their responsibilities accountable, it would be dangerous for the survival of human societies. Individual victims or societies will start adopting private justice measures, such as lynching thieves and other forms to protect themselves. If there is no guarantee that a contract or agreement I have signed with someone is going to be respected, and that his or her failure will result in a justice system compelling him or her to do so, several conflicts would arise out of social interactions. Therefore, an effective, credible, and fair justice system is critically important to the good governance and rule of law, and consequently to promoting peace and security. It is true that members of societies may disagree on the kinds of punishment that is supposed to be imposed in particular group, and may fail to agree on the meaning of justice and what it constitutes. This is true because, as Trivers notes, victims of injustice feel the pain more strongly than do disinterested bystanders, and far more than do the perpetrators. I do not want to imagine how Rwanda would have been had we not conducted justice after the 1994 genocide against the Tutsi. Even if justice cannot mean the same thing in all situations and societies, what is critically important is that the understanding of justice in that particular community has to be guided with the understanding of principles of fairness. Justice mechanisms existed and exist in all societies. In Rwanda, for example, long before the colonization, as it was the case in other societies that were colonized, and it was where justice was well structured from the topmost level, which was the king's court and the highest appellant court of the land, to the lowest level and families. Chiefs or abattoirs, courts, and heads of families, abakuru b'imiryango, administered justice through customary rules and often applied precedents well known especially from the king's court decisions. If you see the way Rwanda's traditional gacaca courts and the courts of peace or justices of peace in Peru, they are similar in nature. Both are meant to deal with cases on community level, where judges are members of communities selected because of their outstanding character to rely on their wisdom of culture and knowledge to render justice. In the case of post-conflict societies, justice is a negotiated good. All parties in conflict need to be taken into consideration, and the compromise is often a certain part of justice. The challenge, however, that is facing post-conflict societies in Africa is that there is often external interferences from those who are neither part of the society that is going to live or coexist in that kind of peace, nor be part of preventing the consequences of that justice. The justice that is provided in the end is often not aligned with the context of that society, because external actors are more often normatively driven than context interested. The fact that we have been made to believe that everything we do, we have to explain it in terms of Western knowledge, we have not done much in developing our own national or traditional knowledge and ways of doing things. Where we have attempted, we have also been struggling to convince the international audience to see it in their own prism. We can also talk of justice, of the mechanisms that are made to administer justice. And that is important, whether it is traditional, national, or international justice. The justice system that fails to distribute justice fairly risks losing its legitimacy. This is exactly what, for example, has been happening between the International Criminal Court and the African countries. The failure of the International Criminal Court, whether by choice or design, to distribute international criminal justice across the globe equally, has resulted in people perceiving it as an institution of injustice, if those it prosecutes would still, even if those it prosecutes would still be prosecutable under normal circumstances. It is the failure to distribute justice fairly among all peoples and societies of the world that is seen as an injustice, than whether those it has prosecuted were indeed supposed to be prosecuted. Therefore, in conclusion, one important aspect to agree on is that the development of justice is in its connection to making communities or social relationships succeed. This can be seen in the way justice contributes to resolving disputes peacefully, but also to the way it helps in preventing conflicts and how the society administers its justice mechanisms. So justice certainly contributes to peace and security. We can therefore talk of justice of the society, justice of laws, and the justice of how justice is distributed. This involves the work of police and law enforcing agents as well. Transitional justice in particular that leads to peaceful coexistence should empower both victims and reintegrate perpetrators and restores trust among members of community to work and thrive together as a society. So I will stop here for a moment. Thank you.
Thank you very much, Dr. Murefu. That was enriching and highly informative for the audience. Thanks again for sharing that long embedded research in just a handful of minutes, but particularly for being practical of how, as human beings, we need each other for survival, but also we need accountability. Now it's time to invite Dr. Kabumba, who will discuss the administration of justice by critically reviewing the current and past justice practices in Africa with a view of drawing different lessons. You're welcome, sir.
Good morning, everyone. I will stand again, as before in the protocol already observed, and I'll request your permission to stand here, partly because it's very cold and it helps to stand a bit, but also maybe it's because of the bad training or bad custom as a teacher. We're now sort of used to these particular things. So it helps a bit. You'll just indulge me if you might. Today's morning discussion, I think, is very interesting. and has already come up from the guest of honor, from the Vice Chancellor, and already from my colleague, the concept of justice itself is a broad one. I suspect that justice is like love. We all know it. We all feel it. But if you are to be asked what is love, you might have difficulty describing it. Many have tried. Shakespeare in his sonnet 116, "Let me not the marriage of two minds," attempts to describe love as being that thing that is an ever fixed mark, that doesn't change easily. But it's a description, it's a definition by description. It's not quite comprehensive. Justice, similarly, I suspect, is one of those things where we can't describe it before, but afterwards. I'm reminded of the dictum of a certain US judge, Justice Brandeis, who said, my apologies, he was trying to describe pornography. And he said, "I know it when I see it." How do you describe it before? Not quite, but when you see it, you know it. I suspect that justice is like this thing. So we've been asked to look at administration of justice in Africa, and the topic is a critical review of current and past practices. But of course, as we know, Africa is not a place. It's a complex area, and each of the constituent parts are themselves complex, and each of the countries themselves, within themselves, are really, really complex. So I suspect perhaps the most honest way of doing justice to this is by using a case study, and I'll refer in very many ways to the Ugandan case, but also extrapolate this where necessary to other cases. And I'll be quite mindful of time. So I suspect that the crisis that we face of justice is linked to the crisis of the state itself, that was not born in love, that our states were born through violence, through extraction of another. Lines drawn arbitrarily. On the way here to Musanze, I could see hills that remind me of the place I come from. But I hold a passport which is Ugandan, and many of the colleagues here hold Rwandan passports, but there's a certain line, a very random line that was drawn at a particular random point, that then suddenly says, these people that normally cross the border are different people with different passports and different. So the birth of these states was not organic, not authentic, but it came with crisis. As the state was being imposed through force and violence, so too were a range of instruments of that state, in terms of education, in terms of dress, in terms of culture, in terms of language, but also in terms of law. So the violent establishment of the colonial state involved a disrupture, that from that moment onwards, to be a part of that state, you needed to abandon a part of yourself. To get an education from that state, from that point onwards, you had to go to school. So anyone who had not gone to school was suddenly not educated. Although, of course, this is a very strange thing to say. And the point has been made about people in the community that have knowledge. Similarly, therefore, suddenly, while education was a part of the community, from that moment onwards, for you to have any relevance to the community or any inclusion in that state, you had to go somewhere. You had to go to school. At that same moment was the imposition of an alien system of law. In the Anglophone world, it was the common law system, and suddenly, the question of precedent. So suddenly, the normal experiment I do with my colleagues at the School of Law is to ask how many people will know, for instance, and I'll just choose a random article, how many people know what is in Article 95 of the Constitution? And there will be silence. Even at times, including within societies of lawyers. But if I ask, how many of you know in your societies how power changes, for instance, in the traditional society? The laws about inheritance and succession. The answer would come in a minute, without hesitation, without thought. It will come naturally. But those descriptions are descriptions of law. So there's a set of law that is known, appreciated by everyone. But in the colonial moment, there was a set of law that was brought that was alien. And in this alien nature, to learn it, you had to go away. And in going away, there was both geographical distance, but also cultural distance. The farther away you went to learn the law, the farther away you went away from your community, from the things you had known. With the effect that when you came back, you were a stranger to yourself, a stranger to your people, of little use to yourself and to your people. And so I suspect that that is the very root of the crisis that we face today. It's a crisis of identity, it's a crisis of being, it's a crisis of constitution. So assuming that we're talking about, say, Kenya, for instance, what does it mean? So if you're talking about the justice of the land of Kenya, a fundamental question at the very beginning is, what does it mean to be Kenyan? Because that is a flag, there's an anthem. But there are people within Kenya, there are societies within Kenya who identify very strongly, in the very first sense, not with that abstract entity, but with other notions of belonging and identity. In Uganda, our country is named after Buganda, an entity that traces its history 500 years, up to 500 years before, while Uganda's history as an independent state is just 1962, and as a colonial state, 100 years. So the challenge of definition starts from the historical challenge of formation. Now, incidentally, while in the colonial state, people had to go away to study, strangely, for many colonial African states, one of those things you could not study was law. As strange as it sounds. So in 1902, for instance, in the Ugandan case, the order in council was established. So from that moment, you had law applying to you, from 1902. And the law that was applying to you were statutes of general application and English common law. So suddenly, a gentleman in Karamoja, when he goes to court over a dispute with his colleague in the village, would have to go before a court, and the judge is telling him about Thabomeli versus Rex, about Wilmington versus DPP. But the dispute was between Okello and Ongom. But the dispute between Okello and Ongom is being solved by reference to Wilmington versus DPP. And the person before whom they were appearing, because the African was denied legal education, in Uganda's case, in Kenya's case, in Tanzania's case, law schools were only established after independence. And that was by no accident. So because Africans were being denied access, deliberately being denied access to legal education, what Ongom faces before the court is not just an alien law, but an English judge, an alien judge putting on a wig, a horsehair wig, putting on scary robes. But even the lawyers through whom Ongom must engage with that state are English lawyers. So you have this strange scenario of being in a random part of Africa where an English judge is instituting English law through the mediation of English lawyers in respect of African litigants. I suspect, moderator and colleagues, that this is the root of the problem. That from that moment, you had the ironical situation, and throughout the colonial moment, of English judges, of French judges, or Belgian judges, as the case was, alien judges, alien lawyers, alien law, and African litigants. So the disjuncture starts from there. Imagine going before a court, the language is alien, but even the principles. And what makes it worse, there's even an application of Latin. So the English is already difficult enough, but then you're being told nemo dat, quod non habet, res ipsa locita. So the idea of justice, that's not a place you want to go to. It becomes a scary place. And actually, up to now, many Africans fear courts. They fear them. At times, they don't go to courts not because they don't have genuine concerns, but because the court is a scary place. And of course, inevitably then, with that situation, the justice in quotation marks that was administered was strange justice. I'll just cite two examples, for instance. The infamous case of Rex versus Amkeo, where the English judge decided that this gentleman and his wife, who thought they were married and had believed they were married, suddenly declared them not to be married, based on the idea that the marriage was potentially polygamous. So imagine, suddenly you come to court thinking you're man and wife, and you're told by the English judge, based on a very old case, he says, marriage as we in England know it, and he was quoting the case of Hyde versus Hyde. Lord Peasants, 100 years ago, marriage as we in England know it is the union of one man to one wife to the exclusion of all others. You can imagine the irony, the violence of that statement, that by reference to one old English case by an old English judge, suddenly these Africans who have been living their lives, who even have children, suddenly they are declared not to be man and wife. The other case is Gwao bin Kilimo versus Kisunda bin Ifuti from Tanzania, where the question was whether a man should be responsible for the deaths of his adult son. And again, the judge said that custom was repugnant to natural justice. But was it repugnant to natural justice? Is it really repugnant to hold a parent liable for the deaths of his child? Maybe if you take it from view of the idea of the free market in the Western sense of individualism. But if you think about the community where the primary responsibility for the education and upbringing of children is based on the parents, having that burden based on the parent ensures that the parent brings up this child in a way that they'll respect the rights of others, the responsibility of others. So when one looks at it from the society perspective, it no longer becomes something strange to think about. So therefore, colleagues, I think the challenge that we face now was rooted in that moment. There's a poem here by Okot Bitek, Song of Lawino, but I don't know if the quotes are a bit dangerous, but my apologies, moderator, but it says, my husband, his head is lost. Ochol has lost his head in the forest of books. He has become a fool. My husband was still a black man, the son of the bull, the son of a geek, the woman from Okol. He was an Acholi. But he has read so much. He has read extensively and deeply. He is clever like white men. And the reading has killed my man in the ways of his people. And this is the worst part. He says, all our young men were finished in the forest. Their manhood was finished in the classrooms. Their testicles were smashed with large books. Apologies. So, the education in the colonial state involved a social death. To be educated meant to die in the ways of your community, to die in the knowledge of your community. It meant estrangement. So you become useless to your community by becoming useful to the colonial state. I will not go into the details of that particular moment, but the fact of the matter is the statistics show that through this deliberate negation of legal education for Africans, you had an entire period from the enactment of colonialism to independence where you had African litigants, African disputes, but foreign lawyers. And the few who managed to go to law school were those who were the sons of kings or the sons of chiefs or daughters of chiefs. Actually, the first African lawyer, female lawyer, was Princess Elizabeth Bagaya, at least the Ugandan one, who managed to go to Cambridge, but she was the daughter of a king. So those who managed to get some education, some legal education, did so against all odds and in part because of privilege. So what is the situation today, post-independence or today? I suggest, and again in the knowledge of time, that disjuncture has continued. There were promises made at independence about going back, sort of reclaiming what was lost. But that, of course, was always going to be a major venture. And I'm not too sure that progress has succeeded. Maybe I'll address it in the comments. In Uganda's case, you have two articles that seek to redress this imbalance. You have Article 126, Clause 1, that says judicial power is derived from the people and that it must be exercised in accordance with the norms, values, and aspirations of the people. And then you have Article 127 that talks about involving people in the administration of justice. But this remains on paper. Practically, the law still being applied is alien law. The legal education, unfortunately, is still the cases we teach, the doctrines we teach from first year to fourth year are alien doctrines. So the task of reform of legal education, that is an urgent one, has not one that is not, and we as legal educationists are really to blame. And the students here from ILPD, I'm sure, it gets even worse when you go to the law schools. The motto at the Law Development Center in Uganda is know the law. And know the law, remove emotion, remove custom, remove ideas of whatever. Just know section this, rule this, order one, this the document. So it's the idea of social death continues. And so, of course, it leaves us in a scenario where even if you win the case, what has that justice been? It leaves us in a scenario where you might have legal justice, but that legal justice might not necessarily be, and in fact, in very many cases, is different from what may be called social justice or popular justice. In closing, I'll just give one example from a gentleman from Uganda who studied in Dar es Salaam a very long time ago. A gentleman called His Excellency Yoweri Kaguta Museveni. And he said, he wrote in his book, Sowing the Mustard Seed, but when they were in the bush, 1980 to 1985, they were, of course, disputes arose in the bush. And when, in one particular case, the dispute was that one of the rebels, actually, two of the rebels had shot and killed a peasant in the place called Uero. So there was a trial. Incidentally, some of those who went to fight were lawyers. One was a law lecturer, Amanya Mushega. Some were students of law who went there. So already the court was constituted by some lawyers who were... So there was a trial, and the Chief Justice was Yoweri Kaguta Museveni. And he says that there were arguments, both sides. So he says the lawyers who had come to the bush with their legal knowledge or had already, were arguing things from saying the defenses, the defense of provocation, diminished capacity, intoxication. They said the lawyers were saying, because apparently the rebels had been drunk when they shot the gentleman, that it's not the rebel who killed, but it's the alcohol within the person. It is the alcohol within him that killed. And he said, we rejected these arguments. Of course, they're familiar, to lawyers, they are familiar arguments. Intoxication, and there are cases you can cite. But he said, we rejected these arguments because if we had held that these rebels who had killed a person in broad daylight were innocent, the peasants, the villagers who were watching would never have understood that. Of course, it was also further complicated by the fact that this was the arena was being fought in the Luero area in Buganda Kingdom, and the person who had been killed was in Uganda, and the person who had shot the rebels were from Western Uganda, so there was that other complication. But I think it brings into focus that particular question as the distinction between legal justice and social justice or popular justice. And moderator, I think this is the continuing challenge that we have in many parts of Africa. I thank you.
Thank you very much, Dr. Kabumba, for that interesting discussion on the concept of justice and administration of justice in Africa, particularly for that comparative approach of Western justice and the justice that we need in Africa, where you've clearly showed us that at times it's not practical to the needs or to the justice needs in Africa. So at this moment, allow me invite the Prosecutor General with all humility and respect. And he's going to take us through the justice reforms that Dr. Kabumba was suggesting and taking the practical example of Rwanda. Welcome, sir.
Thank you, Charity. Honorable Minister, ladies and gentlemen, all protocol observed, allow me to thank RINP for organizing this symposium, and allow me to thank the organizers who have chosen this topic that I'm going to discuss, a topic that reflects a journey we traveled all together as Rwandans from chaos to where we are now, trying to build a justice system, but it wasn't easy in order to have a peaceful nation. Justice and peace being two sides of the same coin. From 1959 to 1994, when genocide against Tutsi was stopped, our nation was characterized by injustice, impunity, and worse was that injustice and impunity was done by the leadership. So the starting point of our journey was to change things, and that required dedicated individuals who sacrificed themselves, who suffered during the struggle, who worked tirelessly, people who have passionate concern to change things. And those people are called Inhotanyi, and they managed to stop the genocide against Tutsi. Stopping the genocide was not the end of the struggle, but it opened actually another chapter of the struggle to build a nation that was completely destroyed. And among the things that we had to build as Rwandans was to reform justice. And in reforming justice, the starting point after the genocide, we had challenges. You can imagine, you have just experienced a genocide with more than 1 million people killed. All streets, valleys, all houses, every corner of the country is full of dead bodies and dogs, vultures, and other birds of prey feasting on the bodies of our people. We just had a completely destroyed nation without hope for the future. At the same time, we had more than 2.5 million of people scattered in neighboring countries as refugees, particularly in Eastern DRC. You meet people, you realize that trauma, fear, and broken hearts are symbols of our nation. And you want to change things to build a nation and you have no money because the central bank and the other banks were empty. We had no money to run the affairs of the state. Those who are here can remember that in the period between 1994 and 1995, public servants were working on voluntary basis without salaries, only paid food items like beans, yellow maize, flour, some cooking oil, etc. And most of those food items were coming from development partners. And you want to build a strong justice, you start with the arrest of the people who committed a genocide. And there were massive arrests for nearly 200,000 people detained across the country and all waiting trials in court. But how are you going to try those people when you don't have enough investigators, prosecutors, and judges? With those challenges, you do have massive cry for justice across the country, particularly to survivors. They will tell you, look at how I am. I need justice. The detainees, they will tell you, it's not all of us who committed a genocide. We need justice. And our international development partners, those who are trying to help with the item foods, they will tell you, hey, we are helping you. But remember that justice delayed is justice denied. So we had so many other challenges like building peace and security, establishing a functional government, restoring law and order, restoring social fabric of the nation, and restoring hope for life and for the future. So the country needed innovative, urgent, and decisive actions to make it move forward. But how to do it? The first principle was we no longer accept things we cannot change, but we have to change things we cannot accept. And the second principle, actually we had two options because we were suffering and we had bitterness. The first option was to react with bitterness. The second option was to seek to transform the suffering into a creative force. And as Rwandans, we choose the latter. So we had principles. The first being no revenge of any kind by anybody. And that was not easy. Those who were in force, they could remember. You were there. You were another PM soldier. You have just found that the whole family has been killed, your parents, your relatives, and they tell you no revenge, and you have an SMG. And you know where those people who killed your family are. So you have all the means to do revenge, but they tell you no revenge. We thank the RPA because we had a disciplined army. Otherwise, we couldn't manage it. Another principle, you have to eradicate the culture of impunity and to build a rule of law as a foundation of a new government. But now the question is, how are you going to eradicate impunity and build a rule of law after experiencing a genocide and you don't have enough judges, prosecutors, and investigators? I do remember in November 1994, in the whole country, we had 244 judges. the whole country had only 12 qualified prosecutors and 137 support staff, including investigators. These are the numbers that are going to deal with the almost 200,000 people detained. So it wasn't possible. So what we had to do, we had to do massive trainings. I'm just sharing the experience we went through. Judges, those who have just finished secondary school, they were trained for 6 months, and they go and they start practice as judges. Prosecutors, they were trained for 4 months. They go and they practice as prosecutors. Judicial police officers, training of 3 months. You become a judicial police officer. And after those massive trainings in 1996, we had 841 judges, 210 prosecutors, and 910 support staff, including investigators. There were other political legal actions. After training those digital police officers, the country created what we called mobile teams. Those were screening teams. Those who served in gendarmerie, they can remember what we used to call the brigade mobile brigade, to do screening. And we created special chambers at first instance and appeal level, and special prosecutors to deal with genocide cases. At the same time, because all prisons were full, there were massive releases from detention, mostly on compassionate grounds for the very elderly, the sick, children, and other most vulnerable persons. There were also regular conditional release. So with those actions, with those screening, with these actions, releases based on compassionate ground, it resulted in about 50,000 people who were released. But again, this still left about 150,000 detainees awaiting for trial, with those prosecutor, judges, and investigators. So there was a special law punishing genocide, and with those judges, those special chambers that were created managed to handle only 200 cases between 1996 and 2001. So the country realized that at that rate, trials were going to take hundreds of years, which means that all victims, all suspects would be dead. So it was using the normal classic system of handling cases. It was resulting in the justice for the dead. So it wasn't possible. So we had to find other means of doing things. Other political legal actions, because we had an experience of a country that was rooted by corruption. So as a principle, there must be transparency and accountability. The second principle was the national ownership of our programs. This means, as a country, as Rwandans, we said, okay, there's some aid coming, but we will not allow those people helping us to dictate us what we have to do. We know better what we need than what they think we need. And that's how we had some innovations using some homegrown solutions. And in the justice system, that's how we thought of some gacaca courts. And in 2003, we had our own constitution, because after the genocide, we had no consolidated constitution. We had something that was called Loi Fondamentale, comprised of 1991 constitution, just for some provisions that were not affected by Arusha peace agreements, and Arusha Peace Agreements themselves and RPF declaration after that of 1994. And this, for your information, was the first constitution that was written by Rwandans without the help of people from Western countries. And this is a constitution that expresses the aspirations and the values of Rwandans, what we need as Rwandans. In that constitution, that's where we introduced Gacaca jurisdiction. And Gacaca jurisdiction is our traditional way of handling things, focusing mostly on reconciliation, with some aspect of retributive justice, and allowing those who can confess and ask for forgiveness to be given lesser sentences. We introduced the Abunzi Committee. We prefer the term Abunzi. Before it used to be called mediation, but we realized that mediation is not Abunzi in our culture as Rwandans. Because in Kinyarwanda Kunga, it's something that is broken, and you join it together, it becomes that thing. Whereas mediation is just to reach an agreement or everyone live in peace, but it doesn't have that things of Kunga. And that's the reason why in the revision of the Constitution in 2015, we used the term Abunzi Committee, not mediation committees. And then, because of the history of the country, the separation of power, the guarantees of human rights, power sharing as a constitutional obligation, no matter how many votes any political party has won. For instance, in our constitution, the head of state and speaker of the Chamber of Deputies cannot come from the same political organization. And a political party holding the majority of seats in Chamber of Deputies cannot have more than 50% of cabinet members. That's Article 62 of the Constitution. And then the role of women, minimum 30% in all decision-making processes. Actually, women played a great role in the liberation struggle. So it was realized that they are capable of doing things. But also the special care for vulnerable and marginalized groups. But most importantly, with our history, was to have the national identity as Rwandans than as ethnic groups, tribes, or clans. In relation to legal and judicial reforms, you have experienced the genocide and you decided to abolish the death penalty. But we said, though there is Gacaca, we still have so many people in prison. How do you transform those criminals into a workforce? And we had what we call alternative sentencing, TIG meaning travaux d'intérêt général, that is community work, as a sentence, as an alternative sentence. There was criminal judicial laws reform. We created access to justice bureaus to help the population to access justice. And there were other law reform according to socio-economic development. Now, during that period, people were sensitized to join law schools. And in 2004, there must be a reform. Now you can imagine, you had judges who were trained for 6 months. Since 1996, they have been helping you. Now you do have some people who have just graduated from the university. Now they are qualified because they have law degrees, and you want to change, and you tell those people who had only short trainings, and you tell them, do you know what? Now your job is over. And they will tell you, what? So we went through these difficulties. Now you are telling me that I have to go out. And you tell people, no, you see, now we have to build a professional justice system. But as a government, We help you. Those who want to finish, to go to university, the government will pay for you. And that actually happened. And if you want to come back after qualification, then you can come back. So it wasn't easy to convince them. So recruiting qualified judges, prosecutors resulted in reducing the numbers of judges and prosecutors by 2/3. But we were lucky because of Gacaca courts, because it helped a lot. Actually, when Gacaca courts were closing in 2012, we realized that they handled almost 2 million cases. And if you want to compare the classic system like the one that was used by the ICT era to compare with the Gacaca, Gacaca handled this number that you can see there, almost 2 million cases in 10 years only. But the ICT era at that time, in 17 years, they handled only 72 cases. And in terms of expenses, it's something else. Gacaca, the estimation of expenses used about 5.2 million per year, while ICT era, it was about 1 billion per year. So now, if you want to evaluate the two systems, is Gacaca a success or a failure? I have read so many books about Gacaca. Even the moderator, her PhD was on Gacaca, but I can bet in all the comments about Gacaca, there were a lot of criticism, but no one ever proposed any alternative solution to handle our cases. You can tell me, no one. They just criticize, but no one can suggest an alternative solution. There were other many reforms, like introducing digital aspect in the legal reform. Now we do have what we call Integrated Electronic Case Management System, ICMS, where from Rwanda Investigation Bureau to the court, you no longer have lawyers or prosecutors with documents. Everything is done in the system. It is in the system until a case is closed. We have introduced electronic auction and others. There were also, there has been a reform of some institutions that are linked to the justice sector, starting from the Ministry of Justice itself, the courts, the prosecution, the police, correction services, and other institutions. But we created also new institutions like the Rwanda Investigation Bureau, Rwanda Forensic Laboratory, and the Ministry of Unity. We call it Minubumwe, to continue to deal with the aspect of unity and reconciliation. So the result of our chosen actions was to have a peaceful nation, using our homegrown solutions, using our programs that we own. Now the result is to have a country where convicts reconcile with survivors. The picture you can see there, that lady who is greeting that man killed the husband of that lady during the genocide. You can understand that sacrifice so that we can build a peaceful nation. So where we are coming from is really from chaos. We have managed to build a stable country, but we haven't yet reached where we want to go. Now we want to build a brighter future. And what we have gone through, what the country has managed to do, is not because we had means, we had no money, actually. But the most important thing that we had dedicated people. starting from our leadership. And another most important thing that actually helped was to have the right mindset. And having right mindset is what can help us as Africans, because we really need it. And quoting His Excellency, the President of the Republic, who said, let me read it, I would rather argue that we need to mobilize the right mindsets rather than more funding. After all, in Africa, we have everything we need in real terms. Whatever is lacking, we have the means to acquire, and yet we remain mentally married to the idea that nothing can get moving without external finance. We are even begging for things we already have. That is absolutely a failure of mindset. To conclude, I would say that what we have built so far, we need people, all of us, to protect it. But as I said, we haven't yet reached where we want to go. And the struggle continues, by the way. And our struggle is not the struggle of one day, 1 week, or 1 year. Ours is the struggle of lifetime, or maybe even many lifetimes. And each one of us in every generation must do our part. Thank you.
Thank you very much, Mr. Prosecutor General, for sharing generously from your wealth of knowledge and immense understanding on the subject under discussion. I particularly liked the fact that you took us through the journey that Rwanda had to go to ensure the different legal and judicial justice reforms that needed to be made, to be at the stage where we are, and that is why we are having this presentation, all the celebration of the different milestones that Rwanda has had to go. So to me, it seems it was the best alternative that needed to be taken, either by fire or by force, and here we are celebrating it. Distinguished guests, ladies and gentlemen, the Prosecutor General's presentation was building on the previous two presentations, one by Dr. Kabumba and the other by Dr. Muref. We've come to another interesting session of questions from our panelists, but as the moderator, I will begin by asking, and allow me to start with the Prosecutor General before the question maybe escapes my mind. Yeah. I'm curious to know, dear Prosecutor General, from the presentation and the journey of wilderness that you've shown us, should we say that Rwanda has reached at the peak of its dream, or should we say that Rwanda is at the end of its beginning? Thank you.
I'm not sure if I'm going to choose one of your suggestions, but my response, as I said in my presentation, is that what we have done, we have managed to build a stable nation, a peaceful nation, but that's not the end. Because we have to make sure, because destroying stability of a nation is something easy. Like naturally, it takes a lot of strength to build something, but when it comes to destroying it, it's very easy. That's the reason why we don't have to sleep. That's the reason why I said that our struggle continues, and we haven't yet reached where we want to be. Thank you.
Thank you very much. And as a follow-up question, given the experience of Rwanda, Do you also think to reach sustainable justice, a country needs to start from chaos, injustice, lack of rule of law, or it can be embedded at the beginning? The reason as to why I'm asking is that I need to know whether we can have justice that rebuilds the society from the beginning without going through the cycle of violence, given the experience of Rwanda, and perhaps also you can generously share what are the secrets that made Rwanda go through all that cycle and now reach the phase at where we are at. Thank you, sir.
One, you don't need to have chaos so that you can build a good justice system. What is required, as I have just mentioned, quoting His Excellency the President of the Republic, the first thing is to have the right mindset. The second thing is to have dedicated people. The third thing is sometimes being a victim of injustice may help you to be against injustice, but that's also a choice. As I said, when you are a victim of injustice, you may react as the other quote that I mentioned. You may react with bitterness, and things can go worse. But what is required when you are a victim of injustice is to accept that suffering and transform that suffering into a creative force. So what we need more is dedicated people and right mindset, not necessarily going through chaos so that you can change things.
Thank you very much. I think it's clear, and even from the presentation, it was well elaborated. The other question I have is for Dr. Kabumba. Please feel free to make reference to love and justice in the context. I would like you to present to us the major challenges in the administration of justice. I know you a bit of tackled it, but what are the main challenges if you look at our continent, and perhaps how can we mitigate those challenges?
Thank you very much, Charity. So, I spoke to it a bit. I really think that the main challenge is at this juncture between the kind of law that we have and the society which it serves or should serve. Now, that then leads to other challenges, and I think it was very interesting to see the difference between Kachach and ICTR even in terms of finances. So when you talk about case backlog or lack of finance, etc., I think those are manifestations in some cases of that disjuncture. But that's compounded by something else. A class of people who are invested in the maintenance of that structure. And that class of people are lawyers, judges, lecturers like myself, because if the system changes, I don't have a job. If the system changes, there's a whole other group of people are empowered. And that involves the loss of, I think we referred to the question of someone has gone to school for so many years, they have invested, they have paid money. So in very many ways, we are part of the problem because we're invested in keeping the system as is. Shakespeare once said, the first thing we do, let's kill all the lawyers. And I suspect that sentiment was coming from that frustration that society has against these people, us, who have a manifest interest in maintaining a system that doesn't work for many people. And I think that's really the main challenge. Thank you.
Thank you for sharing that. And now, Dr. Muref, is there a nexus between the evolution of justice and peace and security? Are there alternatives? Can they be cumulative? What do you think from the research perspective and practical experience?
Maybe to avoid repeating myself, because as I said, the nexus between justice, peace, and security is obvious. Is obvious in the sense that when you see distributive part of justice, where in the arrangement of the society has to accord equality among its people in terms of distribution of resources, but in distribution of opportunities as well. In that, in itself, prevents conflicts that would arise from marginalization of people, frustration that goes with those that feel that have been left out by their society. And the fact that justice, when you see it from the classical understanding of justice as resolving disputes, that in itself also contributes in contributing to peaceful resolution of disputes and providing just peace. But I think what Dr. Kabumba talked about with the killing of lawyers, I think in the process of Gacaca courts, there is a lot that was demystified. One is that justice is not something that is alien to people. We all, in ourselves, have the ability to know what is fair and what is not fair. And I remember one of the criticisms of Gacaca was that there were no lawyers in Gacaca processes. And I remember I was having a conversation with one of the researchers, and he was arguing from the point of view of the equality of arms, that there are no lawyers, so this person have no capacity to defend his or herself. But there is something they had failed to understand is that there were no also prosecutors. So if you're talking of equality of arms, that is a canon principle in the classical law system, is that even those who were making accusations were ordinary people. And then there was, what about the judges? The judges too were not also lawyers. But the question I wanted to ask, because the judges in the Gacaca courts were mainly determining on whether someone is guilty or not, depending on what has been said during the trial. And the aspect that was important to understand, and I think lawyers that still needed to understand, is that there is no law school that teaches how to determine that someone is telling the truth. You will never find that lecture on, when you listen to someone, you know this one is telling the truth or this one is lying. And if you want to go a little bit further, you can ask yourself, how do countries that have jury systems operate? The court d'assises in Belgium, for example, or the jury systems in US. Because the determination of whether someone is guilty or not is made by people who did not go to school. And that in itself tells you how the idea of deciding that this is a fair outcome is shared among all of us. If you go to a courtroom, you will leave it knowing that this person is, to a large extent, likely to be acquitted or to be found guilty. And you don't need to go to a law school to learn that. So so justice, as classical justice system, these are systems that we have built for so long. There is no one who is going to suggest that we should get rid of them, but we should also improve our ways of knowing and doing things. And this we don't, and probably we'll touch a little bit on what the Prosecutor General said. We don't need to face challenges as Rwanda faced to be able to say that we can reinvent our traditional ways of doing things because they relate with our context and the way we understand, and we don't need to refer to the divorce that was decided in the UK to know whether our families are married or not.
Thank you very much. That was informative, or as you indicated, there is a nexus between justice, peace, and security, and it is your suggestion that justice should be pursued in all situations to achieve sustainable peace. But I'm wondering, how can we do that? Thank you.
To the extent and the maximum possible, considering political will, available resources, and I would say other values, because sometimes lawyers tend to assume that law and justice are the only important values in society. Peaceful coexistence is an important value. Reconciliation is, unity is. So you have to consider all those other aspects. And then, more importantly, is how the people themselves, to whom that justice is going to serve, are going to be involved. Then we will talk about justice as a process. Not only justice as an outcome, but also justice as a process. Because it is these individuals, ordinary men and women in communities, who are going to live with that form of justice. So when you decide to release someone back to community, someone who was suspected of a crime, how is that individual going to be received in that community? That is not a responsibility of the prosecutor general. It is not the responsibility of someone, a local authority. No, it is that particular neighbor who has experienced the harm. So I repeat, it should, justice, reparation, and other forms of justice need to be pursued to the extent possible, considering other values.
Thank you very much for bringing that aspect of political will, and this matches what the Prosecutor General was talking about, having the right mindset. And going back to Dr. Kabumba, who also talked about the motto of a legal practice institute, where it is know the law, nothing else. So how do you reconcile that? What is the correlation? What do we need as Africans, as African institutions, to reach that justice that we need?
Okay, so I think one of the ways was in the Ugandan case, and it sort of mirrors the Gacaca process, was the reform called the local council system, formerly called resistance councils, but then called local councils. Because there also, lawyers were forbidden. So you had, so these were systems, or are systems where the society takes charge of its own justice, if you like. So the judges, people from the society, and no lawyers are permitted to be there. The challenge, of course, is that, again, historically, the greatest resistance to that fundamental reform has come from the legal community in Uganda, the Uganda Law Society and others. And right from 1986 to present, that system has not been allowed to grow and develop. And I think really that is the challenge. Because again, it goes to vested interests within lawyers as a class. And a class which is, and I use that term very deliberately, a class which is itself wedded to capital. If you ask law students what kind of law they want to practice, 80 to 90% usually say commercial law. That's normally the answer. When they're in first year, then it may be 60 to 40 or half-half. Some will say human rights, etc. But by fourth year, they're talking about, there's a phrase now, securing the bag, which is basically, I've invested so much time and effort, I'm going to make money. And that it is that marriage between law and capital that is resisting any real effort towards change. And I think that really is the dilemma that we face. Thank you.
Thank you very much. We're actually looking forward to the debate, which I think it was timely. Thanks again to our panelists, and thanks to the organizers of this symposium, and specifically for including this sub-theme that the panel has been discussing, which has been explored in great detail. Allow me, distinguished guests, participants here present, open the floor to the audience for different questions, comments, or commentaries. Yes, and the MC or the protocol will help us in giving microphones. I just want to make a few remarks as we open up the floor to the audience. We want to keep this session as interactive as possible. So right now, we will invite the different people that have raised their arms. You have to mention who you've addressed your question to. Is it to one panelist or to the whole panel? Yes. Yeah, I see a couple of hands, I think starting from the front and then, yes. Yes. The Vice Chancellor.
Thank you so much, moderator. And if I was to rise, I would rise with a lot of disappointment because the honorable panelists, when they were presenting, I was feeling really moved because they were all directing to something that I've been working on for quite some time, even though I'm not getting to the end of it soon, which is about the evolution, comparing the systems, the traditional justice system in Rwanda and in Africa and the contemporary one. Right from Dr. Mure, very well, that it was comparing the King's Court and so forth, and was kind of showing some good results of it. It came to, he did the same. He was showing how disappointed were as they interacted with the classical justice system. And when we came to Honorable Prosecutor General, he showed us how there was a total failure when it comes to classical system, justice system, and how the unconventional, let me call it unconventional, but when we got back to our history, to our system, produced great results. But now in the discussion, they all seem not to be willing to, retreating from the classical system to getting back to the useful one, most relevant one. Is it a fear of losing the jobs? Is it about, why are we not exploring possibilities of getting back to that very rich system that served us best and sticking to this system that is not producing better results as we would wish? Thank you, moderator.
Thank you very much, Dr. Kayura Didas, for those who may not know him, but for other people who are raising their hands, please mention your names. I may know you, but the whole audience needs to know you. And I guess the question is addressed to all panelists. They need to justify their fear or come against it. So thank you. We start with this side, yes. I can see other hands there.
Thank you very much, moderator. I think the Vice Chancellor has sort of preempted what I wanted to say, but maybe I would say it in a more crude way. Sorry, my name is Arthur Simwe, and I'm in the media sphere. You see, for me, I think one sector in Africa that has never been liberated is the justice or legal sector. I think when Africa got liberated and got independence, one sector that remained behind is the legal sector. Even the way they dress, the justice, even the way they dress, you know, the judge is happy to come with their robes and wigs. The lawyers are happy to come with their long white, for lack of a word, maybe handkerchiefs that they put here, and And you know, they feel so smart. For the most celebrated lawyer in court, he or she will be respected and honored if they are quoting case laws that are from Belgium and London and the US. None of them is happy to quote a case law from Ghana, from Kenya, or from Nigeria. You know, they're still so much westernized. So my humble question or submission to, and of you, because all of you are coming from the academia, is what needs to be done to develop principles of law that are grounded in the African context. In the African context. You have cited very good examples of, Gacaca, the Museveni case of social justice, but still, you see that much of the academia is grounded in the Western principles of justice. So how do we bring in the African context? And especially you guys that are in the academia. That's number one. Number two, bring it back home now. And in relation to this topic, justice, peace, and security. In Rwanda, when we look at these, the three legs, justice, peace, and security, we score very well in all these areas. Even global rankings, even those that are done by RGB. Justice, we're scoring very well. Security, we are very okay. Peace, same areas. But there's an element where we don't score so well according to the global ratings, which cannot be distanced from these three. And that is democracy. Or even say human rights. So I ask myself, can you be performing extremely well in these three areas without being a nation that values the principles of human rights, of freedom of speech, of democracy? Is it some sort of confusion? Or you can say that, you can perform extremely very well in those three aspects, and then the other one you do poorly. What's the link between these three things? Thank you so much.
Thank you, Arthur, for those two interesting questions. I think, if I'm not mistaken, it must be Dr. Goloba. Yes.
Yeah, thank you very much, moderator. My name is Frederick Goloba Mtebi. I'm a former academic. And I say this with a certain degree of satisfaction, having listened to my friend Usinje, and how, on the one hand, academics, lawyers, judges recognize that there is something wrong with these things you're protecting. There is something wrong with the practices you engage in. But then, at another level, there is this inertia. We know this is wrong, but we will not change it. That made me think of something that some of my fellow political scientists and I keep reflecting on with regard to issues of democracy and governance, in that the practices that we are encouraged to engage in to promote democracy have been found to be potentially disruptive, potentially destabilizing, but we still protect them. Competitive politics and multipartyism and so on and so forth. Now, we usually tell ourselves that it seems as if some of the greatest enemies of Africa are we, the educated elite. And I would like to ask the panelists to comment on this. My second issue, I raise this question, it's directed at the Prosecutor General. The Prosecutor General did a very good job of showing how this whole Gacaca process came about and the justifications for it and the difficulties that the government of Rwanda would have faced if they had gone the conventional route. Now, after Gacaca ended, what has happened? Have you continued with applying the principles of Gacaca in the judiciary of Rwanda, or have you abandoned that and now gone on to embrace the things that you say are wrong? Because I know for certain that the justice and law and order sector in Rwanda, we have some of our development partner friends who are very active in that sector. How much are they infusing their confusion in the reforms that you're carrying out and the practices that you're engaged in? Thank you very much. Oh, maybe the last thing, Dr. Mlef, you mentioned this thing of political will. Now, this is something that is thrown around very often. Political will. As a political scientist, I wince each time I hear people use that term, political will. It's actually not true that politicians make the right decisions or the wrong decisions because of political will. It's not true. It's absolutely not true. Politicians make the decisions they make. And again, the Prosecutor General has demonstrated this in one of the slides. The reason why Rwanda chose not to go the conventional route in settling this question of what do you do with genocide suspects, 150,000 of them in a crowded prison system. The reason you chose to go the Gacaca route was because you had a problem. If you had gone the other way, it would have taken hundreds of years. People would have died in prison. You would have been accused of human rights violations and worse. So actually what caused that was the incentive. The incentive was you wanted to avoid the consequences of holding these people for a very long time in the prison system. So rather than talk of political will, it's actually the incentive. You ask yourself, what's the incentive that politicians have for making the decisions they make? Political will just doesn't cut it. Thank you.
Thank you very much. For this session, we are going to take questions. I was going to say 5 questions. It's not actually 5 questions. It's questions from 5 people. So Gatete, you can ask a question, and then the officer behind, and then we call it for the next round.
Thank you very much. My name is Gatete Nyiringabo. I'm a human rights lawyer who's friends with the police. It's quite atypical for that to happen. And perhaps to speak to, when I listen to Arthur and Fred, I think one is answering the other. One of the reasons we don't score on these indicators of democracy and so on is whenever we attempt to do things the way we think is right for us. So in this capacity, as a human rights lawyer, I recall a case. So I was hired by GIZ once, when I was a human rights lawyer, to help a Tuareg elder to present in front of the African Commission of Human Rights. And now, you know, Tuareg men, they wear these turbans and these robes and so on. And before they speak to you, but while they're removing them, they are invoking all sorts of blessings upon you and your family, and they're speaking in their language. They say, may peace be upon you, may peace be upon your village, may peace be upon your family, and so on. And once they have removed most of them, they feel free and comfortable to now talk. Now, this is true also in Rwandan culture. Before people start addressing you for the real issues, they offer you some local alcohol, maybe milk, and so on. Now, it turns out that at the African Commission of Human Rights, you only have under 5 minutes to speak. Otherwise, they cut you off. So I spent a week this human rights symposium in Banjul. I spent a week with this old man trying to explain to him that he has only less than 5 minutes. But this is an old man who's 65 years old. He's not going to learn within a week of speaking to a young man who was less than 30 years old at the time how to behave when he has to address old people. And indeed, what happened, what I feared, my fears happened when he went to the African Commission of Human and People's Rights. He never got his ideas across because he first behaved as an elder who respects the panel that is in front of him. So before he actually got to the issues that he was to address, his time was up. The reason I'm giving you this illustration is that in Africa we have African causes. We have African courts, so jurisdictions. We have African laws. and we have African lawyers. It turns out we never discuss about any of those things. We discuss European or Western causes. We use European lawyers. We speak in European languages. We quote European laws in Africa. So in Africa, when we want to speak, and African courts, which is like the African Court of Human People's Rights, you will see people who want to deny the genocide against the Tutsi. Fighting genocide denial is an African cause. It's a Rwandan cause. But the African Court is the platform that people who want to deny the genocide against the Tutsi go to receive justice. So in Ingabire, for example, Rwanda had to withdraw from this African court because it said this court is now being used by people who either committed genocide or want to deny the genocide. Ingabire Victoire won a case in the African court. Sorry, it's not Immaculée. I went to school with that law done to South Africa. Zimbabwe had just withdrawn from the SADC tribunal. In fact, the SADC tribunal had just been dismantled. Zimbabweans had fought for independence to end apartheid so they can access land as a people. The ZANU-PF wanted to bring back the land to the people. Then the colonizer, the people who had the land, went to an African court to oppose the purpose of the fighting for freedom in Zimbabwe. And this court found that the white farmers were right to occupy the land of the people. And Zimbabwe had to withdraw from this court and, in fact, dismantle this court. Because it was self-denial. It's Kikwete who said they created the monster. So it turns out that when we create institutions that are supposed to give us our rights, these institutions are usurped by non-Africans to undermine our own rights. In Uganda, they're discussing LGBT.
Gatete? Yes, please. Yeah, just make it clear. Who are you addressing the question?
I'm 2 minutes. In Uganda, they're discussing LGBT issue, but is it really a Ugandan question today? Or is it a question, is it the priority in Uganda today, or is it pressure from somewhere else? This African court I'm talking about, there is a GIZ office at the court. You know this? Which funds most of the activities of the court. So you can imagine what agenda the court has. So I'm saying this because it's Jerry Rawlings, the president of Ghana at the time, who said during the Cold War, we had no opportunity, between the East and the West, we had no capacity to be Africans. In Rwanda, the reason we abandoned the Gacaca, which is taking this opportunity to do some marketing, we just finalized a book on the history of justice in Rwanda on behalf of RIB, of Andejano. And we document the Rwandan justice system. But the Rwandan justice system had nothing wrong in it. Maybe we could have borrowed from Western system to complement it. But because we fear what Arthur is saying, not to be scored properly on democracy, on this and that, we have to adopt a complete alien system so that we can fit and belong to foreigners' approach. And now we are surprised if it does not serve our context, our interests, our problems, and our solution. So there is an issue. I think it's what the general consensus here is that we have systems that are alien to us, therefore do not serve us right. Which is why, you see this Peace, Security, and Justice Symposium, it should start with security because it's the paramount issue. But if you prioritize security, they will tell you are not democratic because you are not scoring properly to the scores that are foreign context. Thank you very much.
Thank you, Gatete, for that interesting comment that you're making. And now let's have the final intervention for this round. We'll get back after we hear from our panelists. Yes. Okay. Yes, the complaint has reached the panel of judges who will handle it diligently.
Thank you. I'm Superintendent Jean-Pierre Sanvora from Rwanda National Police, also a student in the Police Senior Command and the staff course. Before asking my question, I want to make some ground on tradition in Africa, also in the culture. Maybe I want to refer to the northern Uganda, where we have the Akoli tradition, culture, where they encourage individuals to accept their mistakes and take responsibility for their actions, which is about the justice, which is including reparation. Also, I have to think also to Ubuntu from South Africa, where they think humanity towards others. And again, come back to Gacaca in Rwanda, where it is about participation of everyone. My question is, how can the historical context, best practice and successful experiences from other regions and or countries inform and shape comprehensive legal reforms and policy initiatives aimed at improving the administration of justice in Africa? Thank you.
Thank you very much for the 5 interventions, but some of the people had a couple of questions. Now it's time for our panelists to respond to the different questions or even the comments that were made. I'll start with the Prosecutor General, and then we'll continue.
There are some questions that are almost similar, but asked in different ways, like the one asked by the Vice Chancellor of the University of Rwanda, which is almost similar to the question that was asked by Arthur in relation to what needs to be done, but also related to what Dr. Goloba asked about if we have completely abandoned the Gacaca, what we are doing. The first thing, let me start with a comment or a concern raised by Goloba, and then I will come back to those questions. Thinking about educated people, if the problem is not the educated people. If you go throughout our history, you will realize that the main problem were actually caused by the educated people. But the issue is not to have educated people, but the issue is now the people who gave that education and how we applied that education. Actually, being educated and having a knowledge with the development of country is something good. But now the problem is how that education, especially by Western countries, managed to corrupt our minds and our thinking. Let me give you an example. I'm a lawyer, and I do remember, because I was educated in civil law countries, when it comes to interpretation of laws, they used to tell us, and I do remember there is even a former minister who used to say that, and that's in relation to interpretation of laws, because there are different types of interpretation of laws: literal interpretation, purposive approach to statutory interpretation and so on. But like in the civil law countries, they stick more on literal interpretation. And one day, they used to say that if the law says that you Aimable is my name, that you are white, then you have to apply it. And that's what we used to accept. And we still have that problem, like having lawyers, judges, even prosecutors, who read the law and stick only on what is written in that law, without thinking about what was the purpose behind enacting that law. So I am giving that example just to show you how they managed to corrupt our mind. So the problem is not to have educated people, but it's good to have the knowledge, but we need to change our mindset. I'm happy that the Minister of Justice is entering this room now. There is a time they were handling, because he used to be the president of the East African Court of Justice. And there is a story he told us that they were handling a case, and one of the judges told them, because there were a lot of debate, and one of the judges told them that the fact of having something written as a law, if I can remember well, does not deprive us as judges of having a common sense. So that's what we lack. That's the reason why we need to change our mindset. And when it comes to the democracy that Arthur mentioned, he said we are doing well in justice, peace, and security, but when it comes to democracy, actually, in all international reports done by these international organizations, we score very well in terms of justice, security, and peace. But when it comes to democracy, they say, no, there is something wrong, especially when it comes to freedom of speech. Now, sometimes I wonder why they are doing this, but actually it shows that they do have a hidden agenda. Because the same when it is applies in their countries, it is not acceptable. Ability. Go and look for funds to activate for human duties or responsibility. You will not get any fund. That shows how sometimes there is something, an agenda behind it. In as far as we are concerned, if we have abandoned Gachacha, or to respond to the question of Didas and Arthur, the problem is not having courts. With the development, with the technology, it's good to have court. But the issue is how our judges are handling those cases. Do they introduce our values in handling the cases, or they continue the practice of those Western countries who taught us law? So the issue is not having court, but how we do behave in handling conflict between the population. And that's the reason why, for instance, in Rwanda, though we no longer have Gacaca courts, but there are some aspects that are handled using our values. For instance, in our court system, at all stages, at all levels of the court, a judge is allowed to do mediation. And we still have, as I mentioned, the Abunzi committees. And even in criminal matters, starting from the Rwanda Investigation Bureau, if they see that it is a case that they can try and mediate the conflicting parties, they have an obligation to do that. We have introduced the plea bargaining system. So those are the things that we are doing in our justice system to continue using our values in handling the case that we do have. But there's something that we need to invest in. Is changing the mindset of the population. Now we do have a population, and this recently I have experienced it, and even yesterday, because I came here yesterday, and I managed to go to visit some of the prison cells. I was with the RPC, and you realize that now the population, where they are, how they think, because they know that they do have an efficient police, RIB, and system. So now they want that every case be handled by those organs. So everything, even someone having a small conflict, that person wants that person to go in prison, in jail. So what we have to invest a lot in educating the people that there are things that they can handle themselves without going to court or without reporting the case to RIB or police or to the prosecution. That's something that we need to do now, educating the population. But also not the population, but even the local leaders, so that they can feel that now they are responsible of resolving most of the conflict using our traditional values and method without using this contemporary system as mentioned by Didas Kaihura. Thank you.
Thank you very much. So after Gachacha ended, the principles did not end with it. Homegrown solutions and approaches are still applicable, like the Prosecutor General was saying. Now it's time for Dr. Businje to continue.
Thank you. And I also note that the interventions from Dr. Kaihura, Arthur, Frederick, Gatete, whom I shared accommodations with in down there, Pretoria, and the colleague from the prosecutor. Not that we're in the same room, but you know, in the same general area. The interventions challenge us. Challenging us partly. So you have identified the problem, and I guess the question is, so what? The so what question, and it's an important one. The inertia, part of the inertia that has been pointed out, again, really is part of a deeply vested interest on our part. I'll just give one example. In Kenya, Chief Justice Willy Mutunga enacted a reform to do away with robes, do away with wigs. As soon as he left office, Chief Justice Maraga reinstituted the wigs and the robes. So it seems that we like these things. We're invested in them. We want to terrorize and terrify the population, and it seems that these are things that we need. Conversely, in South Africa, as part of the post-apartheid reform, part of it even was architectural, to ensure that the court has a lot of transparent windows. The design was deliberate to both send a signal to the judges, but also to the litigants, that what you're doing is being seen, and the justice must be owned by, you're being watched also. Of course, the question at times is, who judges the judges? Who oversees who guards the guards, as the Latin maxim goes? And ultimately, the people should be owners of this process, but unfortunately, as it is, that is lacking. And that leads me to another comment about, and I take the point about the failure of democratizing judicial power. I agree that we have made strides in terms of legislatures, in some cases executives, but judges have now become, I suspect that judicial power itself is now turning towards tyranny. One example is the power of contempt of court, for instance. In our Constitution, Article 28, Clause 12, it says, except for contempt of court, no person may be charged for an offense except if it's written down and the offense provided for. So the one exception The one offense for which you can find yourself guilty out of the blue is contempt of court. Technically, you're looking at the judge badly. The judge doesn't like the way you're looking at them. That is an offense, and the complainant is the same person who passes the offense almost immediately, without any provision for legal defense. And it has happened. I think in our case, there's a lawyer who brings a lot of cases, Malema Virizi. He was disturbing a particular judge, and he was sentenced to 18 months in prison. 18 months. Really for no other offense than annoying the judge. The Supreme Court has also sentenced, I think, one person to 3 years for the offense of contempt of court, which again is annoying the judges. And I think this is deeply problematic. And also happening even at the magistral levels. And one of the scandals came out last month, where a magistrate denied bail to a lady who was, I think, 74 years old. That surely, how do you deny bail to such an elderly person? Well, so the fear is what? They're going to run away? So there's that disconnect that's happening. And my own suggestion really is that as part of the judicial training, the judicial orientation, magistrates and even new judges must spend at least one night, preferably 2 to 3 nights in prison, as part of orientation, so that one appreciates, because it's easy. It's easy to sign and say, these are 2 years, 4 years, but even one night can change your life. And if there's that appreciation, I think it will change things. And this leads me to one aspect of justice in Africa that is really a problem: the prison system itself. Incidentally, the prison as an institution is un-African. I challenge anyone here to cite an African culture, an African society, where there was a room where you take someone who has infracted the law and you lock them, and then you keep checking on them for 1 month, 2 months. There was none. At worst, there was banishment. Banishment. You're excommunicated. You go somewhere, you take your bad manners somewhere else. But the idea that a human being is in a room, 4 feet or something, and has to perform their entire life functions for 5, 10, 15 years in that room is problematic. And it's historical. Its introduction here was historical. It's being used in the United States to target black African American people. Today, 1 in 5 black American men is in prison. And for me, it's problematic that we continue here in liberated Africa, we continue that practice that was rooted in that sense. So I think I'll leave it at that for now, only perhaps to agree with the Prosecutor General about the importance of judges having values and infusing their decisions with those values. The best case scenario, of course, would be to have popular justice. But if that's not being achieved at the moment, then judges must be deliberate and intentional about infusing their decisions with. I'll just give one example. UEB versus Musoke. This was the case where a boy of 14 years was killed by a vehicle belonging to the Uganda Electricity Board. Now, weirdly, there's a law, the Law Reform Miscellaneous Provisions Act, that calculates, there's a law that enables it to calculate the value of life. The calculation is life expectancy minus the age at which you've died plus the particular amount of money. So there's a figure that is put to life. Now, in that particular case, part of the argument by the applicant was that we were expecting this child to take care of us in our old age. Any African parent here can relate to that expectation. But the judges said that expectation is fanciful. It's not known under the Law Reform Miscellaneous Provisions Act. All we know is the expected life. And so it's that. Those are the challenges that we face, and I think the question about judges, the importance of not letting the letter of the law deprive judges of the common sense, I think is critical. Thank you.
Thank you for sharing that and for bringing in the aspect of values. So it's not about the gowns and the robes that judges have to put on, but it's the justice that they deliver that matters. I remember one interview with an official from the Ministry of Justice during the proceedings of Gachecha, they asked him, can these people really render fair justice? And he said that, please, the fact that these people are not putting on robes and gowns doesn't mean they cannot render fair justice. So thank you for that. Let us hear from Dr. Murefu.
You said that in Uganda people were denied to study law until after independence, but in Rwanda we got the university after independence, and we got the prison in 1930. So that tells you what you're talking about. So I will, because most of the questions were really like the same, and I think there have been some fair justice in the response, in the continuation of the conversation. I want to talk about the aspect of the fact that we are judged poorly on democracy, and argue that it is probably because we claim that what we are doing is democracy. And maybe let us that sink in a little bit. Because, and this is part of the decolonization that we needed to do, the desire to explain whatever we do in the Western concepts. If we explained what we do only in the principles that are claimed to be the best principles of governance, without necessarily having to call it democracy, then probably we would be fairly criticized for not practicing justice, but what we are practicing could be judged on its own merit. And this comes to, because that's what we do at the university, we do research. I have a proposal that I'm working on with some other colleagues from South Africa, where we are asking ourselves one question. Africa has had, with its 55 states, countries, have had some countries changing leadership for more than 5 times or more. And it cannot be true that all these African leaders are bad leaders, unless we are equally saying that Africans are bad people. Otherwise, African leaders come from Africans. So there should be something that is wrong about the governance systems in Africa, or something that is really wrong that makes it difficult for African leaders to live to our expectations as people. And we want to do research in traditional African governance systems, not to say that we can reproduce those governance systems, but to see what kind of values that were in those systems that could be introduced in the governing systems in Africa. Let us take an example of where, for example, whenever, because Africa has suffered a lot in terms of divisions, because of the way the boundaries were established arbitrarily. And we are now practicing where democracy is vibrant. I speak under because the academics, we always speak with immunity. We are free to offend some people. When you look in our region, you could say that the vibrant democracy that we have is in Kenya. But when you look it closely, you will realize that it is ethnic mathematics that is being played around. How many Kikuyus do I have? And how many Kalenjins? And then if I add this part of the society to this one, then I know I have the majority, I will win. Certainly, in terms of the value system, that democracy is questionable in terms of what kind of values do this person, particular individual, stand for? So if you go back to traditional societies, you will find that whenever one kingdom conquered a particular people in some societies, you'd find that there would be, for example, a need to get married to one of the, a king would marry in that society. They have many, then we go back to polygamy. That's not what I wanted to advocate for. But that says something, about the inclusiveness, being able to include every part of the society to the table where decisions are made. So we can look into different forms of governance and see what values were there that kept people together, and then can we apply them. Whether you apply it to democracy or to another form of governance, that is another thing, because human beings pride themselves in innovation. So it cannot be true that it is only in governance, something that is critically important to our survival, that we shouldn't be encouraging innovation. That we will only stick to democracy. I think that is something that needs to be looked at deeply. I thank you, Goroba. I'm not a political scientist. I wanted to say that when there are so many interests in forms of dispensing justice, there is a need to know what kind of concessions that are going to be made and what kind of gains that those who are going to live with that, what you have called justice, are expecting. And that is, if you, for example, when you talk of post-conflict societies, if there are two conflicting parties, and you want to go for classical criminal prosecution, probably you are likely to prolong the conflict, because some members of those that are involved in the conflict might refuse to a peaceful outcome, because by doing so, there is a likelihood, which happened with actually South Africa, because there was a debate whether those that were involved in apartheid should be prosecuted or not. And then the question was, how are you going to put all these military generals of the former regime under prosecution and expect to have a peaceful outcome? So those kind of concessions and compromises that needs to be made are also critically important for a peaceful outcome. And certainly that is an incentive, as you said, for the recognition. So should we deal with the elite? How? The fact that elite was trained in this system. I've been in school for, the majority of my life now has been to school. And then all of a sudden you want me to change. It is difficult because people have been trained to think in a certain way. So the changes need to go deep into the curriculum, but also the willingness to integrate, not to dismantle what that there is at the moment. Because again, you cannot say that the current systems are not working because of where they come from. They are manned by or womaned by us. So in that case, we need to be interrogating ourselves. How do we conduct ourselves? How do we manage the affairs that we have? Do we do it just because, as I said, justice, fairness, these are things that we commonly share. Whether you go to school or not, you can do something and genuinely feel that this is fair. If something happens, we can all agree that this is unfair, even if we cannot define what fairness is. And I'm doing, my PhD student is now working on a proposal on why is it that Rwanda is, on one hand, encouraging the modernization of court systems so the electronic and all that, but it is also encouraging abunzi. So is there a conflict, you know? And can we find some philosophical explanations for that?
Thank you very much for that deep view, Dr. Murefu. Let us now come to our final round of questions. And looking at the time, we are just going to give 2 participants, and probably we would also love to hear from the students. Yes, so we are going to get 2 students and maybe other participants from this side. And this side said I was unfair for the beginning. So I'll start from behind 2, and then we hear from here. Yes, the MC or the protocol can help us.
Thank you very much. First of all, I would like to thank the National Police of Rwanda for this function. It's much of it. My name is Benedicto Tongbol from South Sudan. And I don't represent South Sudan in any way. I'm a student from ILFD, Institute of Legal Practice and Development, Rwanda. My director is here. To the panelists, I've learned a lot. And one by one, I just want to say that much of the problem we have in Africa is not a problem of law. It's not a question of law. It is a question of leadership. And I go back to the reference made by the then Prime Minister of United Kingdom, Tony Blair, that what we need in Africa is not democracy that people talk about. I think he used to talk about that. But a dictator who is benevolent, dictator who knows what to do. Let me leave it there. To my point, and I will be guided by the presentation made by the chief guest, the Honorable Minister, that out of 9 people, 1 person has no access to clean water or is living below $2 a day. In fact, if it is $2 a day, then it is big. For me, I think it's lower than that. On this point, I would say that the other problem we have, things that we are trying to solve now, and I think this is the reason of this gathering, is the question of people who suffer from what I will call collective punishment. Because people who suffer from collective punishment are very many than people who suffer from individual punishment. A, which is positively addressed, is the issue of the genocide against Tutsis. It was a collective punishment, right? But it's well addressed. But let's go to our neighbors, and I will take one example, Congo. All of you
Kindly be precise and brief.
All right. Congo. Most of you are aware of what Mobutu Sese Seko has done. The man has stolen 5 billion. And this is not from my word, it's a word from Dambisa Moyo in her book, Debt Aid. Mobutu has stolen 5 billion, which was equivalent of 5 billion debt for Congo by then. Assume this money was used in a political way of using things for the benefit of the people, to build the houses for the people of Congo. Then, the rain that destroyed structures that were not well fixed 2 months ago would have not done that if that 5 billion was well spent on housing. So the question is, what more do we need to do to address this identical problem that contributes to collective punishment. Case in point, corruption. Thank you.
Thank you. Who do you address the question to?
I will say that the panelists may choose because it's open question. I don't know whether I've said my name before. Benedicto Tong Bol Tong from South Sudan. Thank you.
Yes, one question from this side, and then we get two from here, and we are done. Yes.
Good afternoon. I am Momodu Musa Marena from Gambia. I am a student of ILPD. And my question isn't directed to anyone in particular, but it's just to any one of them, actually. So I would like to know if it is the lack of Pan-Africanism with regards to some of our leaders that is hindering us from sustaining the justice for sustainable peace and security in Africa. Because a lot of African leaders really take their time when talking about issues with regards to other African countries. Take Senegal, for instance, my neighbor, who are currently going through political crisis, but very few leaders have actually come out to help in solving those problems. So I would like to know if it is the lack of Pan-Africanism that has hindered us from achieving these goals. Thank you.
Thank you very much. Allow me, as we come to the end of this session of asking questions to our panelists, ask Dr. Eusta. She had raised up her hand to make her comment or question, and then I'll end with the Minister of Justice. Thank you.
Well, I had given up for the students, but I wanted to say that I really appreciate the discussion. But I guess I feel we might be getting lost in between the past and the present and the alien and the indigenous. And I guess part of the discussion is really, and I like what Dr. Molefu challenged, we had the first prisons. I know we had indigenous legal systems. We had the first prisons, but we did not have the first penalties from the prison perspective. Look at the histories. You know, those who speak Kinyarwanda, you know what used to happen to girls who got pregnant. There were also some unacceptable social justice behaviors in our tradition. So, and it comes back to what Dr. Molefu ended with. Nobody has ever called us to choose either or. The discussion on why the lawyers are wearing gowns, challenged by an African man wearing a tie, does not add up. So let us not get lost into the semantics and get lost in the right mindset issues. If our people are suffering with challenges of injustice, insecurity, and the absence of sustainable peace, I think the bigger discussion should be, what are the things that cause injustice? And I think the minister articulated it very well. Issues of poverty, issues of opportunity. Otherwise, I guess, you know, well, somebody earlier said, and I will end at this, and the minister quoted it as well, we celebrate when they say people feel secure walking at night. And then we are quoted as a country. Do you know the problem? The biggest problem is that we don't speak about how many kids feel insecure being in a classroom in the US. Because the standard has stopped us to speak about it. Kids die on the hands of other kids or anyone else. The schools have become almost the most insecure. If you look at how many kids die in that regard, or how many people die in school shootings in the US, it's more than any other deaths that happen. But they have gotten the benefit of not being challenged on that, and we have been presented with the justification that, and I think for us, peace and security is a consumption, something that we want to consume every day. Otherwise, I think the discussion might get lost into what we are wearing and what we are not wearing. And If we want to go back to African dresses, we should. But I guess the problem for me with the lawyer is not the gown that they are wearing. It's the mind that is beyond the gown. I might not have decided to wear the gown and wear it because everyone else wears it. But who is in me? Is it an African who is conscious of the challenges and the issues that are in my community? Or it's actually the mindset that is taking me wrong? So I wanted to bring back to that part of the balance. And whether you wear your gown or not, I want you to think Rwandan and African. Thank you.
Thanks for that. Let's hear from the Honorable Minister of Justice.
Thank you very much. And yes, yes, thank you very much. And my remarks are not as Honorable Minister of Justice. It's, my remarks are by Emmanuel Ujira Shemja for a change. Yes, I've heard from the panel reference to certain concepts such as the Western democracy. I would want to hear more about the definition of what the Western democracy is. Because when you look at what we refer to as the West, and look at what they refer to as democracy, and they don't even have a standard one which you can call a Western democracy, then it begs you to go back to the origins of what democracy was in the first place. Democracy was a form of governance for the Greek, which comes from the word demos, which is common, and kratos, which means force. So largely governance for the people, by the people, and all the definitions that we have of democracy. But when you go to certain Western countries, I'm thinking of the US, for example, where what they call democracy is actually not common force. It is to ensure the stability of the states within the US. And that's why it's possible in the US democracy to have someone becoming a president, but when you count one vote per person, they've lost by 3 million votes, but still we call it democracy. So is that part of what we call Western democracy? Then we go to countries such as Belgium, for example, where a country can survive for 4 years with no government, or even more sometimes, and wonder whether that is also democracy. But I want to understand what is Western democracy, if we go by the definition of what democracy is. Then there are certain also concepts that I've heard from the panel, and I heard about freedom of expression. It is true that it's not fully guaranteed, but also the definition of it really also begs some definition, because if I remember well, in the US, in the Supreme Court of the US, when they wanted to cap the funding from people to political parties, that particular capping, I think, was rejected on the basis that it was against freedom of expression. So businesses can express through giving money to political parties. So that's part of what they define as freedom of expression. And then when you come to European countries, what we understand as freedom of expression, including expressing your faith. We've seen certain countries banning dressing such as hijab on the basis that it's against the traditions of that country or customs of that country. At the same time, when another form of dressing is referred to as freedom of expression. So I really want to understand whether these things should not be looked into in the context of what country we are looking into, rather than having broad concepts which you cannot even define. And then, of course, even this freedom of expression is I think it's Dr. Kavumba who really put it in a proper way. You have a freedom of expression because you've been nurtured from the time that you joined school, of course. So your expressions are nurtured in a certain way. And I think it's the Germans who capture it very well when they refer to their formative education as kindergarten, meaning they refer to children as gardens where they can plant seeds so that later on in life they can express themselves in a certain way right from the time they are formed, when they are still very young. And then finally, yes, it is true that doing away with certain symbols does mean a lot in terms of even the symbols that they replace or they represent. I will talk of the gowns themselves. Of course, the gowns originated from religions and then went to judges because you could not differentiate between the two. And it is true that these symbols do mean a lot, because if you put on a symbol and a gown and I'm beginning to forget these things because we didn't have them in East African community, and a wig, then your mindset certainly moves towards citing the cases that Dr. Kavumba was telling us when you're dealing with a case in Karamoja. So that is part of the issue. But I've seen in those countries where these traditions have come from, they've actually discarded most of these traditions. When you go to the New Zealand, for example, they also do have these open kind of courts where when you're inside as a judge, you cannot see someone outside because of course, you don't want distractions from people who are on the bench. But when you're outside, you can see what is happening in the court, depicting, of course, transparency of the judiciary. And then the bench has been lowered to the extent that they're on the same level as the litigants in order to show that the judges are serving the community. So these are some of the symbols which you have to look into and see whether they mean a lot and change them, but at the same time in that move of changing the mindset of what we do have. I have a lot of issues, but I do think some of them I'm going to present them during the panel session that I'll be on. But I wanted to understand some of these concepts and how we loosely refer to them, yet when you go deeper into their context, those concepts don't even exist. But finally, when I came in, there was also the question on the ranking of being on democracy and how Rwanda is ranked poorly. Well, that does not shock me. It's normal. I'm getting used to it. But what deeply shocks me in these indexes, and we've discussed this with Eusta, there's one where Rwanda was ranked very high in terms of fight against corruption in all institutions, including courts. And Rwanda was at the same time ranked very high in terms of confidence of citizens towards the institutions, the governance institutions, including courts. I don't want to put percentages so that I'm not wrong. And then when it came to the independence of the judiciary, where corruption is deemed to be low by that ranking, and the trust is high, when it came to the independence of the judiciary, I think Rwanda was ranked at 31%. Then it led me to look at other countries in the same structure where, and I don't want to name this country, this is one of the baggages of being a minister. You have to be diplomatic. But in this particular country, the ranking in terms of corruption was very low at 20%. And then the confidence of citizens in the institutions, including courts, was at around about 25%. But the independence of the judiciary was at 70-something%. And I had an opportunity of meeting one of the people who run these indexes. And I asked them, in Africa, what is the biggest challenge to independence of the judiciary? And then he told me lack of trust of institutions and corruption. So that shocked me more than in democracy, but let me rest it at that. So we should take these rankings with a pinch of salt. Thank you so much.
Thank you, sir, for that intervention. I now invite the panelists to respond to the questions and make comments, but in the interest of time, in a word or two, please make your conclusive remarks. So I will start with Dr. Buref and then Dr. Kabumba and end with the Prosecutor General.
Thank you very much. For me, the problem, as I said earlier, is the fact that we have made to believe that everything we do, we should explain it in the concepts they understand. So if we're talking about governance, to be in the club of good guys, we should say we are a democratic society. So I think that is unfair. Because if for me, I prefer to use Fukuyama's definition of justice, of governance, as the ability of a state to provide services and keep law and order. So you can achieve that through different forms of governance, including democracy, in my view. And I think that was an interesting analysis of the way the industries are corrupt. Maybe you could say the judicial system in that particular country is independent in its decision-making, of which those decisions might be corrupt, and people might not trust the judicial decisions, but still that judicial decisions are independent in corrupt behaviors and mistrust.
Thank you very much, both to the students from ILPD, but also the colleagues, Dr. Yusta and the Honorable Minister. I'd like to associate myself with the comments by the Honorable Minister. I think he has made my job easier about symbols. I just add one comment. The symbols are powerful, and words also are powerful. Words matter, and they two go hand in hand. For instance, when we address judges, we say, "My Lord." Now, that immediately creates distance. It puts someone up, and you're down. But it also harkens back to the feudal times, where the judge also happened to be from the class of the landed gentry. So it's language that ties us in terms of the present to a very particular past. And one of the ways of decolonizing the mind is by decolonizing speech, decolonizing symbolism, architecture, etc. So in just the interest of time, I'll sort of leave it there at that point. But I also take Dr. Yusas's point about the dilemma then of men in ties, this talking about decolonization. It's a fair point. One of my favorite poems is that by Gabriel Okara. It's called Piano and Drums. He eventually died in the Biafran Civil War. But that poem is for me important because it talks about where we find ourselves. He talks about a person who is listening to a piano and he's talking about the concerto and he's attracted by that music. But at the same time, he's attracted by the beat of the drum. And we are in that identity as Africans. I think all of us in this room. We have, in a sense, a dual identity belonging both to the so-called modernity, but at the same time being, in a sense, children and prisoners of where we come from. And I don't think it's necessarily choosing one or the other, but as you say, it's also about avoiding romanticization of the past. It wasn't a beautiful time where women were being killed, for instance, for getting pregnant before marriage. But without romanticizing the past, I suspect there might be a way of finding equilibrium between getting the best from that but also, and goes back to the dilemma about, I think you talked about the student talking about reconciling modernity and also taking the best from the past. The freedom of expression, I think it's my colleagues who use those terms, so I will leave them with the burden of dealing with those expressions. I just remember one of the past presidents of Uganda, Idi Amin, is said to have said that I can guarantee you freedom of expression, but not necessarily freedom after expression. Which leads me to my last point. And it's a bit of a controversial point. That actually, and it goes back from what we talked about the question of values. And I don't know, maybe one of the students here can take up the challenge. One of the things I've been thinking about is the notion of the right to bad governance. One of the justifications of colonialism was the 3 C's: Christianity, commerce, and civilization. And incidentally, in the 1902 Order in Council, I think it was Article 12, that was creating bad governance here, creating a dictator, giving the governor powers to make law without parliament. He was given that power, and it was ostensibly to make laws for the good governance of the protectorate. The irony, you're creating a dictator and saying the dictator is going to make law for good governance. And those phrases, peace, order, and good governance, the so-called POGG clauses, were all over Africa and elsewhere in the colonial establishment. So in fact, colonialism was ostensibly enacted on the basis that we needed good governance. So I suspect one of the ways of ensuring and protecting self-determination is by ensuring or advocating for a right to bad governance. In other words, a right to mismanage yourself thoroughly. Because ultimately, it may be a bad thing, but I think it's better to mismanage yourself than someone to come from outside to manage you well. I'll leave it at that. Thank you very much.
Thank you. The interpretation of Western democracy towards Africa is how many Hutus and Tutsis occupying leadership position. That's their democracy. That's what they want in Africa. How many seats political organizations have in parliament, in cabinet, that's their definition, the Western democracy in Africa. But the democracy that we should have is a leadership serving the population, is building stable security, peace, and justice, is a leadership that can help Africans to live in cohesion despite their differences in background. Actually, even that Western democracy, they do interpret, when it comes to Africa, democracy in terms of presidential term limit. Our struggle is not about presidential term limits. Our struggle is about building a strong Africa, living in peace and a stable Africa. As the moderator requested us to make concluding remarks as I'm finishing, I would quote again our President of the Republic. What we need as Africans is fighting hard and working hard to be at the high table. Otherwise, we continue to be the menu. Thank you.
Thank you very much to our panelists, distinguished guests, ladies and gentlemen, dear participants. Permit me to bring to an end of what seems to be the beginning of these interesting panel discussions by our panelists and the questions from the audience. And as we close it, we have looked at the nexus between peace, justice, and security, and we believe we cannot have a sustainable justice. If we don't have sustainable justice, we cannot have long-lasting peace and security. So join me in giving another round of applause to our panelists who kept it interesting. Thank you once again.
Thank you very much. We have a new word from Dr. Murefu, womaning the position, so allow me to use it because he's a doctor and academic. So I thank Dr. Charity Wiwawara for very well womaning this panel. And shall we give her a good round of applause, please? We have come to the end of our first panel of the symposium. It's now time for lunch, and we are entering into our lunch time. We are 13 minutes late, and the afternoon session is extremely interesting with fantastic and able discussants, and one of them from Europe who will be joining us online. So I respectfully request you to be a little bit faster in having lunch so that we are here at exactly 2 p.m. Thank you very much, Honorable Minister, and bon appetit, everyone. This afternoon's panel is titled Social and Criminal Justice, Concerns and Prospects. The panel has highly distinguished individuals from international and national institutions, and it will be moderated by a competent lady, Ms. Fiona Muthoni Naringwa. Ms. Fiona Muthoni, please. You can move forward. Ms. Fiona Muthoni Naringwa is a Rwandan business journalist. She is currently a senior producer and an anchor at CNBC Africa. She holds a bachelor's in mass communication and journalism from the University of Rwanda. She is passionate about improving sustainable development outcomes in Africa, and her interests lie majorly in finance, technology, business, women and youth empowerment, climate change, and potential of the continent's creative economy. Ms. Fiona, please, you're welcome, and the panel is yours.
Thank you so much. Thank you for the warm welcome. Good afternoon, everyone. We are more than 5 people in the room. Good afternoon once again. Thank you so much. Welcome to the afternoon session. We are going to continue the conversations from the first session, and pretty much the discussions will still be on enhancing justice for sustainable peace and security here on the African continent. Many African countries face unending conflicts caused by many different things. And on this panel, we're going to unpack some of the main causes. We're also going to look at why social injustices have become a routine, what can we do differently, and what lessons can we draw from Rwanda. So help me welcome our amazing panelists, as I'll call them one by one as they come forward. I'll start with Professor Frederick Ogenga from Kenya. He's the director of the Center for Media, Democracy, Peace, and Security. A round of applause as he comes forward. Joining us, extreme end chair, Professor Frederick, if you could, yes, extreme end. Extreme end all the way. Yeah, you sit there so that we start with you. So hope you're ready with your presentation. Our next panelist will be joining us virtually. We'll have Professor Jürgen Stock, the Secretary General at Interpol. A round of applause. He's already here with us virtually. Good to have you, sir. We'll be coming to you in a few. Up next, we also have AIG Francis Guego from Interpol. He'll be joining us physically. A round of applause as he comes forward. We're also delighted to have with us Honorable Dr. Emmanuel Ugirashebuja, Rwanda's Minister of Justice. A round of applause as he comes forward. I think from the morning's discussions, we are all eager for him to continue unpacking more. We also are very delighted to have a DCG, Felix Namuhoranye, the Inspector General of the Rwanda National Police. A round of applause. Now, to start this session, we're going to start with presentations from our different distinguished speakers, and then right after, we'll also open the floor to questions. For now, we're going to start with Professor Frederick. If you could kindly get ready, come forward and present to us your presentation, and he will be taking us through social injustices, exploring connections with conflict here in Africa.
Thank you. Thank you, colleagues. All protocols observed. I would like to thank the National Police College for inviting me once again to come and give my presentation to this esteemed symposium. Well, I'll talk about the crisis of polycrisis in Africa. And by that I mean that Africa is experiencing a polycrisis, a crisis of polycrisis. So what do I mean? Polycrisis is actually a situation where multiple crises are happening at the same time. And these crises are things that are common to us. Some of them are climate change, COVID-19, the war in Ukraine that has led to grain shortages in many countries in Africa, artificial intelligence and the implications, forced migration and displacement, and very bleak and uncertain future. You might want to narrow down that in Africa, but it's a global problem. But then, within the crisis of polycrisis, I'd want to isolate one crisis, which is the crisis of democracy and governance. And that kind of crisis open up pressure points and cracks that lead to the emergence of conflict. So we have democratic deficits that has been visited upon us by issues of poor governance, corruption, marginalization, ethnic politics, economic exclusion, and politics of power and plunder. You can underline that, politics of power and plunder. This one manifests itself in terms of governance. I wouldn't want to go back to the man in the bush political sociology 101, where man was very insecure, and in return for that security, he entered into a social contract with what we know as the state today, the modern state. Forget about the Westphalian state with the expansionist ambitions. Just the state and the idea that the state is supposed to guarantee that man security. The state has increasingly failed to do that. So we have seen an increasing loss of social legitimacy when it comes to institutions of governance, and you have also seen lack of public trust in those institutions of governance. Now, there's something else that has come to exacerbate the problem, which is now why we say there's also a crisis of artificial intelligence, social media, algorithms, and what have you. So this has made the problem worse. But then, what kind of solutions do we want to prescribe for Africa? And what can we argue as scholars regarding what we call African democracy? So because there are two issues. There's democracy in Africa, and there's African democracy. So when you talk about polycrisis, and the crisis of legitimacy of institutions, and the crisis of governance due to politics of power and plunder, we are referring to the fact that African societies are either democratic societies trying to transist, or democratic transition. So they are democratic states under transition, or they are democratic states that are trying to consolidate their democracy, or they are democratic states that are trying to experiment with a version of democracy that can manifest itself the African way. And this they do through what we call periodic elections. So in this argument, I want to make a case. I want to make a case for an African approach to systems of governance, without necessarily qualifying the fact that that system of governance must be neoliberal democracy. Because as we know it today, neoliberal democracy is being taken with a pinch of salt because it's increasingly failing. It has manufactured crises in many countries in Africa. And I'll tell you, look at Africa today. Kenya, for example, has not recovered from the ghost of 2022 election results. So they are still burdened. And if you go to Kenya today, you'll find post-election jitters, where people are demonstrating on and off. There is an aspect that is being cooked there where people want to come and have some bipartisan discussion, but they are meeting halfway then retreating. So they are not even sure of which approach that they should take in order to decide on how they want to govern themselves. So in the thesis, I want to propose that African societies must shy away from manifesting democracy the way it's being manifested elsewhere. So because democracy is not a one-size-fits-all. So we have two theoretical paradigms that defines how democracy manifests itself conventionally. One approach to that is called a minimalist approach to democracy. The minimalist approach to democracy is that approach that considers 4 to 5 things. 1, constitutionalism. 2, justice. 3, rule of law. 4, periodic elections. 5, a robust civil society. Do you see signs of that in Rwanda, if I ask you? Are there those signs? Well, those signs are there. That is the minimal approach to. So if you attain that minimum as a country, then you will be celebrated as a democratic country that is transitioning to democratic manifestation and democratic consolidation. So African countries are somewhere transiting. But then, the reason why they cannot reach a level of democratic installation and consolidation is because there's an obstacle that is there. Because the assumption has been, if you want to go back to the United Nations Agenda for Peace in 1998, that was 89, that was actually conceptualized by Boutros Ghali, where he argued that the more democratic societies are, the more peaceful they become. So there's this aspect of democratic peace building. Democratic societies allow people to freely express their will, they participate in issues pertaining to that country, and therefore they tolerate each other and are bound to be peaceful. That is the assumption. But then this assumption has watered down the standard of measure of democratic transition in many societies, not only in Africa, but also the rest of the world, which is defined through elections. We have seen controversies coming in the US about the last election that put Joe Biden into power, into office. In fact, Donald Trump was contesting those elections. They were saying they were rigged, and they were surprised as Africans. So election could also be rigged in America. So Africans, therefore, should not be blamed for rigged elections. So that measure of democracy is not enough. Where democracy in Africa is defined through how you can peacefully transit power transition. So in Kenya, for example, if we managed to go through an election without fighting, and it was peaceful, free, and fair, then we now argue that Kenya is democratic. That is the wrong turn. Kenya, in fact, if you ask any ordinary Kenyan today, they'll tell you that they have a problem with the kind of democracy that they are seeing manifesting in Kenya today. And I'll tell you why. The emergence of the necessity to use election as a measure of democratic transition has enabled other things to come on board. One of those things is sophisticated elections. Sophisticated elections are those elections that are defined through electronic electronic electoral management systems. And what electoral management systems are, they are just technology. And this technology are things that can be programmed. You know, voter identification, voter verification, vote tallying, and consolidation and tabulation of those marks. These things have been problematic because they've led to two things. One, they've led to the idea that machines have now replaced voters. Your right to vote has been given to a machine, and you have surrendered it. Just like that man in the state of nature surrendered his power in exchange for security. We are now surrendering our right to vote at the mercy of electronic machines on the assumption that these things are more effective, more efficient, and more sophisticated. But again, they are taking us back because we have seen technology being used, but election taking more time than is expected to deliver on results. And somewhere in between, the tallying stops, and people go back manual to start counting manually, and then it results into a disputed elections. That disputed election leads us to the second problematic area, which is the judicialization of politics and politicization of the judiciary. So this case will lead to a crisis where people will go out in the street to demonstrate that their victory is stolen, and they'll be told, constitutionalism. We are living in a democracy. Remember those things I touched, the 5 things: constitutionalism, rule of law, human rights, justice, robust civil society. They'll tell you if you're unhappy with those results, go to the court. Then there's the Supreme Court. We don't want to preempt, we don't want to argue that the Supreme Court is actually bribed, but we want to assume that the Supreme Court is a clean court until the court brings back a hot air judgment based on what we call rules of natural justice. You know, rules of natural justice say that a good man, an ordinary man who is good, who is going about his duty, should be treated carefully and as a good citizen. And you should do to him what you think should be done to you. That is an average man. But the rule of natural justice will not allow Kenyans to accept, majority of them, to accept that really justice can be held regarding elections in the corridors of the Supreme Court. So when this thing goes to the Supreme Court now takes over the First Amendment. Supreme Courts become law in itself, going against Article 1, because Article 1 of the Kenyan Constitution says the people are supreme, and they exercise their supremacy either directly or indirectly through elected officials. So in other words, the Supreme Court is a product of the people. And if the Supreme Court is making an unpopular judgment, then it means in terms of social justice, the Supreme Court contributes in terms of saving the citizens. So I'm touching on critical institutions. And because I want to close this conversation with a way forward, where we can look at where do we go therefore for answers. So the electoral mechanism is broken. The Supreme Court is compromised and politicized, and therefore, what emerges out of that process is what we call populist, illiberal, authoritarian. And who is a populist, illiberal, authoritarian? You might have heard of the aspect of the rise of strong men and democratic illiberalism, which is actually the opposite of democratic liberalism. Democratic liberalism means these are popular leaders who masquerade as Democrats very well, with nice language, PR, but give them power. They become authoritarians who dictate things. They lead to the capture of separation of power, where they go and influence the voting decisions in parliament. And therefore, the representatives of the people through parliamentarians is also threatened by a leader who threatens his own parliamentarians. This is who a strong man is. And therefore, what you get from such a situation is not good for democracy, is not good for citizens. So what is the solution? In our book on institutional designs of democracy and peace building, published by Z Books, edited by Professor Abubakar Ba, you might want to use that reference, we are arguing about what we call institutional designs of democracy. And these institutional designs of democracy are not supposed to be nurtured in a vacuum. They are nurtured through Pan-African ideals. So what are these institutional designs of democracy the African way? Usually, when you look at liberal peace building and democratic institutionalism, there are some things that come to mind when you want to build countries out of conflict. We have things such as right to protect. You know, these are UN concepts. We have post-conflict reconstructions, and so on and so forth. But in Africa, we also do have designs, but some of those designs have not been allowed either through omission or commission to see the light of the day. And I'll give you some examples of those designs. These designs sometimes emerge from regional bodies that have been set up in Africa, such as SADC. And I'll give you an example of what SADC did in Southern Africa during the times when Zimbabwe was experiencing a lot of political and economic crisis in the reign of Robert Mugabe. I'll tell you that if you read literature about regional African RECs, regional mechanisms in dispute resolution, the role of SADC in Zimbabwe has been rubbished by scholarship. But then we have other scholars emerging who are African scholars with a Pan-African perspective who are arguing for the role of regional mechanisms in an aspect of conflict resolution called mediation. So they mediated, you all remember the SADC mediated government of national unity in Zimbabwe, which was inspired by what we call neoliberal solidarity, where Mbeki refused to listen to the whims of the West and treat Mugabe with kids' gloves, as it was being reported. So he was being told that, look, he was being soft on Mugabe, but what he was just employing is a Pan-African memory that reminded Africans, especially Zimbabweans, who share the same views or historical trajectory with South Africans, of the atrocities that were committed by white folks in Zimbabwe and South Africa. So for him, the idea of conflict resolution, the idea of finding a lasting solution to the problem in Zimbabwe would be to sit around with Mugabe and shake hands and negotiate and dialogue, the African way. So I'm introducing something here called the handshake. I know our president came here and said there will be no handshake in Kenya. Our president, Dr. William Ruto, came and I saw him on TV saying that there would be no handshake. And that is the problem. Because Ruto himself is a product of the handshake. And if I want to remind you that I'm using Kenya as a case because that is where things are hot now in terms of what you're arguing. If there was a serious crisis in 2007, 2008, this crisis was an electoral crisis, disputed elections. The old man, Odinga, has been stolen for elections ever since we know. And now it has become like, preaching to the choir when he says that his elections are stolen. But of course, the reality is that there is a problem. So my thesis is that, my question is that, could African countries, led by countries like Kenya, concede that post-election violence is part of democratic transition? Should we just accept and concede that yes, people have to fight in Kenya after every election? And since people have to fight in Kenya after every election, it becomes part and parcel of an institutional design. And we have to do something about it, because that's the reality. So if that is the case, because politics in Africa of elections are contentious because of the winner-takes-it-all mentality. And the winner-takes-it-all mentality is driven out of politics of power and plunder, where you want to get into power and redistribute and share resources for your own benefit. So you want to protect that. Then people fight after elections. So what we have seen and what we've witnessed is that after every disputed elections, we have two people who normally come and shake hands. In 2007-8, we saw Kofi Annan mediating, Raila Odinga and Mwai Kibaki shaking hands. And by the way, after that shaking of hands, Kenya really prospered. In fact, you could tell that Kenya was progressing. What they failed to do, they failed to instill or institute that institutional design into the Constitution in 2007. I mean, in the 2010 Constitution, post-2007 violence. Not because they didn't want, because some in Kenya we call them wakora. Wakora means some thugs, political thugs. When there was this bombers, there was a discussion in Naivasha about the Constitution, which was supposed to give them an opportunity to put some of these things in the Constitution. Then it was doctored by lieutenants of Mwai Kibaki, only for them to realize that they are receiving and passing a document that was not the real version of what was decided upon. That was a missed opportunity. Fast forward to 2013, 2017, another disputed election. That election was so disputed in such a way that one of those people in that chaos who was disputing or disagreeing with the idea of the handshake was William Ruto himself. And there is this belief that Kenyatta shook Raila's hand without the blessings of William Ruto. And he rebelled in that government. So he was an opposition leader within government. So I'm giving you some political perspective of the handshake. So then we saw violence subsiding, then Kenya going back into sanity, and then there was some level of governance and progress, and then you fast forward to 2022. 2022, Ruto competes Raila, and now there's another crisis. But Ruto has refused to embrace the handshake. But Raila has also refused to accept that he lost those elections. So as we're speaking today, there is a bipartisan bill that has been, there's a bill, a finance bill that has been, a very unpopular bill that has been passed in Parliament, and many people are not happy with it. I'm trying to remind you of the illiberal, popular illiberal authoritarian. Because what is happening, we are seeing members of Parliament voting against the wishes of the people. Yet these are the people who are supposed to represent us to please the executive. So the judiciary is captured by the executive, the legislature is captured by the executive, and therefore the people are left at the mercy of institutions that are malfunctioning. So can we still be talking about constitutionalism in minimalistic approaches to institutional designs? So let me take you to maximalist approaches to institutional designs. So maximalist approaches to institutional designs are those approaches that accept that we are Africans. If somebody gives you a goat in Africa, is that a bribe or a present? It depends on the context. So if you are living in a particular context and you want to build a house, you must design that house to the specifications of the geography, of the biology, of the mathematics around that area, so that you come up with some very resilient house. But in this case, we want to build a copy and paste house. And you have seen this copy and paste mentality doesn't work in Africa. So we are going beyond and saying, what else can we add on democratic democratic institutionalism so that we can make it work for Africa? There are very popular things that I will bring here. Africa peace-building mechanisms. We had them from the morning sessions, the Gachacha courts. This is actually an aspect of truth, justice, and reconciliation. Let me tell you the story of truth, justice, and reconciliation. The story of truth, justice, and reconciliation in Kenya is that report is gathering dust somewhere in government shelves. Nobody knows the truth. Nobody wants to reconcile. Yet that is a Pan-African approach that has worked elsewhere. We saw it working in South Africa.
Hopefully you're wrapping up soon.
Yes, I'm
and then
wrapping
we'll
up.
get into more details.
That time flew. I didn't know it in such a short time. Yeah, so we are seeing that kind of a problem in Africa. So we are arguing that if we can introduce some African aspects, negotiation, it's an African peace-building mechanism. Mediation is an African peace-building mechanism. Handshake, no changing it, not even sugarcoating it with anything, just the handshake. It's a magical African peace-building mechanism. Then there's bipartisan agreements. And then, of course, lastly, there's government of national unity. What do we have in Sudan? Southern Sudan. Do you have government of national unity there? We have a failing government of national unity. Because the military has also invested in the political economy. And therefore, the military is also there to protect. They've become politicians. And this one introduces something else, politicization of the military. So that military officers now become politicians, and politics is about the sharing and distribution of resources, so they come to share and tell you how to distribute those resources. If you come to intervene, they fight amongst themselves, because they are all power hungry. So if you have these designs somewhere instilled into constitutionalism, if we do not rubbish these designs the way our president was rubbishing handshake in Kenya, and by the way, I'll tell you here for free, there's a handshake coming in Kenya. I can tell you here, because you can bet at $1 million on that. Because there are no signs that the opposition is conceding on the win of William Ruto. And what they'll do, they'll create what is called politics of disorder. You make Kenya ungovernable. In other words, quoting from Notorious B.I.G., Notorious B.I.G., as I finished, said, if you don't have a lady, please don't shoot up the place. Because I'm seeing some babies, I'm seeing some ladies that should be having my babies. So Kenya, we're just seeing politicians who are going to shoot up the place so that it's a zero-sum game for everybody. They go back to the drawing board. And this drawing board would actually be nothing other than either negotiating, mediating, arbitrating, or shaking hands. And if you ask me, handshake works like magic.
Thank you so much, Professor Frederick. You've unpacked quite a lot. You were discussing social injustices, exploring connections with conflicts in Africa. You've challenged the Western democratic norms and also setting that Africa should define its own African democracy. We'll get into more on that later on. For now, we're going to get a presentation from Professor Dr. Jürgen Stock, the Secretary General of Interpol, and he'll be talking about transnational organized crimes in Africa, trends and policing interventions. The floor is yours, Professor.
Yes, thank you. Can you hear me loud and clear from Lyon?
Yes, we can.
Excellent. So thank you very much, Madam Moderator, for giving me the floor. Honorable Minister of Justice, esteemed Inspector General of the Rwanda National Police, distinguished Director of the Center for Media, Democracy, Peace and Security, ladies and gentlemen, it's a pleasure to be among you at such an esteemed gathering. Although, of course, I'm unfortunately not able to join you in person, let me start by thanking the Rwanda National Police for making it possible for me to share, at least remotely, some of my insights with the police leaders of tomorrow. Having been in charge of the Police Academy of the German Federal Criminal Police, the BKA, I know firsthand the immeasurable importance of curricula such as the Police Senior Command and Staff Course. They are much more than their academic value. They instill a passion for curiosity and lifelong learning that is fundamental in the growth of police officers. I'm also thrilled to see the symposium address criminal trends from a more transnational perspective. In Africa, and of course across the world, the threat landscape is constantly evolving. It's adapting and it's seizing all opportunities available. But above all, it is and remains global. A local incident, seizure, or investigation is often the tip of an iceberg cutting across continents. A case in point is the Interpol operational support teams that were into 3 different countries in West Africa at the request of national police, following record seizures of almost 8 tons of cocaine in total. This brought police from Africa, from other regions, and Interpol together at the scene, confirming how bold organized crime groups had become, stretching across South America, Europe, and the African continent. These incidents reminded us that Africa, like any other region, is facing threats that grew, evolved, and hardened through the COVID-19 pandemic. For instance, our Africa Cyber Threat Assessment showed how COVID-19 had accelerated cyber threats in Africa, from online frauds to digital extortion and, of course, business email compromise. This threat was at the core of Operation Jackal last year, a targeted strike against Black X Network and other criminal groups, which are rising actors in the cyber-enabled fraud landscape. We see these groups increasingly reaching global scope in their operations and victimization. Most of the chiefs of police I have been meeting report similar concerns. Cybercrime has become a priority threat to individuals, companies, and critical infrastructures across the regions. And as digitalization rapidly advances throughout Africa, building capacity to address cybercrime has become urgent. The launch of Interpol's African Joint Operation Against Cybercrime, thanks to more than €3 million committed by the United Kingdom, is a key to answer that need, from threat analysis to enhancing cyber resilience. Let me take this opportunity to recognize and congratulate Rwanda for the upcoming establishment of a regional cybercrime investigation center to further support collective efforts against this growing threat. But as we focus on cyberspace, let us not neglect kind of traditional criminal commodities still crossing our borders. Sadly, these continue to include innocent human beings. Human trafficking is becoming the most pervasive criminal market in Africa, affecting victims of any gender and all ages. We saw this when Sudanese authorities arrested Kidane Zekarias, kingpin of a kidnapping and smuggling ring active in East Africa, in January in coordination with Interpol, the United Arab Emirates, and the Netherlands. We also saw that terrorism did not pause from the Gulf of Guinea across the Sahel and to the shores of the Indian Ocean. Over the month of April, Interpol provided operational support alongside Afripol to frontline law enforcement across Central and Eastern Africa. 14 terrorist suspects were arrested as a result. 2 suspected members of Al-Shabaab, 4 suspected of links to Daesh activities in southern Africa, 1 with suspected ties to the 2022 Oicha bomb attack in the Democratic Republic of Congo, allegedly perpetrated by the ADF. Each of them is a reminder of the mosaic of threat actors evolving underneath the surface. In parallel, Interpol capabilities are being regularly deployed to support terrorism investigations, such as in North Africa to support investigations into terrorist exploitation of the internet, in West Africa to support the collection of biometric data of detained foreign terrorist fighters, and in the Horn of Africa to assist successful operations against Al-Shabaab. These investigations regularly remind us of the interplay between terrorism and organized crime, where revenue-generating criminal activities and violent extremism are 2 sides of the very same coin. Ladies and gentlemen, these are just some of the threats the continent is facing. And in the efforts to counter them, Interpol will always be at the side of African law enforcement and African officers. First and foremost, by providing tools and services to law enforcement, starting with the millions of records in our 19 global databases, and by connecting Africa with foreign counterparts and their intelligence via Interpol's I-24/7 network right from the front lines. Just as criminal networks grow across Africa, we are continuously working to expand access to these critical tools where they are most needed. Also, thanks to regional partners like the CEMAC, ECOWAS, and the East African Community. The more African law enforcement access and contribute to this global network, the more islands of information and links between criminal cases are being connected in Africa and, of course, across the world. This was the vision that police leaders across the region endorsed during Interpol's African Regional Conference just last summer. We must be able to mobilize the missing piece. Might be a name, a travel document number, or a fingerprint, wherever and whenever this may be needed to break a case on African soil and make a decisive difference. To arrest a known murder on the run at a border crossing, to identify a foreign terrorist fighter hiding under an alias, or to connect a suspect to an organized criminal syndicate preying on local economies and innocent people. Yet, if the goal is for information to flow across silos, coordination and synergy must be built at all levels, from local and national policing through regional efforts to global cross-regional cooperation via Interpol. A case in point is the close collaboration Interpol is building with Afripol. This collaboration may serve as a model of how regional policing bodies can work seamlessly within Interpol's global structure and, of course, without duplication. An example was Operation Flash IPA, jointly coordinated by Interpol and Afripol. Law enforcement and drug regulatory agencies from 20 African countries were brought together, leading to the identification of hundreds of suspects and seizures of more than 12 million illicit health products. The same is true with our work with the Regional Operational Center in Khartoum. We leveraged our respective strength through Operation WECA alongside other organizations to address the growing scourge of human trafficking and migrant smuggling. As a result, nearly 700 victims of human trafficking were rescued, with 300 arrests made across 44 countries. These figures highlight how we can pool our expertise to augment the value we collectively bring to national law enforcement. This is the same mindset that underpins Interpol's Global Academy Network that we launched in 2019. Through the Global Academy, we are able to bring together police institutions such as the National Police College of Rwanda and coordinate training resources and delivery, provide education for law enforcement, and conduct police-applied research. These partnerships will be pivotal to prepare the next generation of policing in the digital era. It is critical that we understand how the technological developments of today will shape the operational environment of tomorrow. Ladies and gentlemen, colleagues, 2023 marks Interpol's centenary. The world has changed enormously over the last 100 years. Yet one universal truth remains. Transnational crime thrives when law enforcement stops at the borders. Effectively enabling international police cooperation is nothing less than the single most effective tool we have to deprive them of that opportunity. To the police leaders of tomorrow, I hope that you can keep this message in mind and always seek avenues to engage with your foreign counterparts against those threats. This is why Interpol exists, and this is why Interpol will be at your side. Thank you very much for your kind attention.
A 100 years mark. On the panel with us, we also have AIG Francis Rwego. He is the special representative of Interpol to the African Union. I invite you, if you have some complimentary remarks to the presentation that has been done on transnational organized crimes in Africa, trends and policing interventions.
Thank you very much, moderator. Good afternoon, everyone. Protocol observed. Since the boss has talked, I'll be as brief as possible and touch maybe on some areas which are very particular to our region. Let me first thank the organizers for choosing such a kind of theme. You know, when you talk of such a kind of theme, it touches the hearts and minds of everyone. When you say peace, security, and justice, and maybe I could have added here development and not stop at that, because the foundation of all of this is a secure environment, and that's why we are going to talk about transnational organized crime. My boss has talked about it, an Interpol perspective, but allow me to start by saying, what is transnational organized crime? And it is a threat to Africa and globally. Transnational organized crime is referred to as a crime that has registration in more than one country, or an act which violates the laws of more than one country. It can also be defined as a conduct which jeopardizes the legally protected interest in more than one national jurisdiction and which is criminalized in at least one of the state's jurisdictions concerned. Otherwise, it cannot be transnational if it is not criminalized at least one of the states. In Africa, the major transnational organized crimes are terrorism, human trafficking and people smuggling, drug trafficking, trafficking in wildlife products, environmental crimes on land and water, purification of small arms and weapons, and cybercrime, which my boss has just pointed out. Any attempt to explain crime requires an examination of opportunities to commit the crime in question, of motives, and control options, plus the weaknesses. For instance, the profit motive is widely assumed to be the main or only reason behind cross-border crime. Yet political, religious, or ideological motivations can be equally important as a quantitative element. When you look at violent extremism as exhibited by Al-Shabaab or Boko Haram. Look at the current findings. Professor was talking about Kenya. In Malindi, Kenya, where we've seen more than 200 deaths attributed to a religious sect under the leadership of one Paul Mackenzie. Or if you recall in Uganda, in the year 2000, one Kibwetere, 200 people died in similar circumstances. And when we were investigating, he had written that the world is ending in the year 2000. So I had convinced the people that really, you have suffered on this earth. Do you also want to suffer in heaven? So come and join. And many people joined. So the African Union Agenda 2063 is a blueprint and a master plan for transforming Africa into a global powerhouse of the future. It is the continent's strategic framework that aims to deliver on its goal for an inclusive and a sustainable development in Africa. I think one of the discussants this morning touched on this Agenda 2063. So what is the role of police and other security agencies in the implementation of this agenda? This is to provide a secure and peaceful environment conducive for long-term investment, which in turn promotes development. Therefore, we need to seriously address the threat of transnational organized crime if this agenda has to be achieved. I recall one scholar in 2012, I was working in Nairobi, saying that if other factors don't come in play, countries are connected by crime, whether as a source, a conduit, or a target. Maybe this explains why is Uganda in DRC, why is Rwanda in Mozambique, why are we in Kenya and the like. It's because of what? Crime is connecting us. Because transnational organized crime affects the entire continent and globally. Let me touch briefly on the threat of terrorism. The overall threat of terrorism in Africa is increasing, not only the attacks and the victims going up, but the attacks are getting more sophisticated. You saw recently what happened to the Artemis forces in Somalia. Many terrorist groups are essentially operating as mafias. They use violence as a tactic for social control. In many failing or failed states, designated terror group has stepped up into offer state services. At times, what Al-Shabaab offers to the citizens there, to the people there, may be more. The services in the health, in the social sectors, may be what the government is offering. So this is seen, of course, in many of the failing states. When you look at Boko Haram in West Africa, the present terrorist groups have had an impact on cattle markets and therefore access to food. Terrorist groups are involved in this type of criminality to fund their activities, but also terrorize the local population. The Al-Qaeda in Northern Africa successfully forged alliances with the local tribes involving in smuggling activities. As a result, the organization has been able to profit from smuggling and trafficking activities between Maghreb countries and the Sahel region. The Al-Shabaab, many people have talked about it. I don't need to talk about the ADF in Eastern DRC and other groups you know very well which are operating there, which have really made that country ungovernable in Eastern DRC. Let's look at drug trafficking in Africa. The main drivers of drug trafficking in Africa are socio-economic factors, such as increase in trade and transportation, lack of alternative economic opportunities for the youth, corruption, weak investment, and high profit margins for criminal syndicates who nurture this trade. The major drugs being trafficked in Africa are cocaine, heroin, and synthetic and controlled drugs. Africa is no longer just a transit route for these other drugs, it is also a production and consumption center as well. Let's look briefly on human trafficking and the people smuggling. Though they are closely connected, trafficking human beings and people smuggling are a bit different. The difference lies in the end purpose and degree of consent of a transit victim or client. Human trafficking is the use of force, fraud, or coercion to obtain some type of labor or service from unwilling victims. It can also arise through a vulnerable person being duped into false promises of better education, employment, and well-being. People smuggling, as named the case, is the facilitation of the illegal entry of an individual into a country of which he or she is neither a citizen nor permanent resident. Now, the danger here, I don't know how much you know about people paying to be trafficked. The minimum is $3,000. Minimum. And this money is being paid to a criminal willingly that please enable me to get to America. They start from Ethiopia through Kenya, Tanzania, some die on the way through Malawi. If they survive Lake Malawi, then they enter into Zimbabwe, South Africa. They are harassed there and at times abandoned. It's a very big problem. Now, allow me to touch just one worrying thing. Perhaps the more worrying angle of trafficking person is trafficking for organ removal. And this is now very rampant in Africa, especially in North Africa. The principal driver of this illicit market is the unfortunate inability to supply human replacement organs following ethical, transparent practices to meet an ever-increasing demand. This kind of trafficking is the most lucrative, and victim donors receive very little or mere fraction of the total organ buyers are willing to pay. I think my boss talked enough on the issue of cybercrime. I will not repeat it, but allow me to touch on the threat of proliferation of small arms and adult weapons. Armed conflicts are supported by availability of firearms, some being illicit and others being illicit. The criminal misuse of firearms is a threat to the safety of citizens in all countries. It poses a wider threat to global security, peace, stability, and development. Instability in some parts of the Middle East led to proliferation of small arms in the Horn of Africa, and this is where Al-Shabaab is getting most of these arms. The collapse of Libya ably armed the criminal networks in the Maghreb and Sahel region. The situation in Sudan is something we must be worried of. Arms are going to trickle down through Sudan, to Kenya, to Ethiopia, they enter Uganda, they will reach here. That's what happened with the collapse of Libya. All arms, and now Sahel region, it's another story which we can discuss. So, what are the initiatives? Combating transnational organized crime needs improved knowledge and skills by countries to adapt to the challenges posed by globalization. Weak law enforcement agencies provide room for increased transnational organized crime that undermine a country's progress in peace and security. Training is therefore very key in addressing the threat of transnational organized crime. More so, joint training, as we are witnessing today, provides an added advantage as officers from different countries share own experiences and build a network. I think this is about my first time coming to this institution, and I must applaud the chiefs of police organization in Eastern Africa who designated this center as a center of excellence for capacity building and training. Criminals are well networked and supported by ease of communication and movement. They know no boundaries and also invest heavily in compromising border control systems. Law enforcement agents operate within sovereign boundaries, and this for a long time has been a hindrance in fighting transnational organized crime. I did a research on legal and ad hoc mechanism in conflict resolution, and I'm telling the truth, the morning we're talking about conflicts, the legal means, all what the professor has been saying, the legal means never resolve structural causes of conflict. They can only address the proximate. But when you go to the ad hoc means, the Matoput of northern Uganda, the Ubuntu, the Gachacha, those are the solutions. And I think we need to consider this. At continental level, also allow me to applaud the Eastern African Police Chiefs Cooperation Agreement, Organization, for the agreement signed in 2013. These are combating narcotics, combating terrorism, exchange of fugitives and extradition of sentenced criminals, and mutual assistance in combating crime. Many of you remember the 2010 bombings in Kampala. The planning and training was in Somalia. The final planning was in Kenya. The transportation of explosive involved a tourist vehicle from Arusha, Tanzania, and of course, the action was in Uganda. So, could we have dissolved that crime without involving all these? Now, when we came to investigation of this case, we have to use the legal means, extradition. You know what extradition means? Can even carry 6 years, 10 years on the neighbors. How do you have a police officer in Tanzania, police officer in Kenya come to testify in a court in Uganda? These agreements, especially the agreement, exchange of fugitives and extradition of sentenced criminals. Mark, the extraditions on sentenced criminals, we are not in a hurry. That person is already what? Sentenced, you can take your time. But a fugitive, this assisted us, fish all these people from law enforcement agencies came to testify, and we had one of the best cases in terrorism. One of the best cases, but because of these agreements and going the ad hoc way of resolving crime and criminality. On continental levels, my boss talked about establishment of AFRIPOL, but you also know the establishment of the Center for Study and Research on Terrorism. Recently, you know, I've been having a regional operations center in Khartoum for handling irregular migration on the northern route. This was supported by the European Union for obvious reasons, stop Africans going to Europe. But the assembly in 2019 says irregular migration in the continent, on the continents, not on the northern route alone, but involves the whole of Africa. That's why they say there must be a continental operation center. We're in the process of operationalizing this. Please, the students, be on the watch out, job opportunities on that center. The Interpol contribution, the SG has elaborated on it. I will not touch anything on that. It was very, very well elaborated. But allow me to say that the Interpol policing capabilities, expertise, tools, and systems for sharing crime intelligence through its secure global communication system is very, very vital in managing transnational organized crime. Through this system, notices, diffusions, alerts, modus operandi, and over 18 databases on crime and criminality are provided to all member states through the National Central Bureaus to utilize identification of crime, criminals, and investigation of cases. I thank you very much.
Thank you so much, G. Francis. Thank you for sharing the case studies on how organized crimes are evolving and accelerating beyond borders, and also highlighting that actually legal frameworks do not solve the root causes of the organized crimes, but also how can we integrate unique homegrown solutions for the different unique African markets. We are now going to invite Honorable Minister, who will also be sharing the presentation on continental and regional judicial mechanisms, interrogating their contribution to peace and stability in Africa.
Yes, thank you very much, moderator. And I've been asked to deal with the question, if I'm not wrong, continental and regional judicial mechanisms, interrogating their contribution to peace and stability in Africa. And I think if I had a very quick answer and then request me to sit down, I would say that if we talk about continental in terms of Africa and regional in terms of the regional blocks, then the court system or the judicial system are not designed in a manner that they contribute to peace and stability in Africa. So that will be the easy answer. But the truth is, once in a while, even though the courts are not designed in such a way that they deal with the question of peace and security, or they contribute to peace and stability in Africa, once in a while they stumble on cases accidentally which have an impact on peace and security, even though they were not designed to contribute to peace and stability. When you look at the regional treaties that establish the RECs, as well as the continental bodies, if you go to the section dealing with the judicial mechanisms, it wouldn't be far-fetched to conclude that that section was a midnight clause after everything else has been agreed, and then people remembered that we need a regional judicial mechanism. And then as a result, they just, because it's midnight after negotiations, they just pick one of the mechanisms that exists around and then provides for it in the treaties establishing the continental regional mechanisms. But that would have been the easy answer to say that they don't contribute. But let me concentrate on once in a while when these courts have stumbled on cases where they've, not by design, contributed to peace and stability in Africa. Let me begin by saying that courts in regional and continental level are structured within a given framework or objective of a given continental framework or a regional framework. An example is that of the African Union. When you look at African Union constitutive documents, treaties, the idea is that African Union is there to ensure or enhance peace and security amongst the member states of Africa, of the African Union. But when you look at the court, on the other hand, the only African court that we have deals with a very specific area, which is the human rights. So that's why we have the African Court on Human and People's Rights, to deal with individual rights. And even then, the way it's designed, one wonders whether it will ever effectively contribute to peace and stability, even within that particular area of human rights. Because when you look at the African Court on Human and People's Rights, there's a question of accessibility. In order to access the African Court of Human and People's Rights, you have to achieve two things. First of all, you have to exhaust your local remedies, meaning that you have to go through all the courts, the judicial system in your own country. But second of all, your country ought to have signed what you'd call a protocol, which allows direct access of individuals to the African Court of Human and People's Rights. I think down there, if you'll correct me, I think now there are about 6 or 5 countries in Africa which have signed that agreement to allow their countries to have direct access to the African Court of Human and People's Rights. So by design, it's difficult to see how it will effectively contribute to peace and stability. Then when you look at the question of how it's funded, the court itself, I don't know if any of you have gone to Arusha and visited the African Court. There is always there is an office for donors. Let me not name the donors. So a bigger percentage of the court's budget is funded by donors because the African countries don't fund these mechanisms. So whether the outcome of what they do is independent or not, the perception of it itself is a question, because justice is not only done, but it has to be perceived to be done. So if you have an office of a donor within the court funding a bigger portion of the budget of the court, then questions of independence of that particular court are brought to question. So that is the regional court that we have, the African Court on Human and People's Rights. What about the regional courts that we have? Let me talk about the East African Court of Justice, where I happen to have served as a president for 6.5 years. The East African Court of Justice is quite an interesting setting. And as I earlier pointed out before, when you want to look at the context of a given court, you have to also look at why a given REC was created. And there are 4 reasons or 4 fundamental imperatives for why countries decide to come together and form a continental bloc or a regional bloc. And the first imperative is affection, where countries love each other and they decide to come together and form a regional bloc. And this is characteristic of the SADC countries, because the SADC countries decided that they want to come together and form a body as a result of how liberation movements were created, right from Tanzania all the way to the southern part. And when you look at the preamble of the SADC Treaty, it's filled with a lot of words such as shared principles, our shared history, which is good, but it has a challenge because it will mean that no single country can oppose any other country objectively because they have this affection towards each other. And that's the reason when the SADC Court was created at the beginning, because the SADC Court was created. But as I said, it was a midnight clause. This was a borrowed framework from the European Court of Justice and introduced to the SADC REC. But when the court decided on a very sensitive case called the White Farmers case, a case from Zimbabwe, so the case was about white farmers whose farms were being, according to the case, confiscated. And once the court ruled that that action was contrary to the SADC Treaty, Zimbabwe, through the affectionate principle that they have in the SADC, moved the other countries to strike out the court. Of course, there were different ways of striking out the court. One was to just amend the treaty and do away with the section on the court. But they did it in a strategic manner, in the sense that they removed the direct access of citizens to the SADC court, and they made it an interstate court where only states can bring cases against another state. At the same time, I think they even refused to renew the contracts of the court. And for many years, I think up to now, I haven't been following the cases. Up to now, once the judges completed their term of office, no new judges were replaced. And you and I know that courts can only function if they have judges. But this is because the imperative of the creation of SADC was that shared vision of liberating each other. And the leaders knew each other right from the time when they were liberating each other. And no one wants to step on the toes of each other. So that's how SADC is created. When you come to the East African Court, the imperative towards the creation of the East African community is not affection, because all of us know that in 1977, the East African countries, the 3 original countries, disintegrated, the community disintegrated, and then it was revived later on. It's almost like a divorce and then you marry later on. There's certainly no affection. There must be something that led you to marry again, which is necessity. And I do believe that necessity is a much more stronger imperative, and it's reflected on the East African Court as an institution. Because East African Court also faced a similar turbulence. I'm going to explain this in a moment. But it did not go the way the SADC Court went. In the East African community, because it was necessity, when you look at the preamble of the treaty establishing the East African community, you can see a lot of distrust actually among the three original members. They refer to the former East African community, and they refer to how they should be able to resolve disputes in a more reasonable manner. When you look at the treaty preamble, that's what it largely provides for. And then they refer to the necessity as to why the East African community countries come together again in order to revive the East African community. And how is this reflected on the East African Court? And when the East African Court was established, yes, it was also what you call a midnight clause, because it's modeled according to the European Court of Justice, with one exception, that individuals have a direct access to the court without even exhausting the local remedies of the countries that you go to. So when the East African community was, the East African Court of Justice, when it was established in the treaty, the jurisdiction was quite broad at the beginning before its amendment. It provided that any natural or legal person of East African community can bring a case against any partner state of East African community, as long as you are a resident of one of the partner states of East African community. So what does this mean? It means that if we are traveling to one of the East African community countries for purposes of discussion, let's say Kenya, and then there's a breach of someone's rights, not my rights, then I can bring a case, even though it's not my rights which were breached, to the East African Court of Justice on the basis that there was a violation of the treaty. So the jurisdiction was quite broad, and it gave standing to any resident of East African community. This is important to note. It was not any any citizen. It is any resident of the East African community. Then the first case that the court treated, which was the Mwatela case, Mwatela was a member of parliament of the East African Legislative Assembly and was challenging certain decisions taken by the Secretariat. And of course, the partner states. And as a result, Mwatela was challenging certain decisions which had been taken almost 5 years before he challenged these particular decisions. And the court accepted that, yes, there was a breach, but most of the decisions had already been implemented, and the court can only annul the decisions prospectively. So Mwatela could bring the cases even after 5 years of the allegations of the breach. And then come forward, there was a very controversial case from Kenya, the famous Anyang' Nyong'o case, and you can see how different it was from the way the SADC court was disbanded. In the Anyang' Nyong'o case, Anyang' Nyong'o is, for those I can see young people, he's the father of Lupita Nyong'o. And he brought a case before the East African Court challenging the elections of the members of parliament of East African Legislative Assembly from Kenya. And in Kenya, what had happened, Article 5051 of the treaty provides that members of the East African Legislative Assembly are elected by national parliaments in the respective partner states. In Kenya, that particular treaty provision was interpreted to mean that political parties can sit together and divide the seats amongst themselves without going to parliament. So Anyang' Nyong'o challenged this before the East African Court of Justice. And the East African Court of Justice annulled the elections of the members of parliament in Kenya. And in effect, it paralyzed the workings of the IALA because it has to be constituted after all the elections have taken place. And of course, the leadership of Kenya was not happy with this decision. And my predecessor told me that he was in the meeting that was deciding whether to amend the treaty. And he told me one of the questions that he was asked as a president was, who do you think you are? We appoint you and then you make judgments which are contrary to why we appointed you. And there was a debate as to whether the court should be disbanded or removed from the treaty as one of the organs of the community. But because of the necessity that was the imperative of the creation of the EAC, there was a lot of distrust, and they believed that one day the court will be needed to deal with a dispute as had happened in 1977. So that's why the court was not disbanded. But some amendments were done to the court to make it a bit more ineffective to contribute to any peace and stability in the region. So the two amendments, one of them was to have an appellate division. Before this amendment, the court was a one-chambered court. So they introduced the court of an appellate division of the court. And the reason was that there was an expectation that in this Anyang' Nyong'o case, Kenya would be able to appeal to this court and probably win the case. But of course, that's not what happened, because after the creation of the court, of course, decided that the courts work in a prospective manner. They cannot deal with a case which had already been determined when the court was single without an appellate division. But another amendment which rendered the court not being able to contribute to peace and stability was the introduction of the 2 months limitation. So yes, individuals have standing, which is good. You can challenge any action of any partner state, but you have to do so within 2 months. So if you don't do it within 2 months, then you're time barred. So this was another amendment to the treaty, which led to the court not effectively deal with very serious cases. So this is broadly how these courts, you may argue, are not designed to contribute to any peace and stability in Africa. Rather, it's just a dispute settlement mechanism, most of the times borrowed from elsewhere, just because there is that view that you should have a dispute settlement mechanism. And then, as I said, once in a while, even though not designed to contribute to peace and stability, the courts have stumbled on certain cases which have indirectly contributed to peace and stability. For the African court, you may know that there was a case which was brought by the Banjul Commission, the African Commissioner for Human Rights, the famous Ogoni case. The Ogoni case was actually a case which dealt with the drilling of oil by Shell in Nigeria, and it affected the Ogoni community. So this case somehow found its way in the corridors of the court. And of course, the court made very interesting decisions that led to pressurizing Shell from continual drilling of petrol there, but of course, in a manner that affected the community there. And you may say that accidentally, it contributed to the peace and stability of the Ogoni land. Another case was the Ogieki case in Kenya. where a community, it's a community which lived in a place called the Mau Forest, and they were being evicted. It created a lot of commotion, and somehow it found its way, the dispute found its way in the African Court of Human and People's Rights, and the court decided that communities do have right to the ancestral lands, which in a way contributed to peace and stability in that particular community. Then when you look at the East African community, again, despite all these limitations, it has in a way indirectly contributed to peace and stability, especially in the area of justice. One case that comes to mind is one of the famous cases, the Katabazi case. Katabazi case from Uganda. Katabazi was someone who was being prosecuted for the crime of terrorism. And then he was released on bail by the court. Then he was immediately, actually I think he was rearrested in the court, not even outside the court. And Katabazi came to the East African court. His argument was that his breach of human rights in this sense, his denial of bail by a high court judge of Uganda, is in a way a breach of the treaty. Of course, just like we like doing the attorney generals, you argue a case very strongly. And the Attorney General of Uganda argued that when you look at Article 28 of the treaty establishing the East African community, the court was given very limited jurisdiction to interpret the treaty. But when you go further to Article 28, there is a clause that provides that the East African court shall deal with human rights when it's granted that jurisdiction. Actually, when the jurisdiction is extended at a particular time that will be granted by the Council of Ministers. So when you look at the Article 28, and this is the original treaty, the East African Court has no jurisdiction on human rights, and yet Katabazi case seemed to have human rights aspects. At the same time, in the same treaty, in Article 6, paragraph D, it provides that the East African Court is founded on the principles of good governance, rule of law, and respect of human rights in accordance with the African Charter of Human and People's Rights. So Katabazi came to court, and I don't know whether the advocate was Don there, because he brought a case in a very innovative manner. And the argument of Katabazi was, I do know that Article 27 does not give me a right to redress of my violation of human rights. But to the extent that the violation of human rights are also a breach of Article 6D, which is the fundamental principles on which the East African community is founded, then the East African Court of Justice cannot abdicate from that duty to deal with the case, not as a human rights case, but as a breach of the treaty, not as a breach of his human rights. And the court agreed with him. And it said, and this is where sometimes judges are very intelligent people, and the judges wrote in the judgment that if you ask us whether we have a human rights jurisdiction, then the answer is no. But to the extent that the breach of someone's human rights is also a violation of the treaty, then we cannot abdicate from the duty of dealing with that, not as a human rights violation, but as a breach of the treaty. And the court was careful in the way it crafted the judgment. And it crafted the judgment in such a way that it said the breach of Katabazi's human rights is a violation of the treaty, not a breach of Katabazi's case. Whether the outcome is different, I don't know. I'll leave it to the jury to decide. So accidentally, again, through this case, the court contributed to the strengthening of the justice sector in the region but not because it was designed to do so. Because when you look at Article 20 or 28 on the jurisdiction of the East African Court, it is actually quite expressed that it has no jurisdiction to deal with purely human rights cases. Then there was another case, and I will probably conclude on this because we don't have a lot of time. And this is the famous Serengeti case. For those of you who know Serengeti, Serengeti is a reserved place, national park, where there is the migration of animals from Tanzania to Kenya and sometimes back, the Great Migration as it's called. And it's considered to be a wonder of the world. Tanzania, for economical purposes, wanted to build a road inside the Serengeti Game Reserve. And science proved that the building of this road will have an impact on the migration of these animals. So an NGO from Kenya called the African Network for Animal Welfare brought a case on the basis that any legal or natural person can bring a case on any violation. It brought a case against Tanzania. This is a Kenyan NGO. And it challenged the building of the road by Tanzania on the basis, again, on the Article 6D, because you can only form jurisdiction on Article 6D because it's broad enough. And Tanzania argued that this is still an idea because they haven't even undertaken, Tanzania had not even undertaken an environmental impact assessment. And of course, when you look at the treaty wording, it says that you can only challenge the action of a state. But on such cases of environment which have an impact on peace and stability, when does breach of environment constitute an act of a state? Do you wait until the trees are cut and the road is constructed? So that was the dilemma that we were faced, at least at the appellate level where we sat, because I sat on this case. And this is where actually the PG you referred to, and the court said in very flowery language that when the judges don their gowns and leave their chambers to go to court, they do not leave their common sense in their chambers. They come with it to the court. And at the appellate level, the appellate level decided that, yes, we do agree that the treaty provides that it is an action of a state that you can challenge before the East African Court. But in these specific cases which deal with environment and which do have an impact on the stability of the region, then in those particular cases, you cannot define the action of a state in a similar manner to any other form of breach. So the court went through all forms of scenarios on how you can determine what would constitute an action of a state when it comes to environmental cases. And the court put parameters which, of course, don't appear in the treaty. And it said once you see a country starting to budget for a given project, to bid and all that, then it's no longer an idea. It has transited to being an action of a state, even though the construction of the road had not taken place. And but when you look at all that, Tanzania had not done any of those thresholds that the East African Court had, the appellate division had decided that would constitute a breach of the treaty. However, because the science showed that the construction of the road would have an adverse impact on the migration of the animals. The court did something which was quite interesting. It's a principle now which is being used in different courts. Again, resorting to Latin, it's in dubio pro natura, meaning that in case you have doubt, the doubt should be in favor of the environment. Normally, that's not what happens in civil cases, because in civil cases you look at the preponderance of the evidence. But in this case, the appellate division decided that yes, Tanzania, you have not reached the threshold of this being an action of a state. However, if you ever again consider to resuscitate this particular project in a similar manner as it's provided for, then you're still permanently injuncted from undertaking that project, even though it has not reached that particular level. So some people may refer to this as judicial activism, but one may differ to do so. But let me conclude by saying that when you look at the continental and regional judicial mechanisms, the way they are constructed, the way they are resourced, you would actually be widely optimistic to believe that they can effectively contribute to peace and stability in the region, because that's not what they were made for. Again, I say that it's a midnight clause. You remember that you do need a dispute settlement mechanism. And this can be, and this, the evidence to this is the way the AFCFTA, the African Continental Free Trade Area, was constructed. When you look at it, it's a free trade area, almost similar to how the European Union began as a free trade area. But when you look at the dispute settlement mechanism, it's copy and paste from WTO dispute settlement. Yet the WTO dispute settlement was meant to deal with dispute between states. It was not meant to create a worldwide free trade area. So this is why, again, I do think there was need to think deep on that particular area of dispute mechanism. But having said that, it's a good starting point. At least there, you can argue as to how it can be made better in order to answer to the questions of the AFCFTA. In conclusion, I would say that the main reason why the continental and regional judicial mechanisms do not contribute to the peace and stability is because of the way they are structured, the purpose or the reason within which the regs have given the role of the courts and the jurisdiction that the courts are given, but also the financing of the courts, because if half the budget of a court is shouldered by a development partner, then you can imagine how the outcome of it will be. Either the independence will be compromised, or even if it's not compromised, the perception of the independence of these courts is highly doubted.
Yeah. Honorable Minister,
thank you very much.
Thank you so much for your presentation. We'll have to cut you short.
Yes, I had actually completed my presentation. Thank you very much. Maybe more
Thank you. We'll do have more time when we open the floor to question and answers. So we're going to get our last presentation, but right after the last presentation, we'll open the floor to question and answers to give more people opportunity to ask. Help me welcome the IGP to give his presentation on community-based policing as an approach to crime prevention, Rwanda National Police Experience. A round of applause, please.
Thank you, moderator. I saw how many times you struggled to press the button because the minister was here, so it wasn't easy. So I want to clear you forget about these ranks. If you happen to want to stop me, please do. And I will obey, because I happen also to want to obey. And the minister did obey, because when you pressed the last one, he said, I'm done. Even before you said, please be done. And I remembered how many times he said, in conclusion. So you would wonder why I am here, member of this panel, because I don't also know why. But when you heard about the professor talking about potential for violence because of an existing architecture in one country or another, it means there is insecurity or potential for insecurity there. And when our friend Dr. Stock, thank you Dr. Stock for being here with us. I know the time it took and the sacrifice you made, together with his representative talking about crime and the transnational and cross-border nature of it. It means potential for insecurity. And the minister was talking all the way about cases. Case of. So these cases means something wrong happened somewhere. I almost wanted to leave out the case of Serengeti and the animals migration until I remember that if these animals were not to migrate from Tanzania to Kenya, they were probably going to migrate from Serengeti to villages in Tanzania and cause insecurity. But he talked about cases. So that's probably why I am here. Because all of that notwithstanding, people must be safe. So that's why they put me here. And they asked me to ensure that people are safe and to discuss a model that would prevent those insecurities, those crimes to happen. And this model is called community-based policing or community policing. And I'm going to go back into history, and I will avoid to use something that Arthur challenged before and others. Why aren't we using our own? Because if you were to trace community policing back in history, you run a risk of tracing it there. There, Arthur, there. It was with a person called Robert Peel, who was then UK Home Secretary. It was in 1829, when he talked about the police are the public and the public are the police. It was during the establishment of what is today known as London Metropolitan Police. So I won't refer to it again, but that's where it originates. So I tried to see if it can originate somewhere near. I couldn't find it, so I was careful not to look at it from somewhere else. But there are other models in our countries that we had to make our people safe, which also looked like community policing. Even if it is traced from back there, it is only for the last few decades that this model of policing is becoming increasingly dominant and ever present in the discourse of law enforcement. From purely a theoretical point of view, there is an agreement. There is an agreement that community policing is about partnership between the police, the law enforcement agencies, and the communities they serve. That agreement is there, theoretically. There is another agreement that community policing or community-based policing is about trust. Trust between the police, the law enforcement agencies, the security organs, and the communities they serve. That agreement theoretically is also there. There is a last agreement that's the partnership and the trust between those two poles is a partnership in problem solving. It is the involvement of both the public and the police in problem solving. And it's not about solving any other problem, it's solving security-related or insecurity-related problems for that matter. It's about problem solving of crime. So this approach, this model is based on the premise that law enforcement agencies, security organs, police cannot effectively prevent and solve crime without the cooperation and support of the communities they serve. That is the baseline. And that is the theoretical understanding. But when you come to the practical part of it, now each police force, each police service, each law enforcement agency will tailor-make its policing model, its community policing model, according to its own context, its own culture, its own socio-economic, geographic context. That's where differences start from when you are applying community policing model to prevent crime. And it depends on each country's focus, whether it's the political context or socioeconomic context or the cultural, that will dictate which policing, economic policing model we use. But all in all, and all of those differences in implementation notwithstanding, community policing is widely and globally accepted in the realm of law enforcement as an effective approach to crime prevention. And the goal of contemporary law enforcement, contemporary policing, is prevent crime. It's not just catch criminals. Because if you focus on catching criminals, then the damage will have been made. You are still catching criminals, but crime has been committed. So the focus in modern, in contemporary law enforcement is more about ensuring that crime does not take place in the first place. So we must structure ourselves to ensure that we actually have low rate of crimes, low arrest rates, not more arrests. Of course, if crime has been committed, you must arrest. But you will be judged on how less you have arrested, not because you have failed to arrest, but because there is low rate of crime. And in our case in Rwanda, we are no exception in the use of community policing model, especially given our post-genocide policing landscape. And this is a situation that's warranted that we do a shift in the policing model of the traditional systems. And this was not only the right thing to do, but also we had to do it because the previous model of policing, the previous law enforcement agencies were actually used in committing the genocide. So we had to change the policing model and embrace a community policing approach, but we had also to do away with a number of major shortcomings. I'm going to mention three major shortcomings in the previous policing model. Aggressive policing, which is mainly characterized by excessive use of force. You ensure security by force. You ensure that people comply whether they like it or not. So that is a dehumanizing approach to policing. So we had to go away with that model. We had to go away with unnecessary social distancing between ourselves and the very communities we were to serve. The further away these communities were from us, the less likely these communities were to make, or the less likely we are to make use of those communities in ensuring their safety and security. Crime is committed inside the community, and it is committed by a member of the community, and it affects the community. It would be bizarre to look for a model that will deal with crime, with insecurity, without involving that community. So, even from that understanding, it became clear that the community policing model will be theoretically and practically effective. So we had to do away with another thing called reactive policing. That means catching criminals. That means intervening where crime has taken place. So we had to focus on actually patrolling, doing internal security things that would make us less intervene, but make us more prevent. So reactive policing was no longer a focus. So we had to do away with those three key or major shortcomings: aggressive policing, use of force, unnecessary social distancing, and reactive policing. And today, I can tell you with comfort that Rwanda National Police has gained quite an experience in our tailor-made community policing approach to crime prevention. And some of the major achievements with regard to the use of community policing include, but they are not limited to, the fact that we have created and sustained functional community policing structures and platforms. These include community policing committees across the country, anti-crime clubs. We currently have more than 2,000 anti-crime clubs, and mainly in secondary schools. These are anti-drug clubs and many different crime clubs. And you can imagine young people, young students being members of anti-crime clubs. You are in a way telling them that if you are a member of an anti-drug club, you aren't supposed to take drugs. Actually, you are supposed to fight against the use of drugs. So it's a preventive way of telling these young students that you are part of those preventing crime, preventing use of drug, than a potential user of that. Another good scheme that we have in the domain of community policing is a scheme we call youth volunteers in community policing. We currently have about 750,000 youth volunteers in community policing. This means that If you were to look, and we only ask them that if you, actually they commit to sacrifice about 1 hour a day to contribute to safety and security of their neighborhood in one way or another. If you have 750 young people committed to sacrifice 1 hour of their day, you only need to synchronize their contribution. That's the work that we do back in the office. And you will have at least 31,000 police officers every 1 hour of a day in the names of youth volunteers. You only need to know how to functionalize them. So you create a sense of security which is produced by members of communities using potential criminals in a way, because the youth is the potential recruits in the criminal pool. It's not at 65 that you start taking a drug, generally. It's at a certain age. It's not at 65 generally that you start doing domestic violence because you have been in the domestic environment for 40 years. So if you haven't done it, you are less likely to do it. So if you have 700 people who are naturally potential, but who are practically involved in ensuring that that thing doesn't happen, in a way you are preventing them to be involved in it, while they're actually preventing others also. So it's a double-edged game that we have done. So community policing using youth volunteers has worked. I can prove it to you. It has worked. And those who were with us in the recent fight or enforcement of COVID measures, we know how youth volunteers contributed to the enforcement of COVID measures, wearing of face masks, social distancing, hand washing. So those 30,000 youth volunteers in a small jacket called community policing youth volunteers, they were only doing 1 hour a day, and you have 750,000 the whole day. So those are 31,000 added police officers who are not paid, who are proud to contribute to security, but also who are not involved in insecurity in a way. So it has worked. We have schemes called Police Month, annual Police Month. These are ways of actually interacting with communities in their human security issues. Our contribution to their human insecurity is getting us closer to them and avoiding the other thing I told you about social distancing. Those in academic year would probably want to look at it from a distance decay perspective. Our annual Police Month is working because it is getting us closer to the communities. We've got security campaigns in the domain of hygiene and security, where different sectors, administrative sectors, imirenge, compete to be the best in ensuring that they have crime-free villages. So you compete for 1 year, that if you have more crime-free villages in your administrative sector, you'll be awarded. And we award them trophies, including vehicles. A vehicle you award to a sector. That's year of competition to become a crime-free village. The competition works. So you are a crime-free sector, and you are given a vehicle to actually strengthen your security operations. It's not a vehicle given to the police station, it's a vehicle given to Murenje. That's Murenje, that sector, it's written hygiene and security campaign, best performer. So they will still use this vehicle for security purposes. But they have competed to get that vehicle. So it's another double-edged game. So that thing has worked. We've got road safety campaigns, you know, this animal called Jiraya Mahoro. The architecture of it is, it's another animal seated here. So you have seen him on media fighting for Jiraya Mahoro. Thank you, Kabera, for that, for your fight. So, all of this has to do with involving communities, involving people, involving that partnership that I mentioned, to partner with the public to prevent what a member of the public would do. It's very effective. And lastly, there is something we have recently introduced that is proving us to be working, is something we call agents of change. Imboni Zimhinduka. You know these centers we call rehabilitation centers. There is one famous called Iwawa. These are delinquents that end up there in the rehabilitation centers, potential criminals. So it had become a vicious cycle where it's about crime, rehabilitation center, back to crime. Today, we are saying, why don't we join them in the center, start with them for the whole period they are in the center, make them compete to become agents of change when they come back, and we organize them in associations and other schemes and give them some little things to do, but in a competitive mood that they actually become agents of change. And you can imagine a hardcore criminal, a delinquent that had become a leader, a ring leader in their delinquents architecture where they used to be, coming back after rehabilitation, becoming an agent of change. He is naturally influential in his group. You only need to recognize him or her that you can actually contribute to crime prevention. It is working. So I only use those few examples, but in few words, community policing tailor-made to our model has yielded considerable results in supporting our continued effort towards ensuring that people in Rwanda are safe, involved, and reassured. This is evidenced, I'm done. This is evidenced not only by very well documented level of safety and security we have in the country, but also by the amount of trust and confidence the population of Rwanda has in law enforcement agencies, in the Rwanda National Police, in the Rwanda Defense Force, in the Rwanda Investigations Bureau. In these law enforcement agencies, Yusta will not disagree with me because she conducts rankings every year in the context of Rwanda governance scorecard. So Rwandans today are able to take their safety and security for granted. I will elaborate more during discussion. I thank you very much.
Thank you so much, IGP. We'll now go directly to the questions. We have unpacked quite a lot around different areas. We've talked about social injustices and looking at connections between that and conflict. We've looked at transnational organized crimes, continental and regional judiciary mechanisms, which in Honorable Minister's words, are not tailor-made for peace and stability here within the continent. So we'll look at what could be done differently. If we have any questions, kindly do raise your hand. Okay, we can see we have already 2 hands. We'll start with Arthur. Okay, we'll get 5 questions from this side and then 5 questions from this side. If we could have a microphone Protocol, if you could kindly help, hand the microphone here. Yeah, let's start with Arthur. Kindly keep it short.
I'll try to keep it short. You see, the beauty of such symposium is that you get an opportunity to dispel off some rumors that are always out there, especially out of in the outside world. IGP has given a very good account on the contribution of community policing and how it has, helped to secure or build a secure environment for us in Rwanda. But again, on an equal measure, you find that, and I think I had a chat some time back with one of the academics here. On equal measure, such an initiative will be criticized. That by involving the community in securing their communities, you are indirectly building a police state. That, for every village or every sector, there are people that are there to make sure that you are secure. But again, is that the best way? So some people in this world out there will translate it into, Rwanda is a police state. You can't do anything because, there's someone out there watching you. So, Mr. IGP, how would you address such criticism? My second question, and I think the chief of Interpol can also intervene here. I mean, crime has changed. Crime has, it's no more about, physical crime where someone comes and jumps into your home and robs you. The crime has become more sophisticated. It is a lot more, cyber-based. Do you foresee that in the very near future, your model of training will even change, from even teaching the basics of shooting a robber to instead training an army of police personnel that are sophisticated, in hacking or looking out for hackers, because the crime changes every day. It has become more of cybercrime. It has become more of, transnational crime. So how, in a nutshell, how does this inform your approach to training for the future? Thank you.
Bana?
Thank you so much for the opportunity to ask this question. IGP, I just wanted to ask you one question regarding following up on your presentation on community policing. We see a trend globally, including the country where you mentioned community policing originated, the UK. There's less trust in law enforcement. The police, specifically the London Metropolitan Police, has had scandals of late related to GBV. The US, we see excessive force. Within our region, we also continue to see that the credibility of the police and law enforcement has gone down, mostly because there are criminals within the law enforcement agencies. Is this a threat that you see? Thank you.
Thank you. Okay. And then we'll take the gentleman right after.
Thank you very much. I would like to hear your perception on non-reconciliatory mindset by courts or approaches on social and criminal justice. This is because in dispute resolution, the focus is on the dispute, whereas in reconciliation, the focus is on the relationship of parties or their reconciliation. Even going further, for dispute resolution approach, it is not harmoniously rendered. For example, if I give a practical example in the former ICTR, one judge was known to always dissent to the rendered decisions. So the judges tricked him and said it was a decision they wanted to render and they did not want any dissenting opinion. And they said this time we are going to take the wrong decision so that he dissents and then we come back to him. So they did that. They said, oh, they took the wrong decision and the judge said, I dissent. So they said, oh, you're actually right. Let's go to your opinion. And then the funny part is that he again said, oh, I dissent to it. So the reason I'm bringing this is my concern is that do we get relevant or tailor-made justice or that contributes to resolving conflict or that contributes to peace and security or not? Thank you very much.
Who would you like to answer your question, Charity?
The Minister of Justice and Professor Ojenga. Thank you.
Okay. We have a gentleman at the back, and then we'll also get a lady right at the back. Not him. There's another one who had raised his hand before him. Kindly stand. Remember to state your name, keep your question short, and who you're directing it to.
Good afternoon, ladies and gentlemen. I'm Junior Nelvi Kemanjong, student at the level at the Institute of Legal Practice and Development, and I'm from Cameroon. So my question is directed to Mr. Dr. Jorgen Scott. So irrespective of the measures put in place by the Interpol to combat cyber transnational crimes, we discover that transnational crime still thrives on a massive level. So I would like to know what are the challenges that Interpol has been facing in order to combat these transnational crimes, and equally, how successful have they been in tackling these crimes, and equally to ensure what more can be done in order to ensure that although the crime cannot be totally stopped, but regulated to a large extent. Thank you.
There's a lady at the back wearing a black blazer and a white top. Kindly stand.
Thank you so much. My name is Ngetike Solange Foncham. I'm from Cameroon. I'm a student at the Institute of Legal Practice and Development. My question is with regards the crisis status that Africa finds itself in, and in relation to the transnational crimes. The question is to enable me understand the concept of transnational crimes. Now, there are countries in Africa that are currently going through, we'll say, crisis. I would not want to use civil wars because, now they are going through serious internal crisis. And some of the instigators of this crisis, they are in foreign countries, they are in the diaspora, and they publish themselves saying things that instigate the crisis. I want to know if these statements that they make, they constitute a transnational crime, given that they cannot come back to Cameroon. Or, yeah.
Okay, thank you. I think we'll let the panelists respond to the questions before we can get more. We'll start by inviting Professor Stock to answer. We've had, I think, 3 questions come up. Did you take note of all of them? If you could kindly just take us through the answers.
Okay, thank you very much. And let me first of all repeat that I really regret not being in Musanze currently and being with you live on stage. A really very interesting discussion. My congratulations to my co-panelists, and also thank you for the excellent questions that were raised. I try to respond to them very briefly because they are all excellent and complex. In terms of the changes we are currently seeing in the criminal landscape, indeed, despite all efforts, despite all success stories in regards to international police cooperation, we definitely see organized crime groups, international cartels, name them as you like, becoming stronger. Stronger means that their criminal activities are conducted in a more sophisticated way, more complex, more international, and of course very, if I may say, very clever in exploiting gaps that we potentially leave in international police cooperation. So it's definitely a challenge. These criminal cartels are experienced. They have huge amounts of money available. They have very often the best lawyers. They have the capabilities and the technology that very often law enforcement is lacking around the world. So what are we doing in terms of responding to these kind of new threats? It concerns definitely our human resource strategies, and I think this was the first question. In regards to recruitment, we already see that the requirements for recruitments are changing all across the landscape. So the traditional picture of how a police officer should look like when I was joining the police some 40 years ago are now changing. So you do not any longer maybe require, let's say, the strong police person, whether it's a man or a woman, that can make arrests or any activity that requires physical strength. We now need a workforce that is operating, for instance, in the cyberspace, and that definitely requires different skills from the skills that were important when I was joining the police. So we need, for instance, the so-called digital immigrants who understand cyber environment much better than the older generation. So how do you investigate crime in cyberspace? How do you seize a Bitcoin? How do we deal with the problem of cryptocurrency that has been used by criminals? With all the legal challenges this is facing, and that definitely requires a different way of recruitment, more diverse teams within law enforcement. You still need the SWAT team, of course, but you also need people with different skills who are able, again, to conduct operations in the cyber environment. So a different way in recruitment, a different way in training police officers, but it's not only coming with challenges, it's also coming with opportunities for law enforcement. We try to exploit them, and I think I mentioned that in my presentation, by expanding our virtual network of police academies and police universities around the world. And we are proud having the academy in Musanze as one of the first members of our global police academy networks, where we are using opportunities to train police officers on Interpol capabilities remotely. We have been launching the first Interpol metaverse, so an environment which definitely in the near future will provide opportunities for police personnel to be trained internationally without leaving your police agency. So meeting your counterparts internationally without having the costs and the time-consuming traveling. So new opportunities on the one hand, but definitely challenges on the other hand. Very briefly, and I think that was the question from the gentleman from Cameroon. Indeed, as I said, organized crime groups are becoming stronger. Despite all the efforts, we are seeing that all across the world. And on the other hand, in regards to cybercrime, we are potentially almost at the beginning of a kind of, how could I call that? A kind of criminal revolution. We already have seen during COVID-19 how quickly criminals shifted their criminal business models to the new vulnerabilities that we have seen with COVID-19, how flexible they have been, scam schemes, business email compromise, and this is continuing. And as our societies are becoming increasingly interconnected, hyper-connected, this will provide unprecedented opportunities for criminals in the future to attack our systems. And of course, we need to tackle these types of crime, which are almost to a 100% international crime. So the IGP spoke about community-based crime. If I may say, what we are learning in criminology, 70% of the crime is conducted by criminals who were born, raised, live in the communities, and they are conducting their crime in the community. Yes, that portion of crime still exists, but the other portion of crime we have to deal with is definitely growing in a rapid pace, and that is international, transnational crime. Again, the various manifestations of organized crime, it's been discussed, and first and foremost, cybercrime. How do we conduct them? How do we tackle them efficiently? It's by recruiting those people who have the skills, young police officer We need a lot of young people who have much better understanding of the environment than my generation has. Those who can deal with the new challenges that come with cybercrime as a service, where let's say the model in which organized crime is organized themselves from historically, let's say, mafia type of crime, where people come from the same ethnic group, same community, are no longer operating, but they meet each other on a virtual platform based on nicknames. That requires a new level of crime. It requires partnership, first and foremost, with the private sector. This is where the information sits very often.
Professor Stock, we'll add you 1 more minute to just conclude on that point.
Okay, fine. 1 more minute is enough. We need to build new partnerships. So the community-based approach, the problem-oriented approach leads to the fact that we need to build more partnerships, particularly with the private sector. Again, we see some models around the world where now not only police officers and community members are working every day, but also members of IT security companies, big telecommunication providers, banking sector are sitting day to day, desk by desk with police officers, also to try to prevent crime from happening. And of course, at the end, coordination. Coordination nationally, coordination by regional bodies like Afripol, and at the end of the day, because most of these crimes are really of global nature, coordination by bodies like Interpol, and that makes Interpol more important than ever. And we thank the IGP and the Rwandan government, who are amongst the strongest supporters also of the global Interpol platform. That is how to tackle these types of crime in the future.
Thank you so much, Professor Stock. IGP, if you could also respond to some of the questions that came in.
Thank you, moderator. Involving communities to solve community issues versus being called police state, it is the other way around, Arthur. It is when we are heavily present in every corner as police officers that we become police state. It's not when a member of community is seen handling community issues that we are called police state. And those who would call us police state are proudly using this model, and probably that's why I decided to quote its origin. So it is probably, I didn't know where to ask that question, but I'm lucky that I quoted where it came from. So I would rather argue that if we were not, because these are not police officers involved in policing. These are members of communities involved in actually solving, problem solving. So whoever, and if you browse around and go into it, you are less likely going to find a lot of criticism about the model. We are all fighting on how to use this model better, not how not to use it. And that's why I said tailor-made use of this model depends on each context. I told you our context. No matter do we have criminals in law enforcement agencies? Jean was out, so I don't know how to answer this alone. Yes and no. You said we see things happening in the US. You saw things happening in the London metropolitan, and you saw things happening also here. So I said yes and no. Yes, because we recruit law enforcement officers from the society. So if you were to analyze whether criminals are members of law enforcement agencies, I would challenge you that we need to deal with the origin, the source of the problem. So that's why we use the other model I said, members of the communities solving problems in their communities, and hence we are likely to recruit from a society that is less, that's a big word. I remember that this session is live streamed, so I start being careful towards the end. But honestly speaking, that is the yes part. The no part is the fight you see as, and I'm using Rwanda as a case study, we have a big fight, daily fight against corruption within the force, and corruption is a crime. So I cannot, and you saw Ingabire here, and for this particular point, Ingabire I mean Immaculée, and she comes from Transparency International Rwanda. So I wouldn't say that there is no corruption in the law enforcement agencies, but I will say, to what extent are we fighting it? To what extent are we fighting our bad members? It's a big fight. And wherever you go inside ourselves, you will find behind ourselves members of ourselves. So that is the yes part. The no part is that the majority of our members are not criminals. Otherwise, Rwandans wouldn't be safe. The reason I told you that we started by saying that our vision is to ensure that Rwandans are safe, involved, and reassured. That's how we started. Today, we are comfortable telling you that we have told Rwandans to take their safety and security for granted. Thank you.
I think also IGP, part of our question was on the declining police credibility in other countries. Would you say that's the case here in Rwanda or no?
Oh, maybe Stock will say about the case in other countries, but in Rwanda, I can say it with confidence. In other countries, I can say it with care. Because I told you, each country tailor-make its way of doing policing. We live in a region that is not very safe. And I'm not going to mention countries, but we live around countries that are not entirely safe. Some of them are completely unsafe. So that's why I cannot say that it is the case everywhere, if it is not exactly the case around me. So if they have chosen to tailor-make their policing model using the traditional policing model of aggressive, of ensuring security by force. If you ensure security by force, security is not, you become insecurity. Because you are going to shoot at people so that they behave. You have become a source of insecurity. So, if you can see our surroundings being unsafe, it means that they have customized their model using another approach. But we also have very many countries that are successful around us and far beyond. So, depending on which country and which model I can answer, and with confidence I can answer about Rwanda. Thank you.
Okay, there was a question posed to Honorable Minister and Professor Ogenga. I think we can start with remarks from Honorable Minister.
Thank you very much. And I do think that Dr. Wiwawara wants me to reveal what happens in our chambers when judges are deciding on how to write judgments. Yes, it's true that depending on judges and depending on the collegiality of the court, some judges might wish to be characterized as dissenting judges. That's very true. Luckily, in the tradition of the court where I served, That was not the tradition. There was only one case where, and I still think it's the only case where the judges dissented. But even then, during the dissenting, it was 3 against 2. A case brought by Don Dare here, is here, seated here. And even then, because of the collegiality of the court, the way judges were close to each other, we decided to enrich each other's opinion. So the ones who were in the majority read the dissenting opinion and made it better as a dissenting opinion. And then the dissenters also made the majority judgment much better due to collegiality. Does dissenting opinion add any value? I would say yes and no at the same time. Because sometimes, depending on how the dissenter writes the dissenting opinion, it can be used against the objectives of a given court by the loser using the dissenting opinion to show that the majority is illegitimate. Does it add any value? Yes, some of it does add value because it extends the jurisprudence of the court, not on that particular case, but probably in future cases. Maybe the minority or that dissenting judge was the one who was right at that particular point in time. And it so happens, I do remember that when I read the International Court of Justice decisions, where one judge particularly sat, the late Judge Wera Mantri, before I read the majority, because he was also a dissenting judge, I always read his dissent before I read the majority because the dissent was much more edifying than the majority. But by and large, yes, dissenting opinions can lead to achieving the objectives of a given court. But of course, some other judges are just dissenters by nature. I do remember that, and I won't say which judge this is, who used to correct our drafts using a red pen. And when you asked him, he said, I was a professor to so many. And once a professor, always a professor to all of you. But we'll discuss the details after this because most of that is what. But it has its own importance in decision making. Okay. Thank you.
Thank you, Honorable Minister. Professor.
Actually, I think tailor-made justice, I would want to move beyond conventional notions of justice. And I would want to move to the realms of Solomonic wisdom. And I think when I move there, then you agree with me that questions of justice are also spiritual questions. And these are moral questions. And what we have seen is market-driven jurisprudence. Jurisprudence that is hell-bent to sustain particular power modalities, whether you want to look at it at the macro level of the global political ecology or the micro level of individual states or entities. So I think there should be a moment of reflection because we are moving towards slippery terrains where when you fail to get justice within the conventional wisdom, then you seek it elsewhere in the streets, and this is where we normally call the court of public opinion. So you tell me which one is more powerful. Is it the court in the institutions, our conventional judicial institutions, or the court of public opinion? I think the latter is more powerful, and if you agree that the latter is more powerful, it is this space that has been diluted. That's why I said the crisis of artificial intelligence. It has been diluted by a polluted information environment, whereby, and this is an example I'll give with Kenya, whereby any prudent jurisprudence that emerges out of these courts, once it gets out of the social media domain, then it gets another gear. it takes a different dimension. Because what then social media does, it is typically designed to amplify the shortfalls of just the gaps in that jurisprudence, the failures of that jurisprudence, the weaknesses of that jurisprudence. And what that does, it contributes to the erosion of public trust in those institutions as they are. And I think so, to me, it's more beyond the question of those institutions to the question of who is this in this institution. I mean, the world has been changed by individuals first before institutions. In fact, it is those individuals that have instituted institutions. And the list is endless, from people like Martin Luther, Mandela, and you can go on and on. So I think, to me, what matters is, because if people lose trust in themselves and the ability to get out of trouble, they become very insecure. And they seek what is called spiritual intervention. And the danger there is that if you have one con artist, maybe this evangelist, modern day evangelist who preach prosperity gospel, telling you that if you bring all your wealth to the church, avoid food and starve until you meet Jesus, then you'll find yourself with the Shakahola massacre that we are seeing in Kenya. To the extent that even those who are suspected and they are being tried in court are actually going on hunger strike in court. And they are being carried around to be taken, to be arraigned, so that the judge can listen to their story while they can't talk. Look at that situation. So it's a battle of the self. We have to relook at who we are, but we also need to revisit the notions of Africans, epistemic notions of who is an African. Humanity, Utu, Ubuntu, Harambe, and perhaps community, you call it what? Yes, community belonging, like a collective belonging. You are because other people are. And those notions will make us, even when one day we find ourselves sitting at the helms of power in the Supreme Court, we would be guided by the market and deliver hot air jurisprudence. We will be guided by Solomonic wisdom from the spiritual realms of metaphysics. Thank you very much.
Thank you, Professor. We're now going to take the last set of questions. We have already 3 hands at the back. We have we have 2 hands here. So we'll start with the 3 hands at the back, and then to him, and lastly him. Remember, keep it short. Do state your name and who you want to answer your question.
Thank you so much. My name is Isaac Odhiambo. I'm a student at the African Leadership University. The first question goes to the minister, and I just want to understand, what is it that governments are really afraid of in terms of strengthening regional courts? When you highlighted issues around funding, they find it very difficult to fund them. And when specific laws come that affect them, they find it easy to amend so that they are not affected. So I just want to understand, what is it that governments are really afraid of in terms of strengthening regional courts? The second question goes to Inspector General, and I'm very much pleased. I was just wondering if you can get a seminar or a symposium around community policing where we can invite all Inspector Generals across the African continent to be able to learn how Rwanda have actually managed to do with community policing. I just wanted to draw one attention to you. I've stayed in Rwanda for about 3 years now, and recently I just saw a message on WhatsApp, and one of my colleagues was saying, have you noticed that there is an increase in crime in Kigali? And one of our colleagues also responded saying that the police are actually handling that. The first question that I want to understand, how often or regularly do you publish reports around crimes, specifically on reduction, and how reliable is that specific data in terms of guiding the measures that the police actually take in terms of crime prevention? And the second question that I would want to get, are there other incentives that the young people are getting specifically, especially with now there's an increase in terms of high life expectancy, the cost of living is very high. Are there other incentives that you're giving to the young people for them to continuously engage in terms of community policing? Thank you.
Thank you, Isaac. Due to time constraints, kindly let's limit to one question.
Yeah, thank you. Good afternoon. My name is Ali Nobomutijima. I am a Rwandan citizen and a student at the African Leadership University. I'll point my question to the Minister of Justice. I have a growing feeling that our court system has not been serving justice the right way. I say this because, and through our, I might call it an ineffective bail awarding system. I say this because I've seen a number of cases where people are held in court and prison for a long period of time. They end up getting released because no crimes have been found charged against them. And to me, that doesn't feel like any justice has been served, given someone has served, let's say, a year or two in jail without any charges against them. How would you characterize this problem? Is it little trust in the police to enforce the post-bail follow-ups once these people are released on bail? Is it an ineffective prosecution going on where they're not giving the right evidence on time, or is it judges that just want to keep people locked up? And
question
if it's
noted.
possible, if we could have maybe the Prosecutor General or REAP Secretary General give us any comments on the recent petition by Edward Morango to the Supreme Court and how they feel about it. Thank you.
Okay, thank you. If we could have the lady in red.
Good evening, everyone. My name is Frida.
I think I'm in red, but you also have red on your hair, but I think they meant me. Okay, thank you very much. My name's Francisca Mujawasi. I work as the Deputy Director at the Lome Odala Institute. My question is posed to the IGP. I'm amazed by the spirit of volunteerism in our country. There's a list of endless homegrown solutions. We can name community health workers, community policing, Bamudugudu, local administrators, Abunzi, Imboni Zumurjanga Church, and many more. So my question is, how has our country managed to achieve buy-in and helping communities to understand the urgency of issues, to voluntarily sacrifice and invest their time to solving issues even when they're not incentivized? Is it because people have less work to do, or they really understand the importance of their participation in becoming problem solvers? Today you mentioned that Rwanda has collected and established a group of 750,000 youth who invest 1 hour per day of their time to oversee crime, substituting that for gym, concerts, and many other things, or maybe their work. So I ask this question, not because I don't understand the importance of these models, but for the sake of replicability of these models. And could you also help to give us one example of quantifiable achievements of the introduction of the community-based policing model in how, for example, it has reduced crime levels? Thank you.
Thank you. We'll take that gentleman and okay, kindly stand. If we could have a microphone handed to him. Please remember to keep your comments extra short. We're running behind schedule.
Thank you so much. I'm called the Senior Superintendent Emmanuel Ndahiro. My question goes directed to Mr. Francis Irwego about to transnational organized crimes. considering the crime trend, the increasing crime trend across the continent, and based on the fact that the African Union Agenda 2063 is fostering the Africa we want, how do you see that the Africa is developing under development in the perspective of peace, security, and justice? Thank you.
Okay. Let's take a last comment from this gentleman. Kindly stand so that they can bring the microphone to you. Kindly stand, sir.
Do I have to? Thank you very much. My name is Goloba Mtevi. My question and comment is directed at the Inspector General of Police. I mean, to what extent does, or rather, let me start it the other way around. One of the biggest challenges with participatory approaches to anything, whether it's keeping law and order or development, is that there is something we call voluntarism fatigue. That time comes when volunteers actually get exhausted and they begin to slacken in their performance. And this may have something to do with them not being incentivized. Now, to what extent does the Rwanda National Police actually track how these voluntary mechanisms are evolving in terms of who is active and who is falling off the cliff? The second one is, if we take the example of the 750,000 youth who are doing voluntary work out there, I could see that one challenge is that these people do grow up and they leave. They go and get married, they go and find jobs. How do you replace them? Or how often do you replace them?
Thank you for the question. As we close this round of questioning, I've been told if we could have a microphone this side, kindly stand. If we could get the last intervention.
Thank you. Yeah, I'm Jude Kagoro, and I work at Bremen University in Germany. And I'm actually quite excited about what I'm learning today, because this has been a great classroom for me. I'm listening to wonderful presentations. And as a person who has done a lot of research on police, several police forces, including Rwanda National Police and specifically on community policing, I was really fascinated by the results of community policing in Rwanda. And what the IGP was actually saying is not theory, because I actually lived it through research that I was doing here. So I want actually to see if there's a connection or if there's a potential marriage between Interpol and how Interpol does its work and community policing. So this question will go to Dr. Stock and Mr. Rego, and also back to the IGP. Do we see possibilities of applying some of the community policing strategies in Interpol? That is going to both sides, the IGP and also Interpol. And then the other thing is that, well, when I was studying the Rwanda National Police, I realized that it has some unique perspectives that can actually be learned elsewhere, including Europe. So I don't know, like Dr. Stock sitting in Europe, does he see some possibilities of Interpol actually learning from Rwanda? Thank you.
Thank you, Dr. Jude. We'll start with the IGP. You have quite a number of questions coming your way.
Yes, if we can have a workshop or a symposium about community policing, yes. If we have to bring all IGPs in that symposium, I don't know, but I will look into it. I will play around some games and see how this can happen via other existing mechanisms. There are existing structures that we have. Mr. Wego mentioned about IAPCO, East African Police Chiefs Cooperation. Dr. Stock mentioned about AFRIPOR, Africa Police Chiefs, that is a branch of Interpol specific to Africa. And there is Interpol, so we have a lot of engagements. I will see how to apply for a slot in one of the meetings and transform it into a symposium. And Stock will organize a meeting sometime this year. He is here, so I'm committing him to give me a slot in our next Interpol meeting, and he has accepted, so. I don't know whether it was about a significant increase in crime in Kigali as opposed to increase in social media, increase in our ability to tell people to report crime. Because we have data of crime. At some point between February and March, there was that outcry, which outcry is not there today. You can ask me actually what we did for it to disappear. There are two things that's happened. I talked about rehabilitation centers. These people, we have different lines of operations to ensure that there is less or no crime in some places. One is to take criminals through crime justice up to Rwanda Investigations Bureau, prosecution, courts, and where it ends there in Rwanda Correctional Service. That's one chain. There is an understanding and an agreement here that is not the solution to take everybody through there. And it should be more of exception, catching people and taking them behind bars. Some of them are rehabilitatable. So before these people become hardcore criminals or are still in delinquency mood and growing into criminals and later into hardcore criminals, there is this thing we call rehabilitation centers. It's a homegrown solution here. So some of these people who are in between criminals and not criminals, so they are taken through a rehabilitation scheme where indication shows and evidence shows that you are involved in some drug transactions, but you have not reached the point of becoming a threat to the society. We don't want to take all of them to Rwanda Correctional Service through the chain, and we don't want to let all of them grow into that criminal trend. There is that Rwanda model. So when they are going through that training, that rehabilitation arrangement for 1 year, for 6 months, depending on the way they mature, they graduate. So when a good number of them graduate, the majority of them will have recovered and rehabilitated. another number of them will find themselves back into it. That's why I said that vicious cycle of crime, rehabilitation, back to crime. And when we introduced this thing we called Imboni Zimhinduka. So that's time between February and March and January, they had been a graduation. So when they graduate, a majority of them go back to their business, go back to school, go back to their families. There is a number of them which go into recidivism. So those now start growing into candidates for criminal investigations, for prosecution, for courts. So when we go into operations to look for them and rechannel them where they belong, that's the period where people will sense crime going up, but we don't allow it to go up indefinitely. That's why we can tell you that it went significantly down, and people are no longer talking about it as they did back in February and March. We do publish our data, and probably we need to tell you how we do it. First of all, I referred to Rwanda Governance Board. They publish every year in the Rwandan Governance Scorecard many things, including our relationship, the trust between police and the public, and how it grows or doesn't grow. Fortunately, it keeps growing. Transparency International, they are after us. They are our friends, but they are also after us. So I don't have to like them, but I like them. So whether I want to hide it or not, they will publish it. And whenever I publish something different from what they publish, the public tend to agree with them, as if I did hide something. So I'm careful not to be different from them so that I don't find myself on a defensive angle. So we do publish through government structures, through schemes that auditors, formally and informally, human rights commissions, but also our own publications. We do have annual publications on our websites. Please be free to visit and see how we increasingly decreased crime for the last 10 years. You will find it there. Incentives to, and this cross-cutted, many people who ask this question, do we give incentive to communities, to youth, for them to participate? Yes and no again. When I said their free time, actually I need to clarify how they do it. It's not a written 1 hour voluntary contribution. It's a silent agreement that every youth volunteer, remember, and I will answer across the board, Dr. Jude, Dr. Gorob, and the one who talked about incentives. And the last people who asked me these questions are Dr. Gorob and Dr. Jude, honestly. Because Gorob published a book on our behalf about this, so he knows it. Dr. Jude is publishing a book about this. He knows it. So I think they wanted to drill me so that I say it. So I will say what they know that I have to say. So these people, we don't pay them, yes? But there is something here in Rwanda that we all know, that people are involved. Those people who criticize about democracy here, I think they are misplaced. When you go into these schemes of inteko z'abaturage, something that happens every Tuesday, where people are gathered drilling their local leaders about some things. They are being involved in the problem solving of their communities. When we have gatherings after Umuganda, and people are drilling us, asking us questions, and we have to answer. If you don't answer or you divert, there is a next Umuganda anyway. You can only hide today, but how do we hide tomorrow? So there is that culture that has become mature here, that people are involved in one way or another. And it has become like natural behavior. I see it when we ask people to get involved in, like in COVID. We go on and we ask people that to behave in a manner. We don't meet a lot of resistance because people trust. So there are those who would misinterpret it as if we have dictated this. But my interpretation of this, why do we tell people to stay home during COVID? Because COVID is dangerously spreading and people stay home. Those who don't want to understand it positively will say, maybe you forced them to stay home. But we didn't stand outside their doors. We only informed them about the threat, and they understood. So my interpretation of it is more of trust than a forced behavior. So if they trust their leaders, if they trust their security organs, it's something that has grown and matured, and we have taken it for granted now. And when we misuse it, that's when we see how they behave now. So to me, the first incentive has to do with natural growth in trust of people's contribution in their well-being. Secondly, for the youth, yes, there is some level of incentive. When they come, they get involved, we put out there other existing schemes that they are likely to benefit from when these schemes are available. So these are graduates from universities who are in between university and job. These are students. These are unemployed people. It's a number of categories. So if you are telling me to recruit new police officers, and I get 2 people coming to register, I will give priority to a youth volunteer.
Yes. Thank you, IGP.
There is a last question. There is a last.
Okay, 1 minute.
Yes. Applying this thing to Interpol, this community policing thing to Interpol. Dr. Stock, please apply it to Interpol. It will work. So I wouldn't want to answer this. I would want to ask you to tell them that you will do it. So, Dr. Gorob, these people do leave youth volunteer scheme, but it's a natural trend. As young people grow and leave, very minor people grow and become young and join. So it's a natural trend. Thank you.
Okay, thank you, IGP. Dr. Stock, before we come to you, let's first hear from Honorable Minister and then AIG Francis, and we'll conclude with you. Remember, keep your remarks short, please. Honorable Minister.
Yeah, I'll do that. The first question is, what is it that governments are afraid of in terms of strengthening regional courts? As I earlier pointed out, it's not so much about what they're afraid of. It's probably that governments have not yet really discovered the importance of these regional courts, and probably they have other alternative means of resolving disputes such as diplomacy. Maybe it's still working. And we all do know that when countries come together to establish a given body, be it a court or any other body, they do it because they believe that that body can handle certain challenges better than the domestic bodies. So that is why even where there are regional courts, the principle of complementarity is also applied. So I don't know, because when you look at the way the courts are structured, at the very beginning they are not that different from other courts from other regions with similar objectives. But when you look at them deeply, the way they are structured and the jurisdiction that they are given, they probably don't come to answer the raison d'etre of that regional bloc. So that's a big challenge, and so it's necessity, as long as states have not discovered why these courts are important in resolving disputes, especially those between states, then these courts will not be strengthened. I'll give you an example. In the East African Court of Justice, the East African Court has, there are three entities that can bring cases before the court. Of course, I talked about individual, but the states can also bring cases against other states. But I will confirm that since the court was created, no state has brought a case against another state. Almost all cases have been brought by individuals, and yet it doesn't mean that probably the courts will not be better placed to do that. And then there was a question asked by Mutijima, very interesting questions. Let me begin by protecting the Prosecutor General and the Secretary General of RIB, because one of the questions that was asked is to comment on a petition which is already before the Supreme Court. We have a judge of the Supreme Court here, and he will confirm to me that you cannot comment on cases which are ongoing in courts, so that they won't have an answer to that, because the case is a live one, and when a case is live, you don't comment, because you risk to be told that you're interfering with the process. So this one, but if you want to get more information about this, you can always, because it's a case, I think, where the Attorney General is appearing on behalf of the government, because it's a constitutional case, you can look at the submission of the Attorney General, then you can understand what the government thinks about this, but we won't comment on this. In terms of solving cases and the idea of the bail, let me say that statistics do matter when you're answering these questions, but also context. When you look at the statistics of Rwanda, I don't know, maybe Prosecutor General will correct me, the number of inmates who are, there are those who are serving sentences and those who are provisionally detained. I can't remember the ones provisionally detained, whether it's at 15%, I can't remember. Almost 10%. 10% of those in prison. But try and look at statistics of other countries. Those who are provisionally detained vis-a-vis those who have been sentenced by the courts, the numbers are at 40 to 60%. So you can look at that. These are data which you find everywhere. But let me also talk about the context part of this question. First of all, I think earlier on the Prosecutor General talked about the perception of detention here in Rwanda, which is gradually being understood differently, that people can have their cases outside. But when we are advocating for certain positions in law, you also have to look at the context, because imagine where the citizens do have a feeling that if someone is not in detention, then they are released, they are not being pursued in justice. And then you risk a position where people end up not trusting the judiciary at times and deciding to take justice into their own hands. So that is one of the areas that you have to look at. But also the context of Rwanda broadly, when you look at some of the detentions which wouldn't become provisional detentions elsewhere, look at the geographical situation of Rwanda, a landlocked country, which borders some countries where there are porous borders. At times, the level of detention will be probably higher than, say, Mauritius, which is an island where even when you try to go and hire a car for driving, self-drive, they don't ask you any security because there's nowhere you take the car. It's an island. So these are some of the context you have to look into when you are making this judgment. So I will call upon you to look at this. But if you indulge me for 1 minute, there was this interesting debate about community policing that was raised by Arthur. Someone actually asked me this question some time back, not in my capacity as a minister, as to whether Rwanda is not a police state as a result of community policing. This particular individual was asking me this, the statistics in his country, and I won't name the country, you understand why. The statistics show that an individual is surveilled by cameras, police cameras, 3,000 times on average. One individual, when you go out of your house going to work, you'll be surveilled by cameras. I don't know whether I'm using the right terms, but 3,000 times. So this is the person who was asking why having a community policing is considered to be, is equated to being a police state. Yet, all of us, I do remember the first time when I joined the court, one of the drills that we were given was to be security conscious as judges, telling us not to use the same road at the same time, not to be consistent the time you go to, a lot of, yet I was being taught to be security conscious, and in a way being turned into a community police, and that was in another country. So I don't believe that making citizens conscious of their security through community policing is turning a country into a police state. Whatever that means, because I also don't know what that means.
Thank you, Honorable Minister, for also providing context.
Chair, before you go, I'm sure this panel is ending, but I wanted to give the entire audience some food for thought. Somebody mentioned something to do with cybercrime, and it's good the Interpol director is here. I would want to challenge you to look at what is happening with the chatbots. There's something called ChatGPT-4 that is capable of immortalizing human beings and is also capable of creating pseudo accounts that could be updating statuses based on algorithm programming. So it could be like if you're dead today, your online account, like your digital self, a replica of you will be available, updating photos, updating information, and unliasing and interrogating others. You tell me how we are supposed to solve those kinds of artificial intelligence cybercrimes.
Thank you, Professor. Before we come to Dr. Stock, there was a question that was posed to AIG Francis. Kindly, if you could respond to it in less than a minute, that would be great.
Thank you very much. I think it was from Ndahiro who was concerned about the increase in transnational organized crime. Yet the Agenda 2063 is talking of an inclusive, sustainable development. Yes, African Union is aware of this, and they are concerned, and they believe that to have an inclusive and sustainable development in Africa, there must be a strong, peaceful, and secure Africa. And that's why...
Could you move your microphone closer to you, kindly?
I was saying that African Union is quite aware of the challenges of increasing transnational organized crime, and in ensuring the success of the Agenda 2063, we must make sure that Africa is peaceful. If Africa is not peaceful, we cannot have sustainable development. And the African Union set up the following to ensure that that is achieved. There is a clear protocol on peace and security. It is followed by the African, if you call the African Peace and Security Architecture. We have got the Peace and Security Council. We have a Committee of Intelligence and Security Services of Africa, CISA, by Secretary General talked about AFRIPO, which is a continental operation mechanism for Africa. We have research on study and on counter-terrorism and terrorism. And of course, African Union also cooperates with organizations like Interpol and other agencies to ensure that capabilities that can make law enforcement agencies in Africa are enhanced and will resolve the issue of crime and criminality. So all these areas are put in place for ensuring that the success of this agenda. There are about 15 flagship programs under Agenda 2063. You remember, I think someone talked about the Continental Free Trade Area. We have the Protocol on Free Movement, right of establishment, and right of residence, and all of this will entail that our borders are secure, that the people manning them have got the right equipment, the right capabilities to distinguish between a wrongdoer and someone well-intentioned, and that's why Interpol capabilities are also very handy in this. So, in short, they are all mechanisms, they are all strategies the African Union has put in place to ensure a peaceful environment that will lead to the achievement of Agenda 2063. I thank you very much for that.
Thank you. Lastly, Dr. Stock, there is a lot that has been thrown your way. If you could kindly just touch on the different elements, and maybe we'll give you about 2 to 3 minutes.
That's not much, Madam Moderator, but I will do my best to not extend the time. But I want to start by referring to what Professor Ogenga said. I'm definitely a strong advocate of the community policing model, no doubt about that. But this model indeed was developed for a kind of physical world and not for the digital world. So we have to continue, or we have to further develop the model in terms of applying it to all the challenges we are facing in regards to the cyberspace. So scams, business email compromise, ransomware attacks, DDoS attacks, grooming, online child sexual exploitation, and so on and so on. And I mean, the topic of your symposium is peace, security, and justice. Some experts I've been talking to a couple of months ago have been saying the real game changer for all these topics will be artificial intelligence. So I would like to support what Professor Ogenga said. It's high time to consider discussing what the consequences will be, because the criminals are already there. They are already using artificial intelligence, and we need to be prepared also in law enforcement in regards to a kind of responsible use of these tools. Very briefly, in terms of application of the concept in Interpol, perhaps, I mean, you know, we are not serving the communities directly. We are serving our 195 member countries, but the principle of community policing are definitely also applied within Interpol. So we also need the trust of the general public, yeah, even the general public around the world, that should have a certain understanding of Interpol, hopefully from us, from our national police forces, from the member countries, and not from any videos or Hollywood productions. Secondly, we need the trust of our member countries police services. Only then they will use Interpol platform and they will share relevant information. We need to build partnerships. That is one of the principles of community policing, problem-oriented policing. You define a certain problem and you look who can contribute in fixing the problem. So we cannot do anything on our own. We need partnerships. We need our member countries engaged, hopefully many as active as Rwanda is. We need partnerships with the private sector. We need partnerships with NGOs, with all kinds of groups in our societies. And only then are we in a position to connect the islands of information. Only then are we in a position to receive the necessary information, to organize the necessary information exchange, to prevent terrorist attacks, to prevent organized crime activities, or to successfully investigate crime, money laundering, and all these issues we have not been discussing today. Can we learn from Africa? Can we learn from Rwanda? The answer definitely is yes, and we have already been doing that. I remember a visit a couple of years ago to one of your one-stop shops that is providing an excellent service to the communities in terms of domestic violence, for instance. We are applying the same principle that we have seen in Kigali in many of our cooperation frameworks that we are establishing here. And Rwanda is supporting us in many operations. I remember our Interpol General Assembly, where the World Law Enforcement Community gathered in Rwanda in 2015. East African Conference that was organized in Kigali, the East African Chiefs of Police Cooperation Framework that IGP mentioned, the organization of centers of excellence that serve a whole region. That is definitely a role model for the rest of the world, as the resources are scarce, and we need, of course, to benefit from each other's experience, because the problems are in all parts of the world exactly the same. We are all facing the same challenges, and insofar, Rwanda definitely serves as a kind of role model in sharing information, using our databases to protect your borders, and so on and so on. So many examples which I could also underline with concrete KPIs that we are using. But again, I finish at that line what Professor Ogenga said. The big game changer is already cybercrime, and we are only at the beginning of this development. ChatGPT, don't forget metaverse and other developments. That is something where we have to pay attention. This will be a game changer for all the elements of today's discussion. And again, the criminals are already there. We are already a little bit late. Technology is not waiting for us. Industry is not waiting for us. We know this is the two sides of the coin. It will provide a lot of opportunities for law enforcement, for successful investigation and prevention of crime, but it will provide unprecedented opportunities for criminals to attack our private systems, our critical infrastructure from any point in the world. And that will require a new business model also for international police cooperation. So there is a need definitely to continue that discussion. And I'm looking forward next time coming to Rwanda and continuing this discussion. And thank you very much for inviting Interpol to this important and very timely panel. Thank you.
Thank you so much, Dr. Stock. This was a very lauded conversation. We've seen we need to redefine African democracy, leveraging on partnerships, as Dr. Stock touched on during his last remarks. Also, building trust has become crucial, and also need to redefine our continental and regional justice systems. This is just some of the key talking points that have been highlighted here during the conversation today. I'd like to thank all of you for being patient and for contributing in this conversation. Due to time constraints, we won't get closing remarks from our esteemed panelists, but I'd like you to join me in thanking them for their contribution. Thank you all. And for those who did not get to ask a question, tomorrow we have also very fun and very engaging conversations that will be happening. And yeah, looking forward to engaging more tomorrow. Over to you, MC.
Thank you very much, Ms. Muthoni Naringwa. I think from the morning when the tone was set, and this afternoon after lunch, I think you agree with me that it was difficult to moderate this session, considering the personalities, the SG Interpol, Honorable Minister, the IGP, and everybody, the professor, I think we should give a big round of applause to Ms. Muthoni. I also agree that the discussion was really very interesting and should continue maybe the whole night, but we don't have a lot of time. However, tea is served outside, and some of the questions and clarifications can be made over tea. Unfortunately, we can't have tea virtually with Dr. Jagan, but I'm sure at the 4th floor or wherever you are at the building, you can access a coffee machine or something like that, such that we can continue in spirit. So thank you very much. I also agree that the issue of artificial intelligence and technology in general in policing is extremely pertinent and should have given much more time to discuss now or even yesterday. But if we look at the first panel tomorrow, the first topic to be discussed is about that. Unfortunately, it will be short, but I think I agree with my commandant here that the next symposium will be given quite an extensive time to discuss as far as policing and law enforcement is concerned. Thank you, Honorable Minister. Thank you, IGP. Thank you, Rwego. Thank you, Dr. Stock, and thank you, Professor Ojenga, for giving us an informative submissions and also contributions that will help in future policing and law enforcement. And have a good night, everybody, as we enjoy the tea.
Mu bihugu biri mu nzira y'amajyambere, impanuka ziri ku mwanya wa gatatu mu gutwara ubuzima bw'abantu, biterwa ahanini n'imikoreshereze mibi y'umuhanda. Ni muri urwo rwego, polisi y'u Rwanda ihora yibutsa abakoresha umuhanda kwitwararika no koroherana ibinyujije mu bukangurambaga bwa Gerayo Amahoro. Muri ubu bukangurambaga, polisi y'u Rwanda yigisha abakoresha umuhanda umunsi ku munsi basobanurirwa uko bakwiye kwitwara mu gihe bakoresha umuhanda.
Iyo uhinduye icyerekezo rero ugendera hehe? Iburyo. Ubwo abandi bantu bari buzana ni abashaka kukunyuraho.